Morning members, morning colleagues from the department and the NPA. Ms. Mahlangu, we were informed that you'll be sharing the presentation for the department. Can you quickly test that before we start?
Okay, good morning. Let me try to test the site.
Honorable Hendricks.
Good morning.
Good morning, Honorable Hendricks. Who will be sharing your presentation? Who will be assisting you?
I have my PA with me, but what do you want the person to do that's sharing it? Because I will be reading from my brief.
No, she can share the presentation from. Does she have a separate laptop? She can just log into the meeting. Yes, Ms. Mahlangu, we can see it. Thank you. You will share when you are called upon.
So why don't I log in there?
Is Miss Aisha with you, Mr. Hendricks?
So Hafsa's with me, and I'm on her. I am on her laptop because I thought it'd be better to use a laptop than use my iPad.
Yes, we can use the very same laptop. You can use the very same laptop you are on. You can share the presentation from the same laptop you are using, and then you can just move the slides. I have given you permission to do so.
Okay, no, thank you very much.
Can we test that? Can she assist you quickly to share? So we can test.
I'm gonna open up the presentation now, sir.
Yes. You can share because we've given you rights to share.
Okay.
So both of us can use the same link.
Yeah.
As I tell her, then she can change the slides.
Okay. You have a presentation and you've got the briefing, right? If I get you correct.
Yeah, look, I'm doing a briefing, so I will be reading from my brief, supported by the actual brief that I sent. So I don't have any other slides except my briefing, which I've sent to all honorable members via the committee.
No, it's not a problem. You can share this brief, then members will just to go with you on this brief. It's not a problem.
That's correct, yeah.
Yes, you can actually. She doesn't. You can just press the down. Aisha, you can just show the honorable member where to go in terms of just pressing the next slide, or you'll be assisting the member. I'm not sure.
I'll assist the member from my side, so I will just scroll.
Okay.
Yeah.
That will be perfect.
Okay, thank you.
Okay. Thanks. And the audio is fine. We can stop sharing for now until the member is called upon. Thank you.
Okay, thank you.
Thanks a lot. Colleagues from the NPA who will be sharing the presentation, so we can just simply do it once and for all and test your side.
Good morning. The NPA is testing now the sharing.
From which user? The one you're talking from?
From the NDPP.
Okay. May go ahead. You may go ahead and share.
Chair, the sharing has been disabled, so our colleague from the MPA is unable to share.
I'm asking if from which user are you going to be sharing from?
It's coming from Marty Alberts.
Yes. Okay, there we go. We can go ahead. No. You working? Yeah. We're good to go. Thank you.
Thank
Recording in progress.
Good morning to everybody.
Good morning, Chair.
Good morning, Chair.
Morning. How are you?
Good, thank
I'm
you.
good.
Good morning, Chair.
Thank you very much. Can we flight the agenda?
Chair, before we start, may I just say something, please?
Sorry?
Before we start, may I just say something?
Okay.
I've got another engagement this morning as well. I'll be on off the platform, so I won't be able to participate freely, and forgive me if I log off intermittently.
Okay. No, that's
Thank
fine.
you.
Thank you very much. Can we flight the agenda, Committee Secretary? Thank you very much. You are all welcome to this meeting. A special welcome to Honorable Hendricks, who will be briefing us on the divorce amendment bill, the private members bill. Are there any apologies? I have not received any apology except the standing apology of Honorable Yako, who is recuperating. Are there any other apologies? Or also the Deputy Minister, John Jeffrey.
Good morning, Chair.
Yes. Honorable John Jeffrey, Deputy Minister.
No, sorry, I was just saying good morning, Chair. Sorry for interrupting.
Thank you very much. Honorable John Jeffrey will leave us at 11. He has to also attend another meeting of the Select Committee of the NCOP. Committee Secretary, are there any further apologies?
Good morning, Chair. None from our side.
Thank you very much. The agenda was circulated, it's taken as read. Are there any objections to the adoption of the agenda? No objection. Agenda agreed to. So we will now go to item number 3, briefing by Mr. M.G. Hendricks on the Divorce Amendment Bill 32 of 2022. Over to you, Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, we are always reminded, especially as new members of Parliament, that our main job is to legislate. I know we always also have to do oversight, so it's a great honor for me to appear before this committee in pursuance of that particular role. Honorable Chair, this is a briefing to the Portfolio Committee of Justice and Correctional Services on the Divorce Amendment Bill, and I have to quote the number B32 of 2022 because, as you know, there is a competing bill with the same title. I want to start off by speaking about the harm to the dignity of Muslim wives and also children. Our common law is fraught with evidence of the difficulties and hardships imposed on women and children in Muslim marriages due to the lack of recognition of Muslim marriages. Let me share 3 cases by way of example, each of them, a Chair, very horrific. The case of Faro versus Binga showed how the current lack of judicial oversight over the divorce deprives women of their rights in respect of the deceased estate of the late spouse, where the existence of a talaq is disputed and leaves women in such instances impoverished despite their contributions to the marriage. A second case involves severe domestic violence. A woman was threatened to be burned alive by her husband,
and that he would make sure she was gang raped. She couldn't leave her husband because everything was in his name while she had worked in the business for the entire marriage. In another case, a woman was also badly beaten regularly, but because she worked in her husband's family business, she was forced to endure the regular abuse. If she had access to the same remedies for the fair distribution of the matrimonial property, she would have been able to leave the abusive marriage with her 3 children. I'm sure you understand that in all 3 cases, these women were denied access to the divorce court, whereas other women, if they were in a similar circumstance, could go and seek relief in the divorce court. All children denied the right to access the children's court because of processes associated with the divorce only escape judicial oversight. Their lives are in uncertainty. Their standards of living, health, and well-being deteriorate and only improve once the adult caregivers and parents' lives stabilize. They do not have any agency in this, no option to choose or have a say in which parent would be best positioned to care for them, which is all to their detriment. I consulted Christine Kunta, a legal advisor, on the eve of this briefing and presented those 3 cases to her for her comment. And she then sent me a note that in a dissenting judgment in the case of Daniels versus Campbell, 2004, Judge Dika Moseneke adequately summed up the origins of the unfair discrimination against Muslim women and children. This persisting invalidity of Muslim marriages is, of course, a constitutional anachronism. It belongs to our dim past. It originates from deep-rooted prejudice on matters of race, religion, and culture. Through to their worldview, judges of the past displayed remarkable ethnocentric bias and arrogance at the expense of those they perceived different. They exalted their own and demeaned and excluded everything else. These stereotypical and stunted notions of marriage and family must now succumb to the newfound and restored values of society, institutions, and diverse people. The learned judge, who was also a political prisoner, must have taken into consideration the hardships of the children of political prisoners that, for example, died in detention, and because the father was in a nikah, a Muslim marriage, they were left homeless despite him leaving behind a home. The property went to beneficiaries in terms of the Interstate Act. In the 19th century, maybe earlier, Muslims in a nikah were designated as free blacks and could buy property. Today, there are dozens. For example, the Kamis Daris estate before the court seeking redress for 4 generations, and many of them have difficulty inheriting from the state because of non-recognition of the nikah and non-recognition of the dissolution of Muslim divorces. With judicial oversight, their rights like that of children of non-Muslim marriages can be protected by a court which can at least ensure that their standards of maintenance and care do not drop to detrimental levels and stable. The court will ensure that their best interests are upheld, but this is not currently the case. The Concord judgment, which is the reason why these amendments are being made, shows that Judge Moseneke was right, although it was a dissenting judgment. So here is an example of where a dissenting judgment is vindicated 19 years later or many more years later. So, Honorable Chair, the Constitutional Court wanted this hardship to be remedied without delay. Now, without delay is actually mentioned in 2018, the Western High Court declared that the state is obliged to initiate, introduce, and enact and bring in operation diligently and without delay as required by Section 237 of the Constitution, legislation to recognize marriages solemnized with the tenets of Sharia law as valid marriages and to regulate the consequences of such recognition, which will also mean one of the consequences could be matters relating to divorce. So that's 5 years ago. In a letter sent to me on the 14th of November 2022, the Chief Legal Advisor of Parliament approved my private member's bill and advised that she has sent her opinion to the chair of the Portfolio Committee on Justice and Correctional Services to assist with a possible motion of desirability. The Secretary of Parliament was copied in this email. The bill intended to grant access to the divorce court to Muslim wives, as in the wife who needed court intervention to access her rights in her husband's deceased state, the wife threatened to be burned alive and gang raped, and the wife that was regularly badly beaten. These cases are only a tip of the iceberg of cases over more than 300 years of hardship, discrimination, and harm caused to the dignity of Muslim women. The addendum later on, Chair, shows a long history of delays, stretched over decades to implement court judgments by the Department of Justice, the President, and Parliament. Organizations like the Women's Legal Trust, the South African Human Rights Commission, and Commission for Gender Equality resorted over the years to appeal every court decision. The Concord judgment concludes that their cross appeals are dismissed. It is now a year that I'm given an opportunity to brief the Portfolio Committee. This is very unusual since the Constitutional Court gave a 2-year deadline, and one would have expected more haste. One would also have expected more haste as the 6th Parliament is leaving a legacy behind and is making a special effort to deal with gender-based violence and the removal of discrimination against women. Furthermore, one would also expect for the Portfolio Committee on Justice and Correctional Services to act with more haste, not because of a Concord order, but the will to address decades of discrimination against women. It is my view that the delay was unfair, deliberate, or an oversight. An executive bill called the Divorce Amendment Bill number 47526 has been debated by the committee, and I complained to the Speaker about this injustice and that my private member's bill was plagiarized. I was advised that this is allowed. Plagiarism is allowed in Parliament, but I feel that at least the author had to be acknowledged. The committee now has 2 bills to give effect to the Concord order, and I propose for one of the bills to be withdrawn to meet the Concord deadline of the 28th of June 2024. If we take in consideration the decades of delays, it must spur this committee to make sure that the deadline is met and that they don't apply for further extensions, which has been a pattern over decades, as I've mentioned earlier on. Months after my private member's bill, that's another bill, so I've been very busy, on the registration of Muslim marriages bill was debated in Parliament and fully supported by many political parties, including the official opposition party. A competing executive bill, the Marriages Bill 2022, dated 7 July 2023, emerged. And I withdrew my private member's bill in the spirit of cooperation when requested by the Minister of Home Affairs to do so. So I am not unreasonable. However, I intend to proceed with my private member's bill on amendment to the Divorce Act. And thank you, Mr. Chair, for giving me an opportunity to brief the Portfolio Committee. I hope that this committee will support the motion of desirability to meet the deadline of a Concord order and address the harm against Muslim wives, marriage in terms of an Islamic Sharia marriage. This after Muslims have been in South Africa for nearly 350 years and 30 years into a new constitutional dispensation. The Concord ruled that the Sharia marriage is a valid South African marriage, so Muslim wives can no longer be denied access to the divorce court to seek further redress after they've had their nikah, that's a marriage in terms of Islamic Sharia law, terminated by a Muslim personal law tribunal like the MJC or the Legislative Department of Shura or the Legislative Department of the Majlis Ul Ulama of South Africa. These are 3 of nearly 50 such tribunals in 9 provinces in South Africa. Now, the summary of there are actually only 4 amendments, Honourable Chair. So the committee will obviously focus on those 4 amendments, and I'd like to summarize the 4 amendments. And there's also one relating to application. I make the point that it's important that the law clearly spells out what a Sharia marriage is, and not to be vague about it, to assist judges when matters come before them. My amendments are as follows. Clause 1 inserts a new definition of Muslim marriage recognized by the Concord to be part of South Africa's common law. Clause 2 amends Section 6 of the Divorce Act by providing safeguarding mechanisms for minors or dependents of a Muslim marriage. Clause 3 amends Section 7 of the Divorce Act by empowering a court to grant a divorce decree on the dissolution of a Muslim marriage and to make an order with regard to the distribution of assets. Clause 4 amends Section 9 of the Divorce Act to empower a court when granting a divorce, a decree on the dissolution of Muslim marriage to give an order that matrimonial benefits of a Muslim marriage be forfeited in stipulated terms. So my summary is a Member of Parliament summary, not the summary of a legal eagle. It's in words that a common man will understand. But I thought, Honourable Chair, we have a lot of legal eagles at this briefing. So we've actually put down under 4 the actual amendments, and not by summary of the amendments, the actual amendments in the bill that we presented to you. And so I'm not going to go through the actual amendments. There is Amendment 1, there's Amendment 2, and there's Amendment 3. However, when it comes to Amendment 3, I would like to add that maybe there was for the committee to consider what I have in red, because as you know, once I get my constitutional certificate muster, I'm not allowed to change my bill, but the committee has other powers. So I'm proposing that when it comes to after subsection 3 of the following subsection 3A, a court considering any matter relating to the division of assets of a Muslim marriage into and after the 14th of December 2014, and which has been resolved in terms of Sharia law, may subject to the provisions of sections on application by one of the parties in the absence of any agreement between them regarding the division of their assets. So that is the 3rd amendment, and I hope the committee will consider what I put in red, because that is in the Concord judgment, and the parliamentary legal drafting team, they didn't suggest that that be included. But further advice is that maybe it must be included because once the amendments has been signed off by the president, there may be women that can benefit from this constitutional court judgment. Also, part of 3, when it comes there in A, the existing means and obligations of the parties, including any obligation that a husband to a Muslim marriage as contemplated in subsection 3, may have included in terms of an agreement or contract. So that was also in the Concord judgment, which was absent in my proposed amendments. But like I said earlier on, the portfolio committee may consider that that is important because it was in the Concord judgment. Chair, I want to move on to the 4th amendment. I'm not going to read it. It is there. I have summarized it. But I've added the number 5, which is application. This act applies to all subsisting Muslim marriages, including a Muslim marriage which was terminated or dissolved in accordance with the tenets of Sharia law as at the 15th of December 2014, and in respect of which legal proceedings have been instituted but not finalized at the date of coming into effect of the Act. So this was not in my original amendments, Honourable Chair, and that's why I'm highlighting it. Maybe the committee would like to consider adding it because it was in the Concord judgment and it was not in my amendments. So I would like to request that in finalizing the bill, it must contain a provision that make it clear that a divorce decree as a talaq of a Muslim marriage can only be provided by a Muslim personal law tribunal like the MJC and the others I mentioned. So that is in red, and I hope that the committee will focus on that because it's very important that even if a Muslim woman goes to the divorce court and the divorce court annuls the marriage, in terms of Islamic law and Sharia, the way I understand it as a layman, she still remains married. So you can't get away from not getting a decree from a Muslim religious authority, and you can't just run to our courts for that. I thought I will also, for the sake of completeness, put down for the committee the Concord order given on the 22nd of June 2022. I'm not going to read the Concord order, it is there, and it is a cut and paste of the Concord order, except that I would like to point out the number 2, which is to the second last paragraph of the Concord order. The conditional cross appeal by the Women's Legal Center Trust and the appeals by the South African Human Rights Commission and Commission of Gender Equality are dismissed. So these are the Section 9 organizations and NGOs that, in my view, are largely responsible for the delays in giving Muslim wives and children their rights. Although they had good intentions, the intentions was not in the best interest of the Muslim community. Although I must say that we are grateful to the Women's Legal Center Trust for their best endeavors in this regard. Honourable Chair, I then go on to give members a copy of Divorce Amendment Bill, and that is to make sure that there's no confusion between the private members' bill and other bills. I want to then go to page 3 of the private members' bill, and I want to refer to the definition of an Islamic Sharia marriage, and I would like to read the definition into the record because it's very important, as it will assist judges in future to understand what is Islamic Sharia law. And let's face it, there may be challenges to that definition, but I don't think so, because there is wide consensus that a Muslim marriage means a marriage concluded in accordance with Islamic law, that is Sharia, which regulates all public and private behavior as derived from the traditional customs, which is called al-urf, the true primary sources, namely the Quran and the Sunnah, that is the prophetic model, and that uses juristic tools such as ijma, that is consensus of Muslim jurists, and the individual jurist qiyas, that is analogical deduction to issue legal edicts. I mentioned earlier I consulted Christian Kunta just to give an objective view of this definition, and she felt maybe one should also add the tenets of Islam as it is a wider term. And the Deputy Minister have also, when he addressed you earlier, mentioned that he prefers the tenets of Islam as it is a wider term. So I have no objection to it, but I feel that the crux of the definition, as we stated there, must also be included. So I'm not going to deliberate too much further on the actual bill because it is before the committee. except to go to page 5 and refer members to point 1.6 on page 5 of Annex B. So Annex B, Honorable Chair, is a memorandum on the objects of the Divorce Amendment Bill, that is my private member's bill. And page 5, lower down the page, it gives a bit of a history on the struggle. Now, we're all aware of the struggle to overthrow apartheid. Also took many years, and similarly, the rights of Muslim wives, that particular struggle, microcosm of our main struggle, also took a lot of time. So 1.6 says that in around 1987, during the apartheid era, the South African Law Reform Commission considered whether or not Muslim marriages should be afforded legal recognition. And we heard what Judge Moseneke said about the blinkers on our judges of the past. And Muslim wives will say they must hang their heads in shame because we have been disadvantaged all over the years because of their blinkers referred to by Judge Moseneke. In 1994, the African National Congress, one of the first things President Mandela did was to establish the Muslim Personal Law Board. So the best endeavors again, but we only before this committee, nearly 30 years later, in 1999, there was a process to recognize Muslim marriages. In January 2002, there was a discussion paper. In March 2005, there was an amendment to the draft bill. And in 2010, the bill was still not enacted. And then I want to refer members to page 7 that on the 22nd of January, a Muslim marriages bill was published for public comment. So that is the first paragraph on page 7. And that invitation was challenged in the High Court because the Muslim marriages bill emerged just before Christmas when people were having festivities, and there were very little comments on the bill. So there was litigation for 5 days to get an extension of another month. It was eventually granted. And in the settlement that was reached, and here President Zuma played a very important role because I was there when he was found to try and assist in this matter. It was mentioned that the Department of Justice, they may have had a different name then, had to consult Al-Jamaa with regard to Muslim marriages and Muslim divorces. So the Department of Justice, they should have that order in their files where Al-Jamaa is mentioned as a party to be consulted. No other party was mentioned to be consulted. But as it is, we were not consulted, and that's why we had to take the initiative now to do a private member's bill, and also now an opportunity to consult with the portfolio committee with regard to this matter. I'm not going to go through the rest of the memorandum, except to refer to a question I put to Parliament in 2020 about the obstacles. And honourable members, you can't blame me if my manifesto promise was to do something about legal consequences of Muslim personal law. I had to prove to my constituency when they review my manifesto promises. I know the ANC is going around the country to review their manifesto promises. I had to show on the record that I have done something about it. So I interrogated the obstacles which prevented the government from affording legal recognition to Muslim marriages by using the same procedure that provides for the recognition of African customary marriages through the registration process at DHA. So the registration process, it cannot be that any citizen of this country that their marriage is not on the National Population Register and their divorce is not on the National Population Register. That is a sign of a failed state. A state must make sure that all its citizens have birth is registered, their ID is registered, their marriage is registered, and of course, their death is registered. The last document one gets from your country is the death certificate. And in the case of Muslims and also the Minister of Home Affairs, the death certificate of our mothers, including the minister's mother, said never married, although in their case it was a customary marriage, and in my case it was a nikah. So the legislative lacuna was made glaringly clear in the minister's reply. Why is government hesitating? And he said customary marriages are regulated by the Regulation of Customary Marriages Act, which provides for requirements for a valid customary marriage and a registration thereof. So I argued, but why can't Muslim marriages be registered on the national population? And then the minister says in his question, it was obviously prepared by his department, in this regard, there is no power vested on government to extend the provision of the Act to other types of marriages, as doing so will be acting ultra vires. Ultra vires, that's not what Judge Musaneki said. A marriage entered into in terms of Muslim rights is thus far not recognized in South Africa. This is the Minister of Home Affairs' answer in Parliament, and we know what happened after that. We now are before this committee to redress some of the imbalances of the past. Lastly, Honourable Chair, and thank you for your indulgence in allowing me to brief the committee. In the process to recognize Muslim personal law matters, and you know, we have been busy with maintenance. We have a registration of Muslim marriages bill. We now have amendments to this, to the Divorce Act. We're also in the process of having, creating a specialist court like a Sharia court, and we're already starting with the Arbitration Act to allow matters relating to marriage and status to be arbitrated. I feel, Honourable Chair, that the committee must look at Annexes C to see who we consulted. And some of the people we consulted are in this meeting today. And there were 7 advocates from the Department of Home Affairs at the strategic management meeting. And they sent a strong signal to us that when it comes to divorce matters, that must be in the Divorce Act. When it comes to marriage matters, that must be in the Marriage Act. Now, the Deputy Minister, with respect of justice, feels everything must be in the Marriage Act. So there is something that the committee needs to give leadership as far as that is concerned. If you go down the list, you will see, Honourable Chair, we consulted practically everyone in the Muslim community that needed to be consulted. Not all of them agreed with our positions, but we did engage, and that led to our 4 bills that are before Parliament. What is more important, that nearly half of Muslims are Africans. They are Zulus and Xhosas. And their leaders and their women were also consulted. We consulted with Muslim women from 8 townships, from Atteridgeville, Mamelodi, Hebron, Brits, Hammanskraal, Mapopane, Soshanguve, and Winterveld. And some of the African Muslim thought leaders, and they have all encouraged Al-Jamaa to go this particular route. I don't think that when it came to all the other acts of Parliament that relates to Muslim personal law, that such an extensive and wide consultation took place. And the Portfolio Committee members are quite welcome to ask officials to contact some of them. We will provide more details if it is necessary. We also consulted the mainstream ulama. So government always just consults the MJC as if they're the only judicial body in the country. There are 50 judicial bodies just as important as the MJC. By consulting just one of them, sometimes they consult Maulana Bams Uksa. You can't do that. You've got to consult a much more wider than that. So Al-Jamaa is very proud that in presenting this briefing to the portfolio committee, we can hold up our heads high to say that there has been public participation. And what I'm very chuffed about is the fact that we consulted the descendants of Sheikh Yusuf, where Islam was founded in Zanvlei near Makassar. We had a session with his offspring, and he was the founder of Islam. He's a national hero. He got the award of Oliver Tambo, Companions of Oliver Tambo, medal in gold for being the first to fight against colonialism. And these women are very proud that we are continuing the legacy of Sheikh Yusuf. So, Honorable Chair, that is the end of my briefing. Thank you very much.
Thank you very much, Honorable Hendricks. I will now invite questions for clarifications. We will tomorrow invite the department to respond, and then we deliberate before we start with the public hearings on Friday. I note the hand of Honorable Nivot Tuchen, Honorable Maseko Jele, in that order. Honorable Nivot Tuchen.
Thank you very much, Chair, and good morning to everyone. Thank you to the Honorable Hendricks for your presentation. Thank you very much for persisting and making sure that the rights of Muslim women and children are recognized. Thank you for that. I just have one question for clarity. On page 5, at point 3, you put a date there which says the 14th of December 2014 for marriages entered into after the 14th of December. So I just wanted clarity why you specifically put that date. What about all the marriages prior to that date of 2014? So basically all Muslim marriages should be considered. Why was that date specifically put there? Just clarity of that. Thank you, Chair.
Thank you very much, Honorable Nivot Tuchen. Honorable Maseko Jele.
Thank you, Chair. Good morning. Let me appreciate the presentation by one of our colleagues, Honorable Hendricks, for doing such work. Chairperson, I just want to ask only one clarity question, but let me just say, Chair, I think we appreciate the work, the extent he has gone in also in making his own research in addition to this. And I appreciate that tomorrow we'll also have the response from the department on this matter. But there's something when he was presenting at the beginning, when he was acknowledging that this is the second in fact, we have two bills, Chair, on this matter. One will just acknowledge that, Chair, we support everything and anything that empowers women, because that's what we want to see happening, especially as women. But only one issue, I want to hear from him. He said, Chair, there are two bills. Obviously, one must be withdrawn. I wanted to find out from him, according to him, which one must be acknowledging that the department must respond to the Concord judgment. But he said there are two bills and one must be withdrawn. And I want to find out from him which one and why? Thank you, Chair.
Thank you very much. Those are the two questions. I now invite Honorable Hendricks.
Honorable Chair, let me address the second question first. As you know, that 2 weeks after the Concord judgment, we approached the Speaker to do a private member's bill, as Al-Jamaa felt that there will be delays looking at the record of the Department of Justice and government and the President. And we felt, let us be proactive, because it is my responsibility as a Member of Parliament to honor the Concord judgment. The Concord judgment also asked Parliament to address this. So we can't sit back and wait for other people to every Member of Parliament is responsible to implement the court judgment. So we then managed to get the assistance of the parliamentary legal drafting team. I referred in my briefing that we got a letter from the legal advisor of Parliament that our bill has constitutional muster. We had Advocate Shamaine van der Merwe, who took a very particular interest and coached us along, because this was one of my first private members' bills. So the best minds in Parliament drafted my private members' bill. They obviously had other team members to assist with the work. And so I felt that my private members' bill got a certificate of constitutional muster. It was drafted by the best legal minds in Parliament. I'm not saying that the Department of Justice, that they don't have a similar caliber of legal minds, but there has been a press report that most of the advocates in that department has under 2-year service. Now, they may be very good even if they only have under 2-year service, except for one person. So I feel on the merits, the fact that the private members' bill has been drafted by Parliament, because I must be honest with you, Chair, I had no idea on how to draft the bill to comply with the Concord order. So when the parliamentary legal drafting team asked me for permission to contact the litigants in this matter, and also the Constitutional Court, I said I had no quarrel with it. All we wanted was the Concord order that we meet the deadline. So that bill is not my private member's bill. It's the bill of the parliamentary legal drafting team. They did consult me on the definition of an Islamic Sharia marriage and how to word it. And it's only 4 small amendments to comply with the order. So to answer the honourable member's question, I feel that the private member's bill must be retained, and the bill of the deputy minister must be withdrawn. And the reason is that I've already referred to the plagiarism. They took the bill drafted by Parliament, maybe changed 1 or 2 words, and presented it as if it's their bill. So when I complained to the Speaker said, but plagiarism is allowed when these matters come up. But the Speaker did acknowledge, and the Chair of Chairs, at least they should have recognized the author. Now, I'm not the real author. The real author is the parliamentary legal drafting team. And I think that that in terms of fairness and justice, and to show that members of Parliament must continue carrying out their role to legislate, that this committee must send a strong signal and give leadership that in this particular matter, seeing that the bill of the Department of Justice came maybe a year later after my bill, and as a knee-jerk reaction, that their bill must be withdrawn and that the Portfolio Committee proceed with my bill. However, I am not uncooperative. I already mentioned that I withdrew the registration of Muslim marriages bill to assist the Minister of Home Affairs. I haven't been approached by the Minister of Justice. He seems to be just sitting one side and leaving it to his deputy, but he's the minister. He must take responsibility. The buck stops there. He hasn't engaged with me, and the Speaker and Chair of Chairs indicated that they may be interested to engage with me. So while I say that the private members' bill must proceed and the other bill must be withdrawn, I am open to sit down with the Minister of Justice or his deputies to see how we can take this forward to meet the constitutional deadline of the 20th of June 2024. Because there are a lot of parties in the Muslim community and in humanitarian organizations for women that are going to oppose any application for a further extension of not only the Divorce Act, but also a Muslim Marriages Act. So we feel that there's not much time left for the 6th Parliament. We want to leave a positive legacy behind, and that is the cooperation that I would like to offer. With regard to the suggestion by the Honourable Member that all Muslim marriages in retrospect must be recognized, we fully support that. I only put that in because on the advice of legal people, that is in the Concord judgment. So it's up to the Portfolio Committee to show leadership, understanding of the hardships of Muslim wives over the years, and maybe go beyond what the Concord has suggested. Now, the Concord put the date of the 14th of September because that's when the court action started. So I hope that answers the two questions, Honourable Chair.
Thank you very much, Honourable Hendricks. Thank you for your contribution. Honourable Jelly, is that a second hand? Is that a new hand?
Yes, it's the last one. It's small, Nyana Chair. Without wasting your time. I think it's a follow-up to Honourable Hendrickson, Chair. I wanted to find out from him because of his response, Chair. And also mentioning that here we are talking about the rights, the side of he's got a right as a private as a leader of his political party to come with a private as a member of parliament, and also the right for the department. So it means we're having two rights having to clash with each other. I wanted to say to leave Honourable Hendrickson with the view or the question maybe that even if he doesn't answer now, how, because he was also saying that the department has not yet approached him to talk about this matter. So my issue is that, can't they go and sort it outside? Because now it seems as if we're going to deal with the issue of two personalities which are fighting for tariff. I'm sorry to put it like that, because to me it just comes like that. Chair, are they not going to make it difficult for the committee to take a decision? Because if we're so going to say take a decision and say we go with the department, he's going to be feeling very bad as if we took a side. If we take with the department, we take him. Here, Chair, we want to come with a bill that is going to assist us to redress the suffering of women. I feel that we cannot use this opportunity to Chair. It's like a kicking a ball with the rights that are duly supposed to be given to women. So my view is that, can't they go and meet, and when the department come tomorrow and give us their response on this matter, so that we can, as a committee, make our minds and make a decision without, and which will be accepted by both chairperson, by the committee. That will be the view of the committee, Chair. Thank you very much.
Thank you very much, Honorable Hendricks. Please be brief.
Yeah, Chair, I think that's a very good suggestion. In fact, the Chair of the Portfolio Committee of Home Affairs made the same suggestion in the presence of the Minister of Home Affairs. And the next day, we met and we resolved the matter. So I don't see why we can't do the same, but I mean, it's not for me to ask to be invited to engage. Thank you.
Thank you very much. I hope the Deputy Minister is still in the platform. Are you still there, Deputy Minister?
I'm still here, yeah.
Okay. Okay, I hope before we deliberate tomorrow, you would have engaged with Honorable Hendricks.
Yes, Chair.
Thank you very much. Thank you very much, Honorable Hendricks. Can we stand over this matter until tomorrow? We will now invite the Director General of the Department of Justice and Constitutional Development to lead us on the annual report. Can we allow them 2 minutes to change slides from Honorable Hendricks to that of the department so that they can upload their slides? Or let's meet at 10:25.
In order, Chair.
Ms. Mahlangu, you may proceed. Good morning once again, Ms. Mahlangu. Oh, colleagues from the department.
Morning. I'm trying to share. Is it visible on your side?
No.
Not
And
yet.
the team, the DG and the team, are they in the auditorium or are they using their laptops just so we can quickly test their audio?
No, we are not in the auditorium.
Oh, okay. Can maybe the DG quickly test his audio while you are projecting, Ms. Mahlangu?
Yes, can you hear me?
You are quite clear. You're quite clear, leadership.
Okay, good morning. Thank you very much.
Okay, and the other team members, maybe just to test, to give this time, so that if anyone has a problem, they can change gadgets while the DG is presenting.
Yeah, let me ask Tabi,
CFO,
CFO, and also Mr. Munyai.
Yes, Ms.
Good
Mahlangu, we
morning.
can see the slides.
Good morning, CFO. Am I audible?
Yeah, no, you are clear. And the rest of the team.
Good morning, Tabiso Titi. Am I audible?
Very clear.
Ms. Mahlangu, can you go to the slide mode?
Good morning, Mr. Munyai. Am I audible?
You are clear. Can you move the slide, Ms. Mahlangu, to the next slide and put it on slideshow? Maybe.
Slideshow.
Yeah. While the other team members are testing their audio.
Good morning, I'm Penny Lopez. Am I audible?
We're clear. I think we're good to go. Next slide, Ms. Mahlangu. Can you just move it down? Just. You know, technology can surprise
Yeah,
you.
it's fine. This one, go back to the previous one. Yeah, we can start on this one.
Okay. I think we're good to go. Thank you. Thank you.
I asked Mr. Munyai as well to test.
Yes, I've already tested DG. Am I audible, colleagues? Is Mr. Nicholas Gongoromia?
Okay, we can hear you. Thanks, Mama.
Thank you very much. Can we proceed? Welcome, Deputy Minister, DG, and the entire Justice team. We have gone through your slides. We have received an overview from the Minister and also a presentation from the Auditor General. I would request that you should not exceed 60 minutes with your presentation, because we still have to deal with the NPA's presentation. Over to you, DJ.
Thank you very much, Honorable Chair, and good morning, honorable members. So we will try our best not to overshoot the 1 hour chair that you have graciously given to us, and we've taken into account the point that you have mentioned. So I will, what we'll do, I'll just give some high level, reflection on some of the issues and the journey that we've traversed thus far. And I'll ask Mr. Tabiso, who's our DDG for Institutional Development, will reflect on the specific areas, and it will be followed by Mr. Munyai, who is heading the integrated justice system. And so it's a critical part. So Tabiso will just jump that part so that Mr. Munyai can just broadly reflect on the strides and the milestones that are being achieved there. And the CFO then will come and deal with the audit and the financial matters. Chair, maybe let me just start and say, you recall that in 2021, we presented in April to this committee what we proposed as a turnaround plan in terms of trying to address the challenges that the department had faced in the previous year, which was 2019, 2020. And at the time, the reports of the Auditor General, if you go back to those reports from 2018 to 2020, those 3 reports put together had given a gloomy picture of the state of the department. And so that turnaround was mainly, of course, informed by the concerns of the honorable members that the department was on an unabated downward spiral, and it needed to be arrested. And we had identified 8 key areas that we thought at a time, if we were to address them, we will bring back and stabilize the department. Of course, those specific areas that the Auditor General had identified, you will argue were categorized into 3 different areas, which is strategic, operational, as well as financial. So our turnaround plan had to address those areas. First among it was the stabilization of the leadership. I think the rate of vacancies at the management level was very high, and that affected the execution of plans and the implementation of the strategic plan of the department, as well as the annual performance plan. And that also had a direct bearing on the financial management of the department. And that meant that the department had hollowed out its skills and human capital in general. So the focus and the drive then had been to address that part of the strategic capability. And I must say that, Chair and the honorable members, we made significant progress, albeit we still have some vacancies. And now with austerity measures, I think we'll no longer call those vacancies vacant because they will no longer be funded. However, I should say that at the senior management level, at the executive management level, we hope that Cabinet next week will confirm the filling of 2 vacancies of DDGs. Critical of one of those is the DDG for court administration, which constitute more than 60% of the operations of the department. The chief master, that post, as you know, was filled, and the chief master moved on to greener pastures. The post was advertised. Unfortunately, we could not attract the relevant skills, and then we'll be back to the market as well to make sure that before the end of the calendar year, there's a chief master appointed permanently. You will have seen the post of the Solicitor General has been advertised, and I think it will be closing in a week's time. So at that level, I think more or less above 90%, the vacancies, 95% at that level would have been dealt with. And below that, of course, major work was done as well to make sure that skills at directors and chief directors level are brought in. So there's been a high, there's been a significant recruitment and promotion of officials from the department to take up the strategic management responsibility of the department. So in relation to operations general, I think we have been working on trying to, in terms of our service delivery improvement plan, improve our processes, which for far too long have never been looked at and reviewed. We have conducted a business process review with the help of a service provider, and a report has been submitted and will be shared, which looks at all our service delivery areas and the processes that are running there. And what we find is that we still have archaic, processes that are not necessarily helping in terms of effective service delivery to the people of this country. But we have a clear plan that we will then work on to implement the recommendations of what an independent service provider will have found. The biggest challenge, of course, is that when you re-engineer processes for operational enhancement and efficiencies, you have to do that nowadays, taking into account technological requirements and what technology can do, or artificial intelligence can do as well to improve, those processes and make sure that services are delivered in a smart and much quicker and effective manner. So that's one area as well that we'll be looking at. Now, second to what I'm raising relates to the modernization of the department, which the departmental strategic plan 2019 to 2024 reflect prominently the need for the digital transformation of the department and the modernization of its processes. I must say, Chair, this is one area as well of highlight, in the sense that we had told the committee previously that for years the department had focused on running its ICT from a project management point of view. So there was no insourcing, everything was outsourced. ICT of the department was run by service providers with few officials appointed on contractual basis, even without necessarily having the necessary required IT or ICT skills. But their job was mainly to manage, service providers who would have been brought in through the tendering system. We took a decision to turn around that and in the review or reorganization of the department, develop a permanent branch with a chief information officer at the deputy director general level, and brought senior managers. We wish we had many resources to build capacity, but we have in-source. At least our take is that 80% of the work around ICT must be done by departmental officials than what was the reverse situation. Service providers will always come in and assist, but in the main, at least it should be driven. And we have started seeing the spin-offs of having highly trained and qualified ICT officials taking the responsibility for driving our digital transformation and modernization of the department. Yesterday, the minister and the deputy minister launched the Masters Deceased Estates Administration online services that will make sure that members of the public can transact on those matters online. And that will, as honorable members had raised yesterday with the minister, will address the challenges of queues that we see in Johannesburg, particularly Cape Town, Durban, and Pretoria, as well as areas like Thohoyandou. So those who have access to gadgets and computers online, they can be assisted. But even in the service delivery points and the master's offices, there will be kiosks that will make sure that they can be assisted. And this is an initiative that brings the public, the private sector, the banks, the legal profession, the chartered accountants professions, and so on and so forth, who basically that entire industry that interacts with the department in this area of work. Part of what we seek to do as well in that area is to have an integration, with the Department of Home Affairs, the banks, master's offices, so that there's seamless services and improve how we, service the members of the public. Because that's a critical area. You're dealing with bereaved families, and to subject them to, having to wait in queues and being a cumbersome process is what this will assist. And as the minister has announced already, that we hope that before the end of November, we will launch the child maintenance online as well as one area of service delivery that the department is responsible for. We just regret that the processes around modernization, we hope that if we're autonomous, so we're not autonomous because of the State Information Technology Act, the SITA Act, which requires that we have to be subjected to the SITA processes, particularly in the area of procurement. So this is a main area of concern. We have reflected, we have reported this in the past previous financial years to the portfolio committee. So it's a matter that is well known to us. So when we're not moving at the speed we are supposed to on the modernization of the department, it's not for a lack of willingness or desire on our part. Linked to that, as I'll just inform you, the court recording technology, as you know, 2 years ago, nearly brought the wheels of justice down until Treasury assisted us with that intervention. To date, we have not yet awarded a permanent, service provider will provide on 3 yearly basis. But we have done everything on our part. It's currently lying with SITA, and we have been following up. I've met with the managing director of SITA on several occasions, and I've even met the chairperson of the SITA board that was dissolved 3 months ago, even the new one. And I've impressed on the need to have this matter attended to. We are told now by the end of November it will be finalized. I'm raising it as just an example of a dependency and a constraint, particularly. It's not only for the Department of Justice and Constitutional Development, but it's a general complaint across the state about the processes of SITA. So I thought we needed just to reflect that. And thirdly, in the area of the financial management, I think part of our turnaround plan included an audit plan that needed to improve the management of the resources of the department, particularly the financial one. And it has been our commitment that we needed to get the department out of qualification as a start, and with our commitment that in the following year, meaning the year that we currently are in, the department should have a clean audit. And I think that we are on the right trajectory. The CFO will explain, as you will see, and the Auditor General will have reflected that to you. Our regular expenditure that had reached about 2.9 billion in the register has significantly, been reduced to less than 1 billion. And those matters, the 872 million, are being attended to. The next time we come back here, God willing, we should be able to show you that we have cleared the register. And a clear example of the fact that we will clear this register is that in the year preceding this one, our irregular expenditure was at 61 million. But this year, under review, the one we are reporting on, the irregular expenditure is only 6 million. And even that 6 million relates mainly to, the briefing of council, the state attorney process, because we don't have a framework. And even that framework, it's not that we haven't done anything. We're sitting with treasure, as we reported in the previous financial year. So it's for that reason that I think we reflect these matters that we were on the right trajectory, and we're seeing a serious, significant movement in the right direction. Contract management was a major challenge in the department, as portfolio committee will know, and it even led to the situation where CRT were no service provider. We have since dealt with that. We don't have, challenges of contract management. The challenge remains that even in our better planning, the SITA processes are cumbersome, are slow, are not responsive. So that's just the one area that we'll continue to look at. And then maybe in closure, in relation to the turnaround plan, our take in looking at the work that we've done, we never had a timeline as to when we're going to ditch the turnaround plan, but taking into account that we are 5 years to 2030, which is the end of the National Development Plan, the target date for the National Development Plan, and that the 7th administration is looming, 2024 to 2029. We are working and looking at a 10-year plan that we call Justice Vision 2035, that at the least we start building a foundation based on this turnaround plan, convert it into a foundation for a long term, so that in 10 years, even if we're not here, those who will come after us can continue on that foundation and project. We cannot with absolute certainty project how 2035 will look like, but at the core of it, we are mindful of the fact that artificial intelligence and technological development and advancement is here with us, and every department worth its salt will have to factor how the digital transformation and modernization of its services to improve service delivery to the citizens of this country will look like. So that will be what we'll be focusing on in terms of the 5 strategic areas that will be the building blocks for Justice Vision 2035, which will be mainly the digital transformation and modernization of the department and the entire justice sector. And secondly, building a human, capability, or the human capital management part, to build a cadreship of justice officials who will be committed to the sense of justice, constitutional values and principles, and service delivery to the people of this country. And of course, the promotion of constitutional, democratic, and human rights values. I think that will be very important. That will be underpinned by rule of law, and that's the significant role that the department has to play in our nation building. But fourthly, as well, the interaction with the members of the community. And we have worked as a department on a framework for stakeholder engagement that makes sure that the department is taken down to the ordinary man on the street, that the future of our democracy can only be bright if an ordinary South African on the ground in rural, peri-urban, and urban areas has an appreciation of the nature of our constitutional democratic project and the vision that is encapsulated in our constitution. That's where we can say we can look forward to a future that is based on respect for human rights and rule of law. And finally, of course, the concept, the broad concept of access to justice. So relooking at all the laws that create a fundamental and a critical, pedestal for people of this country to have an access to justice. So there's a number of bills that we will be looking at, and hope that the 7th administration in the early years could be looking at, because of the number of acts and laws that we still have that are old, that will require the adjustment, including a Criminal Procedure Act and the Deceased Estates Act, that will try to bring them in line, taking into account all the amendments that will have been done over time. In terms of challenges, before I step off, Chair, I've already mentioned ICT still remains the same challenges that we have presented to you, but we are working and we do everything possible. Next week, the whole team of ICT, I will be meeting with CETA together with them to just impress more as well, but to have them assist us on what we can do to leverage, some of the opportunities that are available for us to improve, our ICT environment. Secondly, the infrastructure. Potchefstroom was raised yesterday. We have done everything, including leading on the proposal to ask DPWI to increase our day-to-day, maintenance to 1 million. That has been done, but still remains in terms of the Giyama Act. The core responsibility and competency remains with Public Works. We're grateful that, Chair, you and the honorable members have brought us together with DPWI, but DPWI still has a lot of things that they need to assist us with, particularly even in terms of the skills around engineering and so on and so forth, and just the processes as well. You will have seen in social media the past 2 days the challenges at the Pretoria Magistrate Court. We all know that court was burnt down in 2010. We only managed now, after significant follow-ups and engagement, to have a service provider back in place to start the renovation of that building. That remains a major challenge because we are an infrastructure intensive. The 780 or so courts across the country require attention, and this is an area that we continue to engage with DPW. Finally, the austerity measures that all of us know about, they are here on us. Overall, in the vote, we are looking at just under 1 billion or just over 1 billion. Partly one, due to the COLA increase that was affected, the cost of living allowance that was affected in April, which Treasury had not budgeted, and had come back to all departments and say, pay this increase from your baseline. So that means that for the department and the NPA combined together, just that baseline will mean about 700 million. And the total of preliminary indication of how much they're going to cut the budget by is around the region of below 300 million. So all of that put together will mean that about 1 billion or just under 1 billion of how we will be affected. Now, in terms of the programs that will be affected, clearly, the ICT or the modernization of the department will be a major, casualty, including the integrated justice system itself. It will be the major casualties of this budget cut, but the infrastructure as well. So the renovation, it may be that what we had ambitiously thought we will be able to achieve will be slowed down significantly, and things don't. In the meantime, in terms of the medium-term expenditure framework, which is the next 3 years, things are not necessarily looking that better. We can only hope that at some point the economy will be turned around in order to at least move back and attend to this, because then we may start seeing more and more of dilapidated buildings. Currently, the situation is not necessarily looking good itself, but with the budget cuts, that's what's going to happen. And of course, the hiring of employees in significant areas like child maintenance areas, where we require a good number of maintenance investigators, because the current system that was put there 10, 15 years ago was a pilot, and we don't have enough investigators to deal with the issues of child maintenance. I think that will be affected. So on the ground, even where we thought maybe we'll invest in technology in order to free the human warm bodies, that in itself as well is going to be affected. So it's going to be a very tumultuous and difficult times, but we hope that we'll develop strategies. We will have, of course, to meet and look at what we had presented as the annual plan in April, and in the backdrop of what probably the Minister of Finance will announce during the MTBPS, that we'll have to adjust for the next 6 months, because I think some of the targets will no longer be realistic in the light of budget cuts, the limitations. There are travels that have to be done out of necessity, and some of those will be affected. So I thought briefly I should highlight that when the colleagues go to the other areas, we'll have taken, and maybe finally just Chair to say, we present this report, and Chair, I heard your concern about what the Auditor General in the engagement with us and in the management letter, the point that they do make is that we had engagements with them, and we had even invited that, you see, in this journey of trying to turn around the department, we need your support. And indeed, they've been very supportive. By nature, auditing it's a rigorous process, but it's a tough engagement between the auditee and the auditor, and we have accepted that, and they themselves have accepted that, and we have built a relationship of robust engagement, but with respect, and I think we can see the results, all of us. So in relation to some areas where they have challenges, and say it has been the case, but they've noted that. It's not the same as 2 or 3 years ago when they previously could not say the evidence that was given. In this time, it's about a debate of whether this is the evidence or not, but mainly in those areas of masters and the state attorneys. And because that's what, they cannot audit everything, every target of the 90-something targets that the departments have. They don't have that capability, but they know themselves as well that even in terms of the rules, you can't generalize that. Even if you extrapolate, if they came to that conclusion, they could have then given a disclaimer on performance information management. But they do say, we do see challenges here and there, but we do see that management has done a significant work to improve this. And the next time we'll come back here, Chair, God willing, we should be able to say to you, we have moved even the performance information qualification out because of the work that we continue to do. And we're addressing that issue, Chair, you raised through an audit turnaround plan. We have immediately after the report of the Auditor General, we have started developing an audit turnaround plan, because our desire is that when we come back, we must make history and say the Department of Justice has obtained a clean audit, and we think that's doable and that's achievable. I'll ask my colleague Thabiso to take us through, then Mr. Mnyai will come in and deal with the IJS before the CFO. Thabiso.
Thanks, DG. Good morning, Chair, Deputy Minister, and members of the Portfolio Committee. I'm going to start with the performance overview over the past 4 financial years, where we have seen a significant increase from 51% to 86%, with an overall 35% increase from the year 2019-22 to the year 2022-2023. Tabsile, can you go to the next one, please? We have seen a great increase on the analysis of all the 5 programs, where we have seen drastic increase from Program 1 of 58%, Program 2, 60%, Program 3, 33%, Program 4, 18%, and Program 5, 33%. Both Program 3 and 5 grew by 33%, while Program 1 slowed a bit, we showed a steady growth of 18%. Can you go to the next slide, Tabsi? And when we look in terms of the overall percentage, we are sitting at 86%, as I've indicated before, where we had set the total targets of 93, and we have achieved 80, and we have not achieved 13 in the past financial year of 2022-2023. Next one, Tabsile. As I've indicated in the overall percentage, the we have managed to move from 51 to 86% with that upward trajectory since the second financial year from 2021. We had set our targets that we should not be anything less than 80%. And we have developed implementation of, we have developed and implemented a robust intervention plans that has seen significant improvement in terms of performance. And despite all the challenges that we are facing as a department, we continue to look in terms of improving the measures of service delivery. And what we have also seen is a great improvement in terms of our audit performance, where since I think 2016, 2017, where we have been qualified, but in this current financial year that we are looking at 2022, 23, we've managed to achieve an unqualified audit opinion. Next one, in terms of program 3, where we have seen a greater improvement, there are certain indicators that could not be verified, but we are looking at improving on them through our audit intervention plan to make sure that we don't find ourselves with the repeat findings on some of them. But of importance, Chair, is that we have worked tirelessly to improve our process to prevent irregular expenditure. And the department has registered a 91% reduction in frivolous expenditure and wasteful expenditure, while the value of irregular expenditure was improved by 70% for the 2022-2023, and 80% fruitless and wasteful expenditure was reduced by 43%. And 80% fruitless and wasteful expenditure reduction and 43 irregular expenditure increase.
You have 30 minutes left for the whole presentation.
Okay, thanks, Chair. Tabisile, can you go to the next slide, please, where we give an overall branch performance when we move with speed. As I've indicated, from the past financial year, Program 1 had managed to get 76%, Program 2, 100%, Program 3, 93%, Program 4, 75%, and Program 5 managed to achieve all their targets. We can skip this one because I've already touched on it, Tabisile. In terms of administration, we can go to the next slide. We have managed to address reduced 91% of irregular expenditure. As I've indicated, we've also managed to 54% of women held senior management positions, while the youth made up 23% of the total workforce. We have managed to hold a successful conference by the 31st of March, which dealt with the celebration of the 25th year of the Constitution coming into effect. And we have managed to re-engineer our process in terms of dealing with modernization and digitization of the department in increasing access to justice. Let's see the next one. In terms of court services, next one, Tabisile. Next one, Tabisile. In terms of court services, we have managed to upgrade 83 courts into Section 55A of Sexual Offences Court. We've managed to finalize 97% of non-litigation matters within 6 months. We've managed to finalize 94 of family advocate litigation matters within 12 months. 65 courts were refurbished and upgraded through minor capital works, and 88% cases were finalized. Maintenance cases were finalized within 90 days from the date of proper service of processes, where all documents are submitted. Can you go to the next one, Tabisile? Next one. In terms of Program 3, the department has ensured that the self-service computers are in place and further rolled out in master's own verification technology. We have 93% of legal opinions were finalized within 30 days. 88% of suggested bills and subordinate legislation was finalized within 30 days, and the department finalized 96 of international agreements within the 30 days. Next one. In terms of NPA chair, I will skip it because they will go on an elaborate presentation of their work. So I will leave this part, then they will come and give their own presentation after we have finalized with ours. Tabsile, can you go to the next one? In terms of auxiliary services, I will, can you go to the next slide, Tabsile? I will hand over to Mr. Munyai to talk over these issues of integrated justice system. Mr. Munyai.
No, thanks, Titi, Honorable Chair of the August House and members of the Portfolio Committee, the Deputy Minister and the DG of the Department of Justice. And I think let me start by looking at the issue relating to the governance of the IJS. And I think members would agree that there has been a lot of problem in relation to governance because there was lack of control on the work of the program as it pertains to what other member departments are doing. And I must say that in improving that governance, our governance framework was approved in 2021, and the three-tier governance structure was then established. The first one being the lower one, which is the IJS Implementation Committee, which I chair with all the GTOs and the senior business representative of all IJS member departments, including CETA and National Treasury. And the second tier structure was the IJS Board of DG, which is all the accounting officers of all 8 IJS member departments, which is convened quarterly and is chaired by the DG of Department of Justice and Correctional Development. And the third one, which is already set, which is the IJS Ministerial Committee, which is chaired by the Minister of Justice and Correctional Services, with the Minister of Police, Minister of Home Affairs, and Social Development being part of that. And one would then immediately speak about some of the benefits that we've realized out of the creation of this governance framework. One, there's been political oversight and strategic direction, looking at where we are. We've been able to manage the interdepartmental program performance and strategic risk oversight across the member departments. We've been successfully monitoring the IJS program implementation across all member departments. And there's been improved project planning and budgeting process. And we have been able to manage the technical standard for the entire criminal justice system. And of course, I know that this is work in progress. We have been engaging the Auditor General on some of the work, and they've been referring to the IJS project delivery framework, which we have defined as a basis for the audit of the project management processes that we follow in the IJS. Quickly, in the transversal hub, you would know that at the core of the IJS, there's what we call IJS transversal hub. Suffice to say now, the target, the MTSF target of 11 departments being connected to the IJS hub and able to electronically exchange information. And this information exchange are implemented by means of signed interface control definitions. We now have 11 departments that are connected. The latest one was CIRA. I reported last time that CIRA has a lot of challenge in relation to the verification of personnel that are appointed by private security companies. So therefore, they've requested to connect to the hub so that they are able to do the seamless and immediate verification of all security personnel of all these private security companies. Therefore, that's why they came to IJS, so that they can use our PVS, PIVA, and AFIS services for that purposes. Suffice to say that we have also been receiving numerous requests. One is from the DI and IPID on the possible connection to the hub for the purposes of consuming IJS person integration services, what we call PIVA, PVS, PEEP, or what we call 10-piece. And currently, as per the requirement of the FAFT, after we're grey-listed, the FIC also approached us so that they could also have access to what we call SAPS CREAM database through the IJS hub. That is at a high level. But on immediately, if we quickly go to at a high level on the IJS cluster priorities, because I'm speaking to those priorities on program 5 a little bit broaden what is on the presentation. In our 5 key cluster integration priorities, you would know that we always present it in the form of 3 work packages. The first one being what we call criminal justice person integration, where you would recall that we spoke about what we call CJS single person identifier, which has now been created and continues to be created whenever a person visits the criminal justice system in the form of SABS. The second one is the issue in relation to what we call person identification and verification application PIVA, which we use as a criminal record first search to assist us to verify the person and also look at the criminal records. Then our second work package under these priorities is the case integration. We have spoken about a number of case management systems across all member departments, which in our new enterprise architecture plan, we want to consolidate and start having a seamless case management system, one case management system for the entire criminal justice. Currently, they are all integrated through the hub. It's ICDMS of SAPS, it's electronic case management system of NPA, it's ICMS of justice, it's ELA of legal aid, it's court online, of course, with some of the challenges of OCJ. And then you would recall that I reported to Parliament in the previous year of the delay in what is called integrated person management, which is at the cornerstone of the criminal justice system. For us to be able to track the person from the time when the person is arrested throughout the value chain up until the person is rehabilitated back to society. So we needed this project, has been with CETA for many years. We only started in 2019 to be precise. I'm happy to report that for the first time, this project is even ahead schedule. It has 7 releases. We've already piloted it to 10 big police stations across the country. We are now working on the national rollout to go to other 1,057 police stations across the country. In those releases, the first one is a person booked and verified. That's when the person is booked, capturing of a person and linking a booked person to a case docket and capturing of biometric for identification purposes. The second one is unique person identifier I've spoken about. That is the assigning of the unique person identifier to a person. Outside the ID, we are adding the new metadata for verification of a person, which is called unique person identifier, which will be allocated to persons whenever they enter our criminal justice system. The third one is what we call tracked person. That is the establishment of electronic capturing of finger and palm print capability and the basic booking in and out of the holding facility and the development of a person's verification service based on the fingerprint. The PIVA is part of what we call release 2 of the verified identity person. So release 4 is person booked into holding facilities. That is when the person is charged and take fingerprint and the produce of sub 76. And then release 5 to release 7 include, it's one big module which is then cut into 3. It's safeguard and manage a person. The first one is more about managing visitors, managing meals, managing property. the release of the suspect, release to court, release on bail, release from court, correctional facility, release to other places. The second one, which is also safeguard and manage a person, is more on cell visit, escapes and death. And the last one on safeguard and manage a person is more about hospitalization, child in conflict with the law, mentally ill care, restraining and strike. So that is on the IPM. Quickly, because on the person integration, you would have, the DG spoke about integration with Home Affairs. That's why Home Affairs is part of the 8 IGS member department, because it is the source of persons' records. So Home Affairs has been using HANIS, the Home Affairs National Identity System, which is a legacy system. We are pleased to announce that from the 9th of September, on the 9th of September, Home Affairs switched to ABIS, which is the new database, automated biometric information system. And the phase 1 of ABIS modalities, we spoke about the unique person identifier, which is the number that we'll not see is in the background, which will assist us also when we deal with undocumented foreign national, because we'll also have a facial recognition. If you are arrested in Joburg, you give us false identification, you're undocumented foreign national. When you go to another province, with the use of facial recognition and unique person identifier, we will then be able to identify you for who you are, and the fingerprint search and the latent search. So we're currently working on phase 2. We're phasing in all IGS member departments to this phase 1 modalities, unique person identifier, facial recognition, fingerprint search, and latent search. We're working with Home Affairs to finalize phase 2 modalities, which include the iris, the infant footprint, and palm print. Again, in broadening the scope of the person's verification, we did indicate here that SASSA, in order to fight fraud, they needed to use IJS to enable the integration of SASSA to DHA and making a real-time person verification services. And these services they are now using across the spectrum, across all 400 sites of SASSA to verify the identity of the beneficiaries of social grants. And it came in handy also during COVID to verify the identity of those for the unemployment grants. Again, on the case integration, quickly as I'm going towards conclusion, we have already spoken
yes, Mr.
about.
Mia, if you can wrap up in 3 minutes, we still have
I'm
some.
wrapping up on case management. ELA is now deployed across all legal aid sites. The legal aid application is no longer done manual across all the sites. There are still few modules to be deployed. We have also finalized, in response to also the FAFT issues, we have finalized the development of mutual legal assistance and extradition system, which will assist us to manage and track and monitor all the mutual legal assistance and extradition cases, including the management of those records. Then the court online, of course, the issues with the legal issues on the side, but we are continuing with the rollout of the case line while we're dealing with the issue of stabilization, which is between CETA and Microsoft on the first part of Microsoft Dynamics. Then on the case line, we'll be rolling out to Supreme Court of Appeal in this quarter and also the Constitutional Court. And then, and also recently, the electronic monitoring or the inmate tracking, the bracelets. We have been working with DCS and CSIR. They've developed the technology, and we are currently piloting the bracelets for management and tracking of mainly, we're starting with the parolees. So quickly on some of the key integrations that we have that are now in production, the means test, which is the message from a participating departments to IGS interoperability hub, which contains requests for legal aid by any accused person, meaning either you are in SABS, you are in DOJ, you are then able to request for legal aid assistance and means test is able to be conducted immediately. The DG docket POC between SAPS and NPA, which enables NPA prosecutors to better collaborate with SAPS investigating officers through sharing docket information prior to the trial. Docket may electronically be shared by the IO investigating officer with the assigned NPA prosecutors. The NPA development is complete. The system demo has been conducted, and the site readiness assessment has been concluded. And I think we've spoken about the IJS person integration services.
No, I think
Yes.
that will suffice, I think, for just the high level highlight. I'm worried about the time. If Tabiso can just take the remaining slides.
Okay. Thanks, DG and members of the portfolio. Suffice to say that the challenges the DG has raised of CETA are across all 8 IJS member departments. Thanks.
Tabiso, can you finish the remaining slides before the CFO? Mr. Titi, can you hear us?
EJ, maybe you should finish the slides because the time.
Okay. Tabile, can you slide? Can we move from this slide? CFO, please deal with. We were really now left with about 10 minutes. You can go through the financial.
Good morning, Chair. Good morning, honorable members and colleagues. The financial information is as presented in the annual report. I will just show the appropriation statement in terms of the expenditure and the response on the Auditor General. The next slide just indicates that as a department, we have spent our budget and we have improved from the previous year. We have spent 99% of our budget. Chair, you will remember that last year we had almost 630 million that was unspent. And this year we managed to improve that expenditure. And the expenditure that we had, almost we were at around 1.1 billion that was available for EMEs and QSEs. And out of that 1.1 billion, 780 million of it has been spent on EMEs and QSEs, showing that we have been supporting small businesses as well. And 780 million of it relates to payments that went to women. So, Chair, the 222 million that the 226 million that is not spent, you will see from this slide that 101 of it, which is 50% of the amount, is for magistrate. Just go back to the next one. Yeah, it's for the magistrate because that 101 million is earmarked. We can't make any changes of it. And that is followed by state legal services, which had some vacant posts that were not filled. So in terms of improvement, when a post is not filled, you cannot change it at the end of the financial year. If you go to the other slide, Tavisile, you were just showing the full expenditure per program on how the funds appropriated to us has been spent. The next one shows it per economic classification. So all these figures, they has been audited by the Auditor General. If you go to the next slide, we focused in this report on the vote, which is the money that is appropriated by Parliament. So even on our audit report, we have focused on the vote. But because the AG yesterday also spoke about the funds, I think it's appropriate for me then to just reflect on the funds, on what the Auditor General has said. The report for the funds have all been tabled. It has all been submitted to Parliament. It's a separate report from the annual report of the department. You will notice on the report of the Guardian Fund that as a department, we had reported a subsequent fraud event that has happened around April this year. And we had then indicated that we are in the process of investigation. And that fraud case that has happened, the amount that was stolen out of our funds was around 17 million. And already 8.9 million was preserved, and we are working with the law enforcement agencies to get that money back. The case that was reported of the 7 million was also a separate case that happened in 2021, where 7 million was paid out of the Guardian Fund. That one was not specifically a fraud case, but it was a duplicate payment made to the same beneficiaries paid twice. And we managed to recover 3.6 million of it, and the rest are still going through the disciplinary process, and we are working with the law enforcement agencies. So if you look at the report that the Auditor General has issued on the matter of the duplicate payments, they had issued us with an MI for it, but they had indicated that they are still investigating. So we didn't expect them to be presenting it here before you. It's still, but then on the 17 million that we had already presented, they also later considered that it falls into their definition of a material irregularity, and they issued us with a material irregularity. Also, that one is still in the process of investigation. Officials whose profile we used are currently being charged, and they will be going through a disciplinary process. Investigation is still ongoing, and the law enforcement agency is still looking at it. In relation to the internal controls, we have improved our internal controls significantly for both the department and the funds. And some of the things that we have implemented is to try and use systems that will help us trace payments when they are made. And that project is ongoing, and we were hoping that by August this year we'll be rolling it out. But by the end of the financial year, we are confident that that system will be in place. But cases of fraud, you cannot have bulletproof. Cyber attacks are prevalent at this age. We can only continuously have monitoring controls and preventative controls to try and avoid this kind of situation. And where staff is involved, we have to continuously make sure that there are consequence management. So I just thought I must reflect on that to give context of the funds and the Guardian funds. Issue of how performance information of the Guardian funds is measured. Currently, they fall under the masters, and the masters indicators has some indicators relating to the Guardian Fund. We will relook in the new year, in the new MTSF, and see if we can maybe put more performance information so that Parliament can have an oversight on the Guardian Funds and the Justice Administrative Fund. Coming back to the vote, we have received an unqualified audit opinion, and we are very proud of it, because the last time the department got an unqualified audit opinion was 6 years ago. So we managed to get that qualification out of the way. On the report, you will notice that there's still impairments of receivable that we have impaired, money that we are not able to collect from our other departments. And this comes, some of them comes from a long time ago. So we are working with FOSAT, with National Treasury, to try and recover these amounts where we have rendered services on behalf of government. And to correct the AG, I did raise it with them yesterday. It is not true that the department is in a deficit. The legal cost of other department doesn't come into our income statement. It is recorded as a receivable. So if it was a deficit, it was going to be an unauthorized expenditure, and it will need Parliament to condone. But because of this payment, National Auditor General raised a concern that our revenue management collection methodology is not effective. However, it is a policy matter that we have to look at it broadly, because if there's a judgment or representation that needs to be made, we cannot just sit back and say Department X is owing us and therefore we are not briefing council. Sometimes it can be not a good decision for government as a whole. So sometimes we find ourselves in those situations where we brief even if the collectability of the funds is remote. We did restate the corresponding figures to allow the qualification to be cleared in the current year. So in terms of the audit methodology, these are technical issues that has to be presented. So in the next slide, you will see that the AG indicated that the irregular expenditure framework has changed. They've emphasized it a lot, but as far as I'm aware, National Treasury, when they issued new frameworks, they do consult with the AG, and also they show the AG how they must audit the information. So here, regardless of whether the framework has changed or not, the truth is that the department has improved in terms of handling its irregular expenditure. Last year we had 61.5 million, and then this year we only have 6.8 million. And most of these transactions are state legal services. And we are working with National Treasury to find a framework for sourcing state legal services for the state. And we know that this tender, if I were to say, for the database has been advertised now. And we are hoping that in the new financial year, we'll have a new framework. But internally, we are also strengthening our processes.
CFO?
Yes, Chairperson.
How much time, in fact, how far are you now?
2 minutes.
Yes, we will give you 2 minutes. The DG will not have an opportunity to close. Please round up.
Okay. Then, yeah, so I was just showing that on irregular expenditure, we close with 2.9. The next slide is to show the internal control deficiencies that has been identified by the DG. The next slide, that has been identified by the AG, and we have dealt with those. And performance information that is still a challenge. We are working with the Performance Information Division to address those. And mainly here, the issue is the method in which we use to collect information, because it's a manual process. We don't have system in place. Part of the modernization strategy is to make sure that we've got systems that will help us collect information, even for performance reporting purposes. So we have done an audit action plan. We are looking at cases where there are weaknesses and try to make sure that our internal control improves on a continuous basis. Thank you, Chair.
Very much. DJ, we would not, there is no more time for you to make closing remarks. I will now invite members to ask.
Have we lost you, Chair?
Yes, I was saying that, can you start, Honorable Swart?
I didn't hear that. My apologies. Thank you very much, Chair. Thank you to the DG and thank you to the colleagues from the department for their briefing. I firstly want to just say yesterday we did express our concerns about service delivery at courts, at the masters, maintenance. But I think it's very important to give credit where credit is due. And so I do want to commend the department on the unqualified audit opinion. This is a remarkable achievement, given the fact that over the many years, there's always been qualified audits. One remembers the third-party claim, the third-party accounts also always been qualified, and I do think there's a commendation here that is necessary to be given to the department, the CFO. So well done in that regard. Chair, I have a few issues that I wanted to raise. I think what the DG spoke about, the cost containment measures, must be a great concern to us. We have, as a department, as the portfolio committee, we have opposed cuts to the budget in the past. And if I understood the DG correctly, he indicated that this cost containment measure could be close to 1 billion rand over the medium term. This clearly has a massive impact on service delivery, and I'm not sure if it is fair for us to require the department to and other entities such as the NPA to lift their performance when we appropriate the budget as Parliament at the end of the day. Now, in that regard, I want to ask the DG whether he has considered applying to the CARA fund. Now, as we know, the CARA fund has got, there's a balance of 3.38 billion rand, which is compared to 738 million in previous years. And in previous years, the department was given money from the CARA account. And if there is this deficiency of cost containment, then surely it makes sense for an application to the ministers and cabinet that sit on the CARA account in terms of section 68 of the POCA Act to allocate funds both to the department and to the NPA. And I think, Chair, we need to make mention of this in our report as well. There's a substantial amount that is sitting in the CARA account. I don't understand why funds that are supposed to be going to law enforcement, to our department, to victims of fund are being given to the State Security Agency, 41 million rand. The Department of Environmental Affairs, 10 million rand. So I think that there is money to be found there. And I would ask the DG to comment on that. Chair, another major problem relates to the vacancies. And whilst we note there is an improvement in senior management at the vacancy rate, still there's a critical vacancies. And I'd like the DG just to comment on the vacancies relating to the Chief Master, the DDG Court Services, the DDG Constitutional Development, the head of the Justice College, the Solicitor General. Now, we know that was only advertised on the 16th of October of this year. But can I just ask, with the Solicitor General, why is there a 5-year requirement of expertise in the public sector? And will this not exclude experienced legal practitioners that could apply for the Solicitor General position? And then, of course, we know the challenges relating to the State Attorney's offices. The heads of the State Attorneys, there are 5 heads of offices that are vacant. And this obviously has a major impact on the performance of that branch. Chair, can I just say quickly on the State Attorney, I know we've got limited time, but just on the State Attorney's office, the Acting Solicitor General indicated recently that in his estimation, half of the 189 billion rand worth of claims against the government are either fraudulent or are substantially inflated, such as the claims against health, home affairs, police, and that they are fake claims. He suggests lifestyle audits on those officials involved in litigation against the state, and I'd ask the DG or one of the officials to comment on that. Lastly, Chair, the CFO just mentioned the amounts due by client departments to the Department of Justice. And I think the figure that was given was 1.54 billion rand. And this is a perennial problem, Chair, a perennial problem where client departments do the work, the department pays, and then the department is not paid back. And I think whilst we appreciate this has been escalated now to National Treasury, we again need to make reference to this in our report, that it is totally unacceptable and should surely be dealt with at a political level, given that this is a substantial amount that is due to the department, 1.5 billion rand. Thank you, Chair.
Thank you, Honorable Swart. Honorable Horn.
Thank you, Chair. Good morning to all colleagues and those from the department who are present. Yes, firstly, Chair, let me also add my voice in terms of congratulating the department on the improved audit outcome, as well as the indicators that in terms of financial management, there's been significant improvements over the last financial year. The one aspect, of course, highlighted by the Auditor General there is that despite the fact that that post in the supply chain management unit has seemingly all been filled, there is still not a complete compliance from that unit with the Public Finance Management Act in terms of procurement. So it would be good to hear from the department what steps will be taken to address that situation. Yes, Chair, I don't want to repeat the comments and questions raised by the Honourable Swart around vacancies and on a senior level. Allow me just to add an inquiry about the looming vacancies in the and as well as the, I want to say, the capacity or organogram really within the legislative drafting unit of the department. This is, of course, a unit with which we as a committee work closely together. And over the months, it is an inescapable conclusion on the part of the committee, I believe, that firstly, some capacity in terms of additional posts need to be added. And then secondly, we were, of course, already informed about a number of retirements in the near future, and specifically given the information about these other vacancies, some coming from early 2022 already, the legislative unit can't be faced with such a situation where there's a complete drain without proactive steps to prevent that. So it would be good to hear what plans is in place to address that situation. Then, Chair, yesterday we did engage the Minister on the issue at the Master's Court, just to repeat the comments made, but also to say that it is a huge concern that targets are not being achieved, which of course is a clear indication that the experience of ordinary South Africans and those practitioners who practice in that field is not overinflated in a negative sense. There's huge issues still remaining there. It's also an issue that the Auditor General had to, in respect of 2 targets, say to the department, no, you've not achieved those targets. The indicators, your claims to do so is not accurate. And then to, in specific terms, inquire from the department about the so-called digitization project in respect of trusts and the claims from people working in that environment, that what it basically means is that all trust files have been removed from Master's offices. It's with the service provider Veritas, and it is painstakingly difficult to get access to those files now, to change letters of trustee appointments as well as trust deeds, and it has a huge commercial impact. Chair, it would also be good to hear from the department around the comments of the Auditor General on the backlogs faced by magistrates' courts. This committee is well aware that when we interrogated the removal of indicators and targets around this, we were informed that the department is strongly of the view that it's unfair to keep those in place, given the fact that the department is not solely in control of these backlogs. But I think the Auditor General has come out in a very clear manner to say the department as the lead department and the responsible department for court services ultimately has a responsibility to deal with this matter in a more focused manner than would be informal programs to address backlogs. So it would be good to get at least an undertaking from the Director General and his team that this would be rectified come the new APP. Then second to last, Chair, is the issue of 1.8 billion having been spent on ICT and let's say digitization or electronic improvements without the vast number of targets in this respect being achieved. So it's all well and fine now to say, like the Minister did yesterday, that yes, we've not achieved those targets, but now, ironically, maybe not coincidentally, just yesterday, the Minister had to join late because some of these facilities were launched. But from an oversight perspective, Chair, the worry remained that in the financial year, nearly the full budgetary allocation was spent without yet again targets having been achieved, and it's not good enough to simply blame CETA. The Auditor General has also clearly come out to say that internal project management is what should be emphasized. And then the last two small issues. The first is court infrastructure. It's good to hear that the DG at least now have a figure of 170 court buildings that's in need of serious maintenance. As with the Minister, our plea would remain that the only way in which this could ever be dealt with in a proper manner is for a full assessment or audit of all court buildings to be done. The question remains, as per the undertaking of the Minister, that process was to unfold over the last months. Have that process concluded, and can the committee be put in possession with both the outcome of that audit in terms of the needs assessment for serious maintenance, as well as the action plan around that? And then lastly, and we will keep on asking that question, even though yesterday it was in no way answered, what is now the status around court recording technology, the basically interim extension of old contracts on a very unsatisfactory basis, and what is the progress, if any, with settling on a project to replace the current version of the court recording technology with a longer term solution? Thank you.
Thank you, Honorable Neville Trohan.
Thank you, Chairperson, and good morning to everyone on the platform. Thank you to the Department of Justice for their presentation to us, as well as adding my voice to congratulate the department on improving to an unqualified audit. So congratulations on that. Just a few questions I have. I don't want to repeat what was already said or asked. I would like to add to Honorable Swart asking with regard to the CARA fund. I see for this financial year, the department received 23 million. I'd like to know the breakdown of that amount. What was the money used for? What programs did it go to in terms of the 23 million for this financial year? And has all the money been spent before the end of the financial year? So just with regards to that. Then also the Guardian Fund. In terms of the Guardian Fund, what internal controls are put in place to make sure that the money is not unauthorized, spent unauthorized? Currently, do you have any measures, or will you be implementing any measures Then I see the universal access strategy. I see 70 courts have already been made accessible, but if with your permission, Chair, I would like the department to send me a written list of where these 70 courts are based, because I am still concerned, especially in this year, just recently, the court in Bishop Lavis, who threw out a rape case because there was no sign language interpreter there. But fortunately, the case has been postponed and will still continue and will not be dismissed. But I would like to know, now that South African Sign Language is official, you know, what are the processes made available to make sure that sign language interpreters are provided, especially with regard to GBV cases that should not unnecessarily be dismissed because there's no sign language interpreter at that moment. Then one last question with regards to the electronic, the process of access in terms of the IJS system. A lot of decrease by 1.6 million cases that has not been processed compared to this last financial year. So I want to know, how is the department making sure, other than the mention that was made from the CETA issue, but how can you make sure that the electronic processes are improved and sped up? And then what does the IJS committee do to make sure that the big numbers are not reached, so that we complete all those numbers? That's it for me. Thank you, Chair.
Thank you, Honorable Masako Chela.
Thank you very much, Chairperson. Let me also thank the DG and the team. Also with the minister, because I was not able to participate properly yesterday, just to convey that. The minister and the team, deputy ministers, for the good work, Chair. Moving from 51% to 86%, Chair, we really have to commend that. We are really congratulating the department for getting unqualified Chair. Congratulations, Chair. And Chairperson, and there are a few things that one would want to point out to the department, Chair. We also acknowledge and congratulate on the side of the improvement on the expenditure, as the CFO was making a presentation. Chair, that improvement, they have to keep it. We want to, when we close this term, all these improvements, in actual fact, the good work, we have to close this term with a bang, good bang. It makes us feel very good. These improvements, yes, they are there, even though there are problems, as the AG has raised those concerns. Also, my colleagues have also raised a lot of important issues, particularly on the issues of the vacancies. The only question maybe I would want to ask or get clarity from the DG, because it is like there is a point that they are saying, he said when he was doing his presentation, that it looks like they are not getting the right skill when the way there are people, in fact, people who qualify, who are able to do what they did not come forward. It means it might be a lack of the professional skills, as we are always talking about. But I wanted to find out from the department, what is it that we are doing? Because it sometimes it might not be the issue of skill. it might be the issue of interest. People have lost interest working for the department because of all these things that have been raised in terms of how unprofessional we are, how we do things, we unlearn them of what they have learned as professionals before. So I want to see, in fact, I want to hear from the DG, what is it that they are doing in order to make professionals who like working with government, if there is something like that, that they are no longer interested in coming forward. The second one, Chair, it is on the issues of funds. The CFO said there are those stolen funds and the duplicate payments and all those things. The question that I want to know from the department, Chair, is that how easy is our system that it allows such, Chair? Or is it another issue of corruption? If they can also clarify that point, Chair. There's another issue on the ICT that my colleague has just exhausted this one, but I wanted to find out from the DG and the team. I think at some point we spoke about the issues of leadership and all that. I know my colleagues just mentioned that we can't blame everything on CETA and all those things, but we also want to find out from the department in terms of their creativity in assisting us to ease the burden of unemployment, because Chair, our visit, when we were going around in those courts, we saw ourselves, those files lying there in the corridors, everywhere, in all the rooms. The storage is full and the files are everywhere. And it's so worrisome because some of the cases, Chair, are those cases that we are talking about when we talk about backlog. And now the ICT, there is that little improvement when it comes to the issues of ICT. I want to find out from the DG, what is it that can be done to at least, even if it's for a short period, or get those aspirant young lawyers, those who are still not yet in the employment, to employ them only on this issue of data capturing. Try to help them whilst they are helping us in eradicating this issue of files. We saw when we went to, is it Legal Aid in Johannesburg, Chair, the good work of if we can be able to master this issue of using digitalizing our systems, Chair. We saw that it was very good and it's commendable, and we were happy. So if we can master that system and make sure that we are in line with everything that is required in terms of that, Chair, we will be able to eliminate lots of backlog and all these problems. Lastly, Chair, on the issue of the AG, no, I think, yes, that one has emphasized so much since yesterday, the outcome of the Auditor General. But I think as I'm talking now, Chair, the DG and the department, they have already started working on those, because that presentation should have started with them. They are already working. The most important that I thought that next time when they come, they must give us maybe a good report. Is this issue of assisting on the issue of grey listing, Chair? this issue of grey listing, it was clearly articulated, and all that is connected with which is not assisting, it should be taken care of. We want to hear how the department is going to deal with these issues. And next time we don't hear the HG commenting on the issue of not helping in assisting us on this area of grey listing. And then also the issue of maintenance, Chair. My colleagues have spoken on that one. It is important that that issue there must be progress, not just progress. It should be eliminated. We've seen that on our visits, Chair, to these courts, particularly when we went to Kimberley, Chair. As a team, we realized that, Chair, in that magistrate court, the security was so bad that it is like we are in the kitchen, in the dining room. Even there is no, in other courts, you could see that the atmosphere in terms of security, even if maybe there are still problems. But there, Chair, they were giving us a report that even the accused at some point, maybe twice or whatever times, I can't remember, they were able to jump when the magistrate, maybe after saying this case postponed or what, this guy will just jump and get out and run away. And then the job of looking for him again, Chair, start. It is because of the security that is very compromised in those courts. So the issue of infrastructure, Chair, maintenance, our courts outside the infrastructure, it has been emphasized. Please look into that issue, correct that. Lastly, Chair, indeed, lastly, when we went to Bloemfontein, there were issues, those that were raised. Yes, the security, I've already spoken on the correctional services. We requested that they put the fence, the security fence around. We would really love to hear if that has been done. And then lastly, on the issue, there was a senior official which hit the woman, the nurse, the Chair, with a fist. And that woman, we got a very bad report. So that GBV issue, Chair, we need to get the progress report. What have they done? Is that senior official been disciplined? Is that woman? Because these are the things that makes the department not to be able to deliver accordingly when even the officials themselves are not in good terms, they're fighting each other and their issues are not resolved. Thank you very much, Chair. I think I'll pause here.
Sorry, members, I was kicked out. Honorable Jela, are you still speaking?
I'm done, Chair. I'm sure the department, I'm done. I've just finished. The department, I think they heard me, Chair.
Okay. Honorable Janji.
Nkosi Sihlalo, thank you very much. Greetings to you and everybody in the meeting. Just upfront to announce, Chair, that I will focus my questions on the HR and vacancy matter, and I'll really confine myself there. I'll try and ask very specific questions, and I expect specific responses in that regard. I have quite a number of those things that I want to raise. Firstly, just on a general point, I like the slide that the DJ put up that she spoke on. I hope that at the end, when he responds, he'll put back that slide and see whether that slide is still standing after we have engaged, because it's an important slide that is factual, that shows progression, that shows progress and it's quite important because it takes into account the 5-year period we've been with this journey. So I'll thank you very much for that slide. It's very important. But maybe to interact with that slide with some more detailed issues, Chair, perhaps the first issue that I really want to get into, let me start. Honorable Swart has addressed a bit of it. It's in relation to the vacancies, and I'll start with the vacancy of the SG. You have the SG post that has been advertised from September with a closing date of 16th of October. I have a few concerns about that, Chair, and I want to also invite the Deputy Minister to assist in responding to this, because that advert is done on the basis that there would have been a benchmark that was done, and so one would be interested to get, maybe not in this meeting, the report of that benchmark. What came out of that benchmark? Because there are a lot of concerns in relation to how the advert has been designed. And it's serious for me because it raises issues of credibility about the design of this advert and what this advert kind of aims to achieve. Honorable Swart raised one of those issues, this new criteria about the 5-year, because you don't know why this has been included. Is it because it's included because you want to get competent people, or this is included and unintentionally it can give us a result of excluding the required kind of skills? And my next point still on this SG, the position of the SG, when I read the advert, seems to have been demoted to a level that is even junior to that of heads of state attorneys. And perhaps an answer to that must be given in these meetings in terms of those kind of specifications, some of each that would have been lowered. So, for example, currently that position would have been at level 16. It's advertised to be at level 15. And so we need to get a proper explanation why this is so. Is the department aiming to attract skills here and competent people? When it does this, it's already crying about it's not able to attract. Here you have got an advert that is so designed to not attract proper skills. And so I want to get a proper response to that, because it seems from where I'm sitting, and I'm going to be very, very candid. If you look at that position, it looks at attracting everybody else except the acting person that is there. It's very clear how these things, in terms of that advert, is that the intention of this advert? And I'm asking that I get a proper response, both from the DG as well as the Deputy Minister. And perhaps, Chair, this is the one area I'd want to have a follow-up after listening to their responses in a way of a proposal. I'm worried about this advert and whether this advert is contributing to helping that slides that go up, that the DG has put up, or this is an advert that is not going to help us kind of going forward. So that's on the SG matter. And perhaps whilst there on those vacancies, the next vacancy that I have an issue with, was I normally focus myself on the court services, the core program of this department, which has got over 12,000 people who are employed, 79% of that. It's a critical component in terms of program 2. But yet you've got a DDG court services. Chair, this DDG court services has been vacant since January 2022. So you are over 21 months of this being vacant. The advert would have closed after a long time, would have closed in July 2023. Today we're told that what is outstanding now is the cabinet making a decision. So that long period, I mean, not even Parliament does that. We have tried to demonstrate why there's a need for us to have short periods of vacancies and appointments. We've done it twice in this term as this committee, in the Deputy Public Protector appointment and the other ad hoc committee on the new Public Protector. Everything gets done between 4 and 5 months. And it's a process that has got a separate arrangement, including public participation into it. And yet, department can take that long for just from start to finish in terms of the vacancy. It's completely unacceptable. I don't know if there's a reason for this. And I'm raising this in the context of the progress that has been made. Honorable Swart has also, in relation to this, raised the issue of the other vacancies. You've got 5 vacancies of the state attorney's offices in 5 areas or provinces, vacant for a very long time, even those. And these are the offices that must deal with critical issues in terms of legal services, including state litigation. So what are we expecting around some of these issues? So, and I'm not getting any explanation about why these 5 vacancies that are still kind of outstanding. And then my next point, Chair, still on the HR. We're told in the report, the annual report tells us that 640 staff during this period under review have resigned, 640. So it is one thing to say your problem is attraction. And I say, no, your problem is not attraction. The problem you have is that there's a stampede. There's an exodus of people leaving the department in droves. They're getting out of the bus. They just can't wait to be there. So you've got a problem of retention. If you're going to have 640 just leaving, resigning, it is a problem. And it's not improving because in the previous year, it was 486 that left the department. And the year before that, it was 420. So it's not getting better. So I don't think that we must just look at, we have a problem of people not, because it looks like people have made a decision. They've decided this is not a department of choice. Not only those that are outside, those that are inside are leaving. So that for me is very serious. So you have an arrow that is going up in the negative in terms of that. And then the next point, it's this issue of 183 issues of misconduct and disciplinary matters, still part of the HR. And of those, 45 would have been dismissed and 13 jumped, kind of resigned. And I will be interested, perhaps not for today, to get a written response to give us a breakdown of those 45 dismissed, the reason and their levels, perhaps, because they are around the issue of unauthorized fraud, dishonesty, being absent from work, basically, which then speaks to there seems to be an unhappy space in a department. When you look at the figures, there seems to be an unhappy space. And this is happening at a point when the arrow is going up. It's saying we're improving. We're at 86%. And I'm probing this 86% given your own facts that you have shared with us. I'll be interested to get a clarity, Chair, on the 35 individuals that are on precautionary suspensions. Because you have got, and over 30 days, many of those have exceeded that. If we can get an explanation about that on that issue. And then, for me, the next point, also from the report on the HR, levels 1 to 2 in any department of government. This is a heartbeat of a department. They involve your deputy directors, assistant directors, and every other skill. These are your foot soldiers. If you speak to any director, chief director, if we ask them questions here now, the first people they're going to go to is your level 12. because those are the people who are working with this information. But yet, in the report, it's not inspiring. For example, you've got 78% of that level 1 to 12, who have done, who have completed assessment. That's a big gap. Why 78%? Why is it not 98% or 100%? What can you speak to that gap as to the ones that you don't have out of that 78%? I think it's notable that there's a promising wellness program which is yielding some positive results. And then on the SMS, Chair, the 98% issue there in terms of completion of work, there are 2 suspensions. I'm interested to, not necessarily the names, to know which directors, chief directors or DDGs have been suspended. Which of these 2? Director for this, chief director for that, DDG for that, of those 2, and 1 that did not comply. Who's that director? Who's that chief director? Not the name, that position. I'm interested to understand so that we know what really we're talking about here. And then you've got perhaps just lastly, Chair, on the issue of learnership and internship. If you can perhaps break that down, you had 400 learnership and internship, and you club it together because the 2 don't mean the same thing. And yet in the placement, you have 40% of that you have absorbed in terms of placement. Is that placement in relation to learnership or internship? And at what levels are we talking about here? For now, Chair, I would pause there, but I'm really serious about the red flags I am picking up on the HR, because any department, it is a department because of personnel. It's a department because of people. We can talk for as much as we can here. If you don't have a department that is capable, that is well-resourced, that has got these personnel that are attended to in terms of their issues, we can as well forget. That graph that is going up to 86% might easily go down back to 51%. Thank you, Chair.
Thank you very much, Honorable Janji. A few issues on my side before we allow the department to respond. I will start with the issue that Honorable Janji raised on the issue of the Solicitor General. When we assumed office in 2019, the legacy report indicated that one of the reasons the former minister, Honorable Masuta, could not fill that post, it was because people were not willing to come at that low salary. So 5 years later, we are still there. Usually, Albert Einstein would say, if you do same thing over and over again and we expect different results, it's a definition of something. I would not say it here. Now, if you look at the heads, you have the head of the criminal side of the state, that is the NDPP. That person is at a level far higher than the salary that you are advertising. And then you have a head of a civil side, which will be the SG, and you expect that person to be close to 900,000, 800, 900,000 below the one that is heading the criminal division. What sense does it make? What sense does it make? And I mean, the issue that Honorable Janji has been raising, who are you going to be able to attract at that level. And even if you have been able to attract a person at that particular level, will not that create a bit of a tension to say, but why I am responsible for the litigation of the whole state, not only for the Department of Justice, I'm responsible for the litigation of that state. So the issue that what benchmarking was really done. And secondly, I mean, when the legislature created this office of the Solicitor General, are you really advancing the purpose of the legislation by trying to appoint a person who will be at a level so low that even it is lower than level 16? So I think that is one issue that I do think that we have not been able to fill the post for 5 years, but you are not taking measures that are generally different from what you have been doing throughout. So why do you expect different results? And then there is also this issue of 100 days challenge, which was hosted in Limpopo. The issue and some few other areas, but the issue is it's a good program. Why is it not being rolled out throughout the country? Because it makes officials to be very creative in solving challenges that they experience at particular courts or areas that deal with areas of criminal justice. Why are we not rolling it out throughout the country? And then going back to the state attorney, we keep on getting complaints, Solicitor General. One of the complaints is that lawyers are not paid within 30 days. On average, they are paid in 97 days, which is extremely unacceptable. You look at a person who has just taken chambers, who was not getting paid because he was doing pupillage for the whole year, and then the state pays that person after he or she has done her work after 97 days. In most cases, that person will have to incur other costs, including overdrafts. So the money that eventually she will be paid or he will be paid will go to bank charges. And this is what Cabinet has always been trying to grapple with, that the state must be responsive, especially to the plight of your small, medium-sized businesses. But the state attorney is not adhering to that, Solicitor General. We are getting complaints every day of people who are not getting paid, people who have to struggle to be paid for services that they have rendered to the state. And then there was an issue that I think Honorable Swart raised. I think it's important. We are told by some people who are complaining, some councils that are complaining, that your new fee of a person who has 5 to 9 years are as low as the fees of a person who has just assumed, in fact, who has just started practice. Is that true? And if so, why is it so? And then there is also this issue of there seems to be a problem with your policy on how many briefs can a person get within a particular time, because those people who are writing to us, they are complaining that you have sometimes you'll get one brief and then you are told that, no, we have already been given briefs, but other people are getting briefs almost every month. So, other people are getting briefs every month. So, so this issue of random picking of it seems to have its own challenges. I think it would be important for us if you can get responses to those questions. Thank you very much. Over to you.
Sorry, Chair, I'm not sure if the Deputy Minister is still here. There were many times that honorable members, they said that DM should respond to certain aspects of what they were raising.
I think he is in the NCOP.
Okay, Chair, with your permission, I will proceed. I'll start with one question from Honorable Janji for now, then give the colleagues to deal with the other questions, then I will come back. The more than 98% of us who are in the senior management, particularly the executive committee part, that's your DDGs upwards, will have started on average in January 2021. So will be around 2.5 years in those responsibilities, with the exception of 1 or 2. And I'm raising this because just to reflect that the current term, the 6th administration, will have found it midway. So the first 2 years and we wouldn't have been there in these responsibilities. I'm saying this because then there are legacy issues that we may not necessarily have had a same approach with the committee right from the beginning. The department currently has about 17,000 employees across the country. The base, if you look at the pyramid of the staff complement of the department, and I think in the region of about 60%, is your low level. It's not just 1 to 12. Low level is, 5, 6, 7. And if you look at what level 5, 6, 7, they are predominantly distributed across the 780 something or so courts as clerks and different administrative or clerical jobs. Now, when you look at the job requirements, or maybe beyond that as well, you have court interpreters who are on those levels as well, 5, 6, and 7. When you look at the inherent job requirements, it's a matric, that's grade 12. For someone to be hired as a clerk in a court or to do administrative work or to do court interpretation. Subject to correction, the latest information I had, we are sitting at around 2,200 or 300 court interpreters across the country. I'm breaking down that base that I'm talking about. Now, the requirement having been that and officials or colleagues having taken the responsibilities, ordinarily, there were young people having matriculated 2 years or 3 years having matriculated. The department gives bursaries, others study on their own. I guess when HR writes this is a report and call it resignations, someone will think people are running away. The 600 is not running away from public service. They take opportunities somewhere else. So that's at least the context. If we're gonna do the contrast of saying that slide, I take it from the point of view of saying prioritize your human capital development as part of your future in order to maintain that gradual rising graph, but not in the converse of saying if we see the 600 resignations, the argument that of that graph cannot be sustained. And then I take it that I understand Mr. Janji that way to say, take care of these numbers as part of building to the future in order to maintain that graph the way it is. And it is out of that understanding, Honorable Judge, that our turnaround plan, if you remember, the 8 turnaround plan, one of the critical pillar is human capital development. So we are to conduct skills audit. 2 weeks ago, I met with close to 400 law graduates coming from that base that I'm talking about. So over the past years, the department has been awarding bursaries to these officials who will have joined the department with grade 12, and they've now obtained legal qualifications. So we're working on a program with the Solicitor General to grant them opportunities to go and do vocational training, articles of clerkship as it used to be called. And we are starting in January with that program. So part of how we're going to offset the impact of austerity is to go to that, and another group will be graduating end of that year. So we're trying to catch up with time. The department had over the years been deterring on finalizing a policy on doing that. So as you will see, if you do that part, then you move to the middle and the senior management, you see a significant drop. In fact, in senior management, I haven't seen for the time that I've been here any form of, except maybe in exceptional circumstances where colleagues get promotion somewhere and we're not able to keep them and counter offer them. So I thought I need to explain that, because next year when we come back and do an annual report, you will still be seeing that number, because that's what explained. But those who have developed an interest in working in the department have studied LLB, and we're going to help them to get admitted as advocates, attorneys, and then develop a program to place them and have an understanding and agreement with them that once we have helped them, they will come and spend a certain number of years, 3 years plowing back to the department before we can allow them to leave and go and practice on our own. So that's the strategy that we are really developing to work around that issue. Now, from where we are to that level, to the ground, you will know that the department management will start from your court managers, who in the majority or are at an assistant director level, and move to the district level where you have a deputy director, then the provincial offices that coordinate some of the work, and then you come to the branch level. So by any account, without any specific philosophy I'll apply to, the numbers, if you look at the size of the department, the entire staff complement, will not be out of the ordinary in relation to either your cases of 183 and looking relating to fraud, honesty, absenteeism, and so on and so forth. 183 broken into those different areas that Honorable Janchi had identified.
I think, yes, please explain, but don't over-elaborate. We still have to deal with the NPA also today.
Okay, yeah, there was a big threat from Honorable Janji that he will come back on this matters unless I give him a thorough explanation. Thank you very much, Chair.
It's not a threat, please. It's not a threat, Chair. Sorry, Chair.
Okay, all right. No, thanks, Chair.
You're protected, Honorable DG.
The DDG post-court administration, indeed, it was vacant from 2022 January. It was advertised interviews were conducted, a successful candidate was identified. Then the DPSA, as a department responsible for taking the matter to cabinet, came back to us with questions on certain issues that they found when they were doing the vetting that we ordinarily would not have found, as they do an advanced vetting. And we had to approach the candidate to say, can you please assist us with these following questions? There is this and that that they found that you didn't disclose, and the candidate didn't come back and we couldn't take it further. We had to re-advertise the post. But I will not comment because as the members of the committee will know, the interviews are done at ministerial and deputy ministers level. Of course, the DG participates, but we made sure that adverts are done on time, they close duly, and so on and so forth. But from that process as well, the cabinet processes, the processes of going to the DPSA can be cumbersome. There are many things that have to be done as well, including competency assessment. So then we've just been confirmed that the matter is on the agenda of the cabinet for next week for consideration. That's the part on the DDG for court administration that it had to go through that. Now, the challenge that we have started raising in FOSA, the Forum of South African Directors General, is that when you go to DPSA, look at the regulations that are regulating public service and the different regs. There are requirements that are set for all different government departments, and we don't deviate on our own. So they directed that this is what is required. You'll recall some years ago, close to 10 years, they came up with the requirements that to serve as an SMS member at the director level, it used not to be that case. You must have been a middle manager for X number of years. That's part of the reason why currently in the department, of the close to 160 senior managers, we will not have someone who is below the age of 35. So there's no young person, as in like the age 35, who will be in SMS. The reason being that if you count the number that you leave university, gain this and that experience, to be at MS, if you have to first do the 5 years as a middle management and all of that, by the time you are 35, you will not have met the requirements. And it's a matter that is being discussed to deal with that as well. And I think that speaks to all the senior managers' position that says you must have general, number of years in management in this area. And part of it, you must have done this number of years in a public service. So there are those guidelines from public service that deal with those areas. I had mentioned the masters when I was talking about skills. It was mainly the chief master post. You do get expression of interest. Many people apply. But there will then be certain things around that issue, because if you look at the masters, for example, more or less the same as the SG, because the masters as well is a creature of a statute, the chief master. So you will more or less find similar experiences that you must have experience in deceased estates and in liquidation and so on and so forth. That's part of what's required. But public service looks at this and say, you are coming to do strategic management. You are not occupation-specific dispensation. And that's where then you get the dissonance. That then you then need to have management understanding at that level that you must have been in management, but that management also must have some part that was a management in public service. So when we're talking about the relevant skills, that's what we're referring to in the post of the chief master, that you'll ordinarily have people apply. Either they are practicing attorneys who do deceased estates. They may not have specialized in liquidation per se, but then the requirement is that we must have been in management. But part of the challenge as well is, and I'm sorry to say this, my colleagues must not think that I'm putting them under the bus. You would ordinarily expect that masters of the high court who are across the country, the 9 provinces and the 9 high courts, will be the pipeline to have an ambition to become chief masters. But it does look like, knowing what we know, the position has become so much hot that colleagues are comfortable just being masters in their areas and not want to be exposed as the chief master. If in a closed meeting I could explain it further and better. So that's the challenge you have. Even with court administration, you will ordinarily expect that the provincial heads who are running the courts in the provinces, KZN, Mpumalanga, Western Cape, it will be a pipeline. You will have a stampede of all of them having an aspiration to become Deputy Director General for court administration. But this one, for a different reason, is not the same as the Chief Master. This one is not hot and dangerous. That other one is a different case. You then don't see colleagues coming forward. And so that's where the challenge is, that it's difficult to go and find a DDG court administration outside of the Department of Justice, because there's no other department that deals with court. Someone will have an understanding of how to manage the courts. So that's the matter that once we pass this phase, we have to work on talent management. And part of our human capital development strategy is to develop talents that will be able to grow into these positions in the public service. It would have been better if Minister and the Deputy Minister were here to deal with the Solicitor General issue, because I could call it something that is not really in the control of the Director General. Director General and the department will have a responsibility for running the processes. Now, maybe just for your benefit, honorable members, the State Attorneys Amendment Act, if I'm not mistaken, was done in 2014. And you made reference to Minister Masuta. For the whole term, the fifth administration, that Amendment Act was never put into operation. So it was only in the sixth administration. The then minister had reached out to the Minister of Finance and Minister of Public Administration not to put into operation the State Attorneys Amendment Act, but to develop a new concept, more scheduling or setting up state attorney as an entity. Well, there are different levels of entities. I can't remember exactly which one. Both ministers responded separately to the minister. And that's the record that is there, saying that your proposal is not supported. Now, then the minister took a decision to say, let's put the State Attorneys Amendment Act into operation. It will not help to want to amend an amendment act that was never put into operation. Hence, then the Office of the Solicitor General came into being. But the comparison between the National Prosecution Act and the State Attorneys Amendment Act, when you read them on the part that deals with the head, and obviously the National Prosecution Act follows directly from a provision in the Constitution, and the State Attorneys Amendment Act is not coming from the Constitution. But when you read both, the other one is specific about how the National Director and the deputies, maybe and the directors of public prosecution, are to be dealt with in terms of their ranking and so on and so forth, in terms of the financial part of the benefits of that post. The State Attorneys Amendment Act doesn't say so, say something different, and say you have to do this in line with public service regulations, with the laws and regulations guiding public service. So I just thought I needed to clarify that part, that was the argument that Minister Masuta, former Minister Masuta, had about this is litigation on behalf of the state, this is criminal matters, this is civil matters. But then the State Attorneys Amendment Act did not capture that, or the Portfolio Committee and the legislature did not capture that the way it is captured in the National Prosecution Act. Obviously, I wouldn't know for different reasons. That's why I was saying it's a legacy issue. In 2015, though, we got a report that the department conducted a job evaluation, as is required of public service posts, that there must be a job evaluation, which was finalized but the act was never put into operation. So Minister proceeded, used the provision in the State Attorneys Act, Amendment Act, that provides for an acting appointment, and he managed to operationalize and activate it on that basis. But for purposes of moving forward and permanent ties in accordance with what the Amendment Act says, then the process of back and forth with DPSA started. DPSA, Public Administration, was asked to conduct a job evaluation, and they conducted a job evaluation that came back to what Honorable Judge was referring to, that what is advertised. So in doing it, they didn't compare what would be the salary rank between the Solicitor General and the National Director of Public Prosecution, and then say they try to close the gap or not. They do what they think they are supposed to do. So, but this is just the more of a high level part, but to the limit of what the Director General can speak to. So those vacancies now will, at a DDG level, will then be left with the Chief Master post. That as well will be, I think, will have to be re-advertised after trying to look at the specific areas that could have been not clear to people who ordinarily should be applying. And the Justice College, the post was advertised. There were responses, but predominantly the responses as well, there seemed to have been a misunderstanding that Justice College is not just a college, but part of what it does predominantly has to do with law and the justice system. So the advert had to be attended to, again, subjected to corrections of job evaluations. But what we have done now, we've asked for, because of urgent programs that have to be done, we've signed a secondment agreement with the SIU for a senior official from SIU to run the college in order to implement the MOUs that we have signed with other countries from outside the continent that are supporting specific programs that the college has to run, but it's on the cards as well to attend to. I will ask the legislative development, the issue that Honorable Swart has raised and the Honorable Horn on capacity. It is our priority. We are in the process of working on internal promotions in that branch, particularly around the legislative drafting area. And we just hope that soon that process could be concluded. With whatever that will remain as part of our budget after the budget cuts, I've already raised this with EXCO, and all of us in senior management support this idea. We'll want to build up a lot of capacity around legislative development. So we'll also try and run a cadetship program where we create an entry level for assistant state law advisors drafting, so we can absorb young graduates who will have done pupillage and articles and subject them to training on legislative development, because we can see for the seventh administration, there will be a lot on the plate of this branch, and it's very key. Our definition of access to justice revolves as well around the work that is done by legislative development. So we want to make that commitment to you, honorable members, that this area, including intensive training by the college as well around this area, to make sure that we keep the capacity. I would ask Mr. Isaacs to deal with the issue of the court backlogs.
DJ, can we be done at one? Please.
We'll try our best. There's just that critical issues have been raised here, Chair, but we'll try our best. Mr. Isaacs will deal with the court backlogs, and I'll ask Mr. Jabu Shachwayo to deal with the ICT-related matters. Ms. Mamecha to take the infrastructure, critical issues around infrastructure that have been raised, as well as the other related matters on HR. And CFO will come back as well, then Solicitor General to deal with the matters we have raised. Mr. Isaacs?
Thank you, DG. Chairperson, Honorable Chairperson, and Honorable members, colleagues. In respect of the court backlogs, we in the Department of Justice have an integrated case management system on which our cases are registered from a specific date, and the system automatically then if the court case goes beyond a specific date or number of days, it is converted into a case backlog number or statistic, number one. Number two, so we do have reports in respect of such case backlogs. We have reports per province, per court building, per case. And so we can drill down right down to the very reasons for the case becoming a backlog itself. Now, very important is the fact that we continue to encourage local at the court case flow meetings where the actual reason for the postponement is happening. We recognize the fact that the judiciary remains the chairperson and in charge of case flow, the person who has to agree to a postponement or not and consider the reasons. We also know that the role players in respect of case backlog is the department, as it happens at our courts. What then has a role to play in respect of, from the departmental point of view, is our personnel, our infrastructure, our equipment, our specialized admin support, such as foreign language interpreters, then our machines, first of all. Second of all, role players in the case backlog, that is district court as well as regional courts, include SAPS, NPA, the Legal Aid South Africa, Social Development, Health, local government itself as far as the water and electricity is concerned, as well as in our reports even received from the judiciary, they add a percentage caused by the judiciary themselves as backlog. And I'm emphasizing it is reports received by the judiciary themselves, more specifically the regional court backlog report, where the much more serious cases are being heard. So we have prepared a structure, how the backlog structure framework is handled from a JCPS national level down to provincial, all the way down to the ground level, where a whole lot of role players have a large measure of movement in ensuring that the backlog is worked down. So one important issue that has caused backlogs was our very own CRT, court recording technology machines. We can, at this stage, report that from a weekly observation, trending, basically out of the 2,000 and some odd machines, 90 machines are continuously broken down. We also make the assessment that those machines are then the usual. So our focus is to deal with those specifically long-standing broken 90 machines. So once we get those machines up and running, first of all, we expect the machines to be operating at about 95 to 98% nationally every single day, number one. Number two, in respect of the Department of Justice and the backlog, largely caused by the load shedding, first of all. Second of all, it had to be very clinical skills in deciding we have to stop the court, we must switch the machine off, the load shedding surge will burn our wires of our court recording machines. And that was close monitoring that had to happen. And it is and has been implemented because of the fact that, you see, we are monitoring these the 90 to 91% workable machines in the country. And that is very accurate. We have been monitoring it weekly, not only monthly. The generator program in all provinces is at an advanced stage. I think I speak under correction. Because I'm the provincial head of the Western Cape as well, so I can report in that respect that the tender has already gone out in September, And so very soon, once evaluation has happened and allocation of the adjudication of the tender, then we can have service providers on site, and that includes then 99% of our courts that do not have generators, for example, in the Western Cape. And I'm going to safely assume that the same
Mr. Isaacs, try and wrap up. I'm worried about the time.
Thank you, DG. I'm going to safely assume that that has been happening in the rest of the country because it has been done under one memorandum. So we are monitoring our backlogs. We have the reports. We can report on it. We are also now engaging in a monitoring the statistics with a Judicial Accountability Committee via the Office of the Chief Justice to monitor case flow and ensure that our criminal and family law stats are up to date. Thank you, Chairperson.
Well, you are being repetitive. Thank you very much. The next one.
DDG Manager, can we urgently deal with the infrastructure and try maybe to manage time and to the point, and security and HR?
No, so thank you, DG, and good afternoon, Chairperson and the members of the Portfolio Committee. I will start with the issue that was raised on maintenance of infrastructure. Yes, indeed, we've got 170 courts that are in need of serious maintenance, and the 1 million delegations that have been approved by the DPWI is being implemented in terms of some of those issues that needs maintenance. And on the issue of the conditional assessment, the last conditional assessment that was done by Ernst & Young in 2016. And we are now in the process of appointing through DPWI Consultants Database a new conditional assessment service provider to assist us with all the courts. And then after we'll come up with the action plan that has been suggested. The security in the courtrooms, Chairperson, we are limited in terms of providing security inside the courtroom because it's SAPS and correctional services that are allowed inside. We are providing security around the courts. So when an SKP runs out of the court, then we can be able to catch him outside. But inside the court, it is very difficult for us to go in because we're not allowed in there. Now, I want to also touch on the issue of the resignations, the 640 resignations that we've had. Some of them, because we always conduct exit interviews when a person resigns, and we have a report that we also submit to our DG to see why people are resigning, because we are really focusing on building the Department of Justice and Constitutional Development as an employer of choice, and also trying to retain the skills that we have. But we find that in certain situations that people resign, yes, for greener pastures, but some resign just to access their pensions. And we have also noticed that most of them that have resigned, and a few years later, they then come back again to the Department of Justice as employees. And now in our reports going forward, we will have to then streamline this number of people that have resigned and those that have came back so that we can see the impact of that. Now, the position of the Chief Master Chair, it was approved now for headhunting, because we have tried several times to fill that position without success. And as the DG said, it seems like that position is very hot, even for our internal officials. The two senior managers that have been mentioned as having been suspended, one is at the Chief Director level and one is at the DDG level. The one at the DDG level has the case has now been finalized with the final verdict as a dismissal, and the other one, which is a Chief Director level, is still going on. The disciplinary process is still going on. On the issues that was raised on the heads of state attorneys that are vacant, some of those offices like Mahikeng, Kimberley and Toyando, and Mabatu, they were managed by LP10s. So we have some of them. We have already converted those positions from LP10 to chief director post, and the one that is still left, I think it's Mabat or Mafike. That one we will only then convert it once the position is vacated. So on the other issue of the legislative drafting positions that are vacant, yes, we have spoken about it even in our last EXCO, that we need to fast track the filling of those positions between myself and the DDG legislative development. Yeah, I think the DG, you have covered us on the issue of the SG, that we needed to follow the PSR and the public service regulations for us to advertise the post in line with the JE results that were approved already. Thank you, Chair.
Jabu Tlachwayo, ICT, quickly.
Good day, colleagues. Good day, honorable members, Chairperson. I'm just gonna give you feedback in terms of the CRT within the
I think,
department.
Jabu, it's your first appearance to the committee, so you can show your video as you speak so they can see you.
Okay, caught me off guard there. I hope you can all see this ugly face. Good afternoon. So quickly, in terms of the CRT, of course, we've got a short, medium plan versus the long-term plan. I think for short, medium term, we're trying to get a support and maintenance contract to replace the current one, which has been extended up until the end of November on a month-to-month. We are dependent on the SITA procurement processes, but in terms of the target dates, we're expecting that we should get a recommended service provider who's going to support and maintain for the next year or two. By the 6th of November. I believe it's now at the auditing stage because we've completed the evaluation process. So this is just the short term to be able to keep the lights burning, because we're still reliant on this equipment, though it has reached end of life cycle. Thus, we have a plan to sort of have a court recording audio-visual system, which is gonna actually be an integrated system, which looks at the recording functionality, the audio and video functionality, which will actually also take care of the SOS and the AVR at the same time and enable the courts to be able to hold their virtual courts and court sessions and so forth. So that the procurement is initiated with SITA, which is finalizing the spec. And of course, the rollout of that system, as soon as we finalize the procurement, we're going to roll out the audio-visual part, in line with the 170 courts as part of the minister's APPs. And we are hoping that this solution, because it's integrated and it will be software-based software reliant more than hardware reliant, at least, it would be more reliable and sustain us for a long time. And then in terms of, I think there were issues raised in terms of, paper records. So we are trying to initiate a backscanning project, but now with this cost containment, because the aim is to ensure that every paper documents or archive documents that still need to be retained for a specific period of time is available digitally. So I was in the process of initiating the backscanning project. There's a business case for it. However, we are being challenged with the availability of the funds due to cost containment. But we are engaging with the CFO and the other stakeholders to see if we cannot get funds for that. I hope I've covered what is expected of me. Thank you.
Solicitor General, quickly the briefings and the non-payment of lawyers.
No, thank you very much, Chairperson. I see I've got 2 minutes. I'm hoping that I will be able to do justice to your questions because they are very important or critical. The issue of delay in payments of fees to legal practitioners is an issue that I'm seized with on a day-to-day basis. In other instances, I'm required to make interventions in that space so that there should be compliancy with the Treasury practice note of payment within 30 days. However, there are those matters which in fact impact on the decision to make payment as speedily as possible. We are seeing in many instances, and this in fact is something that is pervasive, issues of overcharging or overreaching, which creates a dispute. And this is in fact something that has been taking place for the longest of time. In practice, a day fee is limited to 10 hours. Now, I've limited the DFIs to offices of state attorney who previously had 3 million mandate on each and every matter in relation to fees to 500,000 rand. And what I'm seeing on the invoices that are being sent to me is clear overreaching in certain instances. And this is not to say all legal practitioners are in fact steeped in that practice. I'm seeing overreaching to the extent where other legal providers are charging the state more than 15 hours per day, 16 hours per day, 48 hours per day. And you might ask yourself, how is this happening? It happens when one legal practitioner has been briefed by a number of government departments. And when matters, in fact, are then referred to me, I realize that the same legal practitioner would have built a state department somewhere in Limpopo, sometimes Parliament. On the same day, they are charging day fees. Now, those are issues that ordinarily create the backlog because we need to resolve these issues. It has been happening before, but there is a point where we say it needs to start. There are also other issues in relation to this particular issue, where certain practitioners had an arrangement with offices of state attorneys to expedite their own invoices. So, for example, a practitioner would actually render an invoice today, and tomorrow that invoice is actually being processed to the exclusion of all other invoices that are on the pipeline. Having done a study in that space, and there could be another issue in relation to that aspect that I spoke to, issue of benefication. You expedite my invoices and therefore I'll be able to gratify you. That actually ought to come to a stop. And this is a practice that in fact we have adopted. In other instances, there is clear malice against legal practitioners where their own invoices will be held back for other unexplained reasons. I've issued a directive to take consequent management against any person that in fact unduly withholds an invoice that ordinarily ought to be paid. There are quite a number of matters that fall within that category. And there are also countless matters where I've actually resolved. In this financial year alone, up to now, I think I might have actually intervened in no less than 600 of such matters. That's a big number. But I need to capacitate this space with consequent management. That is perhaps an explanation that might not holistically deal with the issue. In the fourth category, legal practitioners are engaged, but they are not compliant with CSD, number one. Number two, they are also not compliant with, they are not in good standing insofar as tax is concerned. Now, I'm minded that I need to follow Treasury prescripts in relation to payment. And that in itself delays the process. There have been quite a number of other legal practitioners that have actually agreed with SARS that so much of whatever is due and payable to them could be redirected to Treasury, to SARS, in order for them to have a clean status in relation to those matters. So that is the other category. We don't have prescripts that enables the Office of the Solicitor General to remit any money due and payable to a service provider directly to SARS, except where there is an agreement between that service provider and SARS that such portion of money that is owing to SARS should be paid. So if you are not...
If you can wrap up, SG, I'm worried that the chair will then say you also took my time to wrap up. We have CFO as well.
Yeah, I was on my first minute, but I will actually try to wrap up. I was actually just outlining the categories. If perhaps the chairperson permits, I could answer some of these questions in writing. Now, in relation to the fee guidelines, chairperson, the fee, the import...
SG, I was saying that is not true. You are not in your first minute. You started at 12:58 is 6 minutes, and it's not acceptable that you can just do that to the committee.
Oh, no, I'm sorry, Chairperson. I'm not actually focused there. If I can be given 1 minute to wrap up the remaining issues. With your permission, Chairperson. The fee guideline, Chairperson, the import thereof was to standardize amounts that are paid to legal practitioners across all offices of state attorney. I actually found out that you could do similar services to the same department as a legal practitioner in Johannesburg and be paid X amount. And you go to Pretoria, you are paid another amount. You go to Toronto, you are paid. That, in fact, also needed to be streamlined. So the fee parameters does not take anything from the legal practitioners. If you would actually know, there is the rules board that, in fact, year in, year out, will set parameters. But in our space, I've seen inconsistencies in relation to what is payable to legal practitioners. I do have quite a lot to say on this issue, and I want, through your permission, Chairperson, maybe to be given an opportunity to submit written submissions on the 3 issues that you have raised, including the issue of how many briefs can one get in a particular time, because we were operating in terms of standard operating procedures with the approval of the briefing and outsourcing of state legal work, the duty to ensure that there is equity and transformation in this space vests on the Office of the Solicitor General. And before then, we were using standard operating procedures. And because of over-briefing and certain legal practitioners that have been camping on certain departments, exclusively doing that work, it actually became a problem. So with your leave, I'll ask perhaps to be given a date to submit written submissions in relation to this.
SJ?
Chairperson?
Please, you have exhausted your time and we gave you extra time. You took advantage of that. Please, please don't do that.
All right, thank you, Chairperson.
Instead of 2 minutes, you take 8 minutes. And even when I tried to stop you, I got an impression that you deliberately did not want to hear me. You were more focused.
I apologize, Chairperson, to speak over you. Can I do written submissions to yourself?
We will attend to that. I do have a proposal on that issue.
Okay, all right, thank you.
JJ? To do justice to the others that have suffered serious injustice caused by the SG, we will let's finish at 20 past.
Okay, thank you very much, Chair. We are considerate. CFO, if you could just quickly deal with the issue around the supply chain and the non-compliance that was raised. The one raised by Honorable Swart on CARA funding, indeed, the 3.2 billion that we currently have from the discussion we're having from the JCPS cluster and trying to fight illicit mining, a big portion of it, we were likely going to have a meeting today and the ministers will meet later in the afternoon to finalize the proposals. It rotates around capacity to law enforcement agencies to fight this scourge of illegal mining activities that have wreaked havoc in different communities. So the small portion part of it we are looking at how it can be distributed between the NPA and the department, but really a small portion part of it. A bigger part of it, we discover that the law enforcement agencies, the primary ones, have challenges of capabilities, and the proposal was to look at really focusing on funding those. CFO.
Thank you, Chairperson, and thank you, honorable members, for the inputs that we have received. And we commit to continue working with the committee to improve our internal control environment, and the qualification will be maintained. On the issue of supply chain, the supply chain has improved. As you will have noticed, there's no finding on contract management, asset management, and actually there's no material finding. The finding that remains there is the procurement of state legal services. It is just that it's categorized as supply chain, because the issue was about how we brief the councils. So it's not a big area of supply chain. And then the issue raised by Honorable Swart, the 1.8 million that is reflected there on the e-payment is the amount that we are unable to collect for the longest time, and we are making a provision for it as uncollectible. But the actual amount that is outstanding is currently sitting at around 3.8 billion. And the most of the provinces that are behind are Mpumalanga, Eastern Cape, and Limpopo. So we are continuing to work, as I've indicated, with all those that are concerned. So yeah, in terms of the funds, Honorable Jale asked if it's a problem of system. For the longest time, the funds was just using an admin system. So admin system just records all the application that has been received. We didn't have a financial system. So the payment was done in a separate system, and the administration of the beneficiaries were done in a separate system. That's why we have taken a decision to procure a enterprise system that will combine the administration of the beneficiaries and the payment of beneficiaries. There are user problems as well. That's why now we are starting, when we are disciplining people then start to see that we are serious, where we have to strengthen our policies around user management, and also the consequence management that we implement on time. So that are the root causes that we have identified. Thank you.
Two critical ones that are left: the digitization project in the masters and the trust files that cannot be accessed. If the Chief Master, you can briefly speak about that and what we are doing. The challenge emanated from moving the files from Metrofile to Veritas, but there's an intervention that the Chief Master is working on to alleviate that problem. And I'll ask DDG Kale to just speak on the grey listing question as well briefly. Chief Master.
Thank you, DG. Good afternoon, Chairperson and honorable members. I'm the acting Chief Master, DG. With regards to the Veritas issue, in respect of the offsite storage of the files, from the masters, we have been experiencing challenges in terms of accessing our files. And tomorrow, the 12th of October, there is a meeting scheduled with some of the team members from Justice to meet with Veritas, so that we can actually have, in terms of the SLA that we have with Veritas, how we can access those files, because now we are also facing litigation in our space regarding that, because it's negatively also impacting on the services that we are providing. So we are hoping that we can make leeway of that after we have met with Veritas. Thank you, DG.
Thank you very much. DDG Kale, can you deal with the issue around the grey listing and what we're doing as a department?
Yes, thank you, DG, and good afternoon to the chairperson and honorable members. Yes, the grey listing found several deficiencies in the anti-money laundering and terror financing elements of our legal system and our implementation of the laws to be in compliance with the Financial Action Task Force requirements. But to speak specifically to what the department is required to do, there needs to be a significant and sustained increase in outgoing mutual legal assistance matters. And we needed to put in place a system to record beneficial ownership insofar as the trust is concerned. Mr. Munyai has already spoken to the system to record mutual legal assistance and to show adequate follow-up in the matters. We are developing or have near completion for the development of a system to record the mutual legal assistance both incoming and outgoing to assist us. However, that is not a central point to remove us from the grey list, as what is required to be shown is the number of outgoing mutual legal assistance requests to other countries in line with our risk profile, insofar as showing that action is being taken to raise these mutual legal assistance matters so that we can prosecute them in our country. So that's insofar as mutual legal assistance is concerned. On the trust, the General Laws Amendment Act was passed by Parliament last year, which amended the Trust Property Control Act. We have since implemented that piece of legislation insofar as putting in place regulations as from the 1st of April. We are still in the process of finalizing a more permanent system for the registration of beneficial ownership. However, we did put in place a temporary system as of the 1st of April, and we are now migrating to a more permanent system for the registration of beneficial ownership. The other elements on grey listing relate to sustained increase on prosecutions and confiscation of assets, etc., which fall within the domain of the NPA. Thank you, DG. I trust I've answered that question.
Thank you very much, Kwakale. I'll ask Ms. Mamecha to come after me and deal with the learnership and the internship question that was raised. But on the 100 days challenge, I'm advised by Mr. Isaacs here that there are issues relating to donors and NGOs coming to the court space. So there's a process that is working on that we must first discuss at senior management so that we see how the department is broadly part of that initiative. Ms. Mamecha, I thought you didn't answer that question on the difference between learnership and the internship and how we are handling it. In the meantime, also just to suffice that we have gone out to engage Anglo, and Anglo has agreed to fund the department to improve our strategic management capabilities. So working with the National School of Government and the Justice College, we'll be taking the entire senior management of the department through training programs that will also include other institutions like your GIBS, WBS, but funded by Anglo. And we're looking at other funders as well. They have the best supply chain or procurement process, which as well they've agreed that they will subject the senior managers of the department into, exposing them into that system and hoping that we can implement it in the department. And when that program is completed, really we expect to see that our skills and strategic capabilities will be much more improved in areas of, project management, systems thinking, and so on and so forth, which are very much required for us to continue to coordinate the work of this machinery. DG Mamecha?
No, thank you, DG. My apologies for having omitted the question. And I think I've also omitted the question that was relating to the concern on the assessment of employees at level 1 to 12. So let me start with that one first before I come to the learnership and internship. For the assessment of level 1 to 12 for 2022-2023, that will be, it's actually due to be finalized by the 13th of October, and that will also include their payment. So the issue of the learnership, we are having a learnership program where we are working with the sitters, and through the sitters, then we get the learnerships to be paid through the sitter stipend. But also within the department, we do advertise on our own an internship program. Where we are paying them from our own through our budget, and the 40% that we are talking about that have been absorbed. And by the way, let me just explain what we mean by absorption. We don't necessarily mean that once you have completed your internship program and then you will automatically just be part of the permanent staff. We do advertise internally and externally and advise the interns to apply for those positions, as we are mentoring them, coaching them, and grooming them, and they then get into the department as permanent employees through the recruitment and selection policy of the department. No, thanks, DG, and thanks, Chairperson.
Thank you very much, colleagues. All what I can say, Chair, is that I think we continue to say in the Lendlela, but we can see the beachhead. And as we have promised, we are now in the Champions League, from surviving relegation in a space of 2 years into challenging for championship. Thank you very much.
Thank you very much to the department led by the DG. Thank you for the presentations and thank you for the responses. Clearly, we are quite pleased as the committee. Honorable Janji wanted to make follow-ups just before we close. Honorable Janji, can you be brief, please?
Yes, Chair. No, I'll be quick, Chair. Just to say maybe on the advert and the SG matter, the DG made a disclaimer before that this is a matter dealt by the minister or DM. So I would still want to take that issue up in whatever form. So I want to get into that in that way. Secondly, Ms. Manager didn't answer my question, and perhaps it's important that because I think he is referring to something else. I made a point that in your report, 78% of assessment was completed in terms of level 1 to 12. That's in the past. That's what happened. The question was, what happened to the 22%? Why such a low assessment rate, which is 78%? It's not supposed to be that level. She's not answered that question. She's telling me about what is going to happen in future. So I don't at this stage need an answer for that. Quite clearly, it's we can follow it up differently. Thank you, Chair.
Thank you very much. Maybe it's an important question. DDG Manager, can you directly answer that in less than 2 minutes?
No, thank you, Chairperson. Chairperson, may I please request that I respond to it later, because I need to just go back and confirm the notes on that.
Okay. No, thank you very much. As I was saying that, I mean, we can see there is a reason to believe that you can only improve and be much better. I think good steps have been taken. The robustness of the questions does not in any way mean that we don't see the progress that has been made. We do notice it and we are pleased about it. We also take note that this is our last engagement with us, and we are pleased that the last engagement with yourselves, we leave one another being positive about the future. Then we will be able to take some of the issues that were raised to be part of the legacy report, so that the new committee can follow up on some of those issues. there are issues that Honorable Janji wanted responses in writing. It would be good that if we get those things before the end of this month, all of those issues, the committee secretary will communicate with yourselves so that they find expression also in our committee report for legacy purposes. With respect to the issues raised to the Solicitor General, we know that he had a lot to say, but that is his side of the story. We have always taken a view as the portfolio committee that the issues relating to the profession and the briefing patterns are issues that need some form of an intervention. So we have also, towards the end of the term, we are going to call the Solicitor General and his office, that is the state attorneys and the organized profession, so that we don't only hear one side of responses, but the profession must also raise issues so that we can be able to have a fuller picture. Because, I mean, even if we go to myself and Honorable Breitenbach, when we go to the JSC, these issues are not only ventilated by the candidates, but also by judges, presidents, who are always complaining about the briefing patterns and how they are depriving previously disadvantaged, especially women, of a clear career path. So as Parliament, we have always been asked to do something about this issue. So we thought that before the term ends, we have to have a meeting where we'll also get the side of the profession and also get the side of the department through the Solicitor General and the Minister, and maybe we can see what role going forward should Parliament play. As we know that you cannot have a transformed judiciary without a transformed legal profession, and you cannot have a transformed legal professions if you don't deal with some of these issues that we have raised to yourselves today. So the committee secretary is working on a program, and that program will be sent to you in due course. Then you will have a lot of time to respond, SJ and the minister and the deputy minister and the DG. They will have a lot of time to respond on these issues, but we'd also get on our side the side of how the organized profession think about the office itself and how it is being serviced by government. Thank you very much, Mr. Sachela.
No, Chair, I am covered with your remarks. There was just one thing that I wanted to clarify, but taking from your closing remarks, I am covered. It's fine. So thank you, Chair.
Thank you very much. Now the time is 26 minutes past 1. We should I suggest that maybe we have a 30 minutes break so that people can eat, then we go straight to the NPA? Will that be in order? Or should we go to the NPA now?
We're happy to go now if it's possible, Chair.
Chair. Yes.
Honorable,
Chair.
Honorable Jailer?
Thank you very much. Yesterday we took a pause of 10 minutes in between, or then we called the last presenter. I'm not sure if maybe we'll follow that one so that we know that we are free and free forever for today. Thank you.
I think that would be a compromised way forward between the 30 minutes and now, if we can take a 10 minutes break and then we start with the NPA.
Noted, Chair.
Thank you very much. Let's continue. Are you ready, NTPP? So we will
Thank you,
also,
Chair.
so we will also give you 60 minutes.
6-0.
6-0, yes.
We will be much shorter with our presentation, but we'll try to be. Thank you very much, Honourable Chair. And certainly, hopefully, the next time the NPA will be first on the agenda. We are the ones that's generally waiting most of the time.
Yes.
So,
Last time, yes, we must make it up
get
to
crowded out.
Yes.
No, thank you very much, Honourable Chair, honourable members. Good afternoon. I'm joined this morning with members of my team, the 3 Deputy National Directors of Public Prosecutions, Advocate Rabaji Rasitaba, Advocate du Plessis, and Advocate de Kock are present with members of the team. I'd also like to greet the members of the media that may be present, as well as the public who may be tuned into this important briefing by the NPA in terms of high-level progress that we have made in the year 2022-2023 with regard to meeting our mandate. I should add, Honourable Chair, honourable members, that the annual report itself has been circulated and it is also on our website. Before I hand over to my team, I'd just like to provide a few high-level introductory remarks with regard to, so that we could contextualize the work that we have been doing thus far. Yeah, if we could get that to full screen, Marty. And if we could go to slide 2. Thank you very much. So the NPA is in its final years of the 2020-2025 strategic plan. But whilst we are doing this, we are also preparing for the next MTSF period. Over the last few years, it is sometimes easy to forget because of, bad news sells, I think. It's sometimes easy to forget the really important strides that we have made in terms of rebuilding the NPA during this period. The various initiatives that we've undertaken that has enabled us to really reach solid ground from a very, very shaky start. And to, in fact, move on to reaching for new heights during this past financial year. We have been on an upward performance trajectory for the last 3 years, 2021 onwards, from 50% in 2020-21 to 71% 2021-2022 to 75% in 2022-2023. This represents an almost 50% increase in our overall performance. And this, we're achieving this as we deal with approximately 650,000 matters every year countrywide, which hardworking prosecutors throughout the country continue to bring justice in all courts throughout the country. We are very confident, Honourable Chair and members, that we will make further progress and that we will be able to deliver for greater impact. To be sure, the path to get here has been extremely challenging, and we don't expect it to get easier. In fact, quite the opposite. But as we mentioned in our last briefing to the committee, we remain very confident that the strategy we've developed in the NPA has placed us on the right path and that we are seeing positive results with each passing year. We are taking lessons learned and we are using this solid platform that we have built to deliver on the final phase of our current strategy, focusing on delivering for even greater impact. But of course, there are certain things that would help us in this regard, and we will deal with that in this presentation. Slide 3, please. So building a sustainable organization has required the NPA to adopt key innovative strategic initiatives as part of our strategy. And key amongst this, firstly, has been restoring the NPA credibility. This has been critical for us. And so there have been several initiatives that have really focused on driving this important aim and improving our performance. We've set up the office, well, we almost very close to establishing the Office of Ethics and Accountability to ensure the integrity of NPA staff and to drive forward our commitment to our IPAC values: independence, professionalism, accountability, and credibility. We are waiting, the minister signed off on the regulations, and we are waiting for this to be gazetted. We have really worked very hard at strengthening NPA communications. We've had a new comms strategy that has really elevated the public profile of the NPA through credible, accurate, and explanatory public communications on key issues. For example, high-profile corruption matters, sexual and gender-based violence matters, matters emanating from the TRC, etc. We've worked very hard at promoting employee well-being in the NPA. We recognize human resources are one of our most important resources. And so we have developed innovative and, a very critical, important culture enhancement initiative, which is being implemented in a phased approach as we try to deal with the stress and trauma that some staff members suffer. And we find that these interventions are sadly in quite high demand, particularly for our court-based and certain officials in specific specialized areas. The Community Prosecutions Initiative is a really important initiative, working very closely with key partners, including the community. And we've established 25 sites across the country. Many of them actually focus on GBV, substance and drug abuse matters, and they also deal with issues relating to gender-based violence maintenance issues, etc. Slide 4. While we've been focusing on building a fit-for-purpose organization, and sometimes with the focus on the core issue, and importantly so, of high-profile corruption, one forgets about how much of work goes into building a fit-for-purpose organization, and also importantly, to future-proof it in order to mitigate against future instances of possible state capture. So this is a very, very important issue. And despite setbacks, in particular with regard to the Nulani and Gupta matters, which were very high profile, and I call them setbacks, we are still appealing the Nulani matter. The NPA has made significant progress in delivering overall on its mandate to deal with state capture and corruption. The ID has declared 99 investigations and enrolled 34 cases involving 205 accused persons. The SCCU, Specialized Commercial Crime Unit, and the DPPs working together with mainly the DPCI, also with the SIU, FIC, in the context of the Anti-Corruption Task Team and the new NPCOC, have enrolled 78 cases from the priority case list. So the focus has not only been on getting perpetrators to wear orange overalls, and believe me, that is a very important focus for us, but also on following the money and hitting criminals where it hurts most. In this regard, the AFU and its partners have secured freezing or preservation orders to the value of 14 billion, approximately, recoveries to the value of 5.4 billion, inclusive of the landmark ABB matter, and we have indeed paid back billions into the CARA account to assist in rebuilding the criminal justice system. So the narrative that the NPA is not doing anything about state capture is both wrong and dangerous. We are, in fact, one of the few prosecuting authorities across the world where we can say that we are prosecuting. Sorry, if colleagues can mute. that are prosecuting former ministers, the former Secretary General of a ruling party, a former president of our country, and also some of the most powerful CEOs and private sector actors in the country. These cannot by any measure be regarded as small fish, although we appreciate that too many architects of state capture remain unaccountable, and there is a lot of work that still needs to be done. The reality is that even though the wheels of justice turn slowly, and not just in this country, internationally, in South Africa, impunity no longer prevails. And those with dirty hands know that it's just a matter of time before that dreaded knock on the door will come. Even though 2023 has not been as impactful as 2022, where the wheels of justice were certainly turning faster in terms of enrollments, many cases, a number of critical arrests were made, it's important for the public to, and the committee, of course, no doubt understands that criminal prosecutions require patience, good preparation, and a certain measure of certainty. We're certainly grateful for the work of the Zondo Commission, which shone a light on the ravages of state capture, who was involved, the amounts it cost, damage caused, etc. However, we must remember that the Zondo Commission did not give the NPA a blueprint for successful prosecution of cases. Obtaining convictions in high-profile and complex corruption prosecutors is a different matter, with a highly onerous standard of proof beyond a reasonable doubt. Unfortunately, these two aspects are often conflated, and there are significant complexities in bringing these matters to court in order to meet the required standard. These matters are too important for our country. The NPA cannot and will not be rushed due to public or media pressure. This is when mistakes may happen, which the NPA cannot afford. Many of these cases are among the most difficult to prosecute, even by global standards. They often involve multiple accused, multiple jurisdictions, and complicated digital evidence that would test the limits of any prosecuting authority worldwide, not just ours. In fact, the Deputy National Director has just returned from the International Association of Prosecutors meeting that was held a couple of weeks back. And that is indeed the case. In line with our legal duty and prosecution policy, we will only, and I emphasize, only proceed when we are satisfied that there are reasonable prospects of a successful prosecution. Honorable Chair, honorable members, with those remarks by way of introduction, I would like to hand over now to the Chief Director of our Strategy Management, Ms. Salome Baloy, who will give us a more granular overview of the performance for the 2022-2023 period.
Thank you, NDPP. Good day to the Honorable Chairperson and Honorable members of the Portfolio Committee, as well as members on the platform. And I say all protocol observed. I will be just giving you a brief snapshot of performance overview of the NPA at high level, and much more details on this performance will be spoken to by my principals. So in terms of the performance of the NPA, we have achieved 12 indicators. In terms of the slide that is shown there, we were measuring 16 targets against our annual plan, and we have achieved 12 of those, which translates into 75% of our achievements, and we have not achieved 25% of those indicators. I would not necessarily want to go into the more granular details in terms of each and every achievement of these indicators, but safe to say that the Portfolio Committee has got the presentation and they would have seen these achievements, but I would want us to maybe focus on the non-achievement of these indicators in the next slide. And in terms of that 25% of indicators which we have not achieved, it relates to conviction rate in complex commercial crime. And we all know that complex commercial crime cases requires a multidisciplinary approach to investigate and successfully prosecute. And the NPA has narrowed its focus to more serious and complex commercial crime cases, finalizing 419 cases with a verdict which is 38 more than the previous year, and obtaining 364 convictions. However, despite this improvement in the number of verdicts and convictions, the conviction rate of 87.1% was 2.9% below the target of 90. And with the complex commercial crime, we know that various factors contribute to these non-achievements of targets, such as inter alia, failing memory, uncertainty in evidence, contradictions, and uncorroborated evidence. And the finalization of complex commercial crime cases takes longer to be finalized, since the cases often require expert witnesses and specialized investigations techniques. The next indicator relates to the number of cases finalized with a verdict involving money laundering. And as we all know that also, money laundering and terror financing are key concerns of investment partners and are renewed areas of focus for our country, especially in light of the findings of the FATF. During the period under review, NPA has finalized 89 cases with a verdict involving money laundering against the target of 100. The non-achievement of this is due to trials that are protected with several legal challenges and the usage of Stalingrad tactics by the defense. Value of completed forfeiture cases. Confiscation orders are obtained in terms of Chapter 5 of POCA on convictions of the accused, targeting the benefit derived from those crimes. Forfeiture orders are obtained in terms of Chapter 6 of POCA, following a preservation having been obtained. Forfeitures targets the proceeds and instrumentalities of crime. During the financial year, the AFU obtained 521 completed confiscations and forfeiture orders to the value of 495 million against the target of 550 million due to the delays in the finalization of trials in serious corruption and high-value cases. Value of freezing orders obtained for corruption or offenses related to corruption is another indicator which we have not achieved. And in the reporting period, freezing orders to the value of 570 were obtained, which is 76% below the target of 2.4 million. This was due to delays in the finalization flows in the investigations of high-value cases. And as we know that freezing orders are a preceding step to ultimate recoveries. However, there was a delay in obtaining freezing orders in the case of the ABB, which could have had a potential freezing order of 2.55 billion, which then impacted on us achieving this indicator. And however, notwithstanding this underachievement of the annual target of 2022-23, it is important to note that the AFU is close to achieving the 5-year target in the MTSF, which is the target of the MTSF for 5 years, which is 10.4 billion, and we are sitting at 10.2 billion against the target already, even though we have not achieved this in the current financial year. Can we go to the next slide? These are obviously reasons that I have also spoken about. Why is it that we have not achieved the indicators as just spoken to? And interventions in relation to these indicators that have not been achieved is that NPA will continue to prioritize and closely monitor these cases. They will train and capacitate our prosecutors to ensure that cases that deal with money laundering are ongoing, and will continue to collaborate with stakeholders in order to expedite the cases effectively and efficiently. And will also continue to ensure that we use the ADR, corporate ADR, in order for us to to finalize the cases that are related to asset forfeiture. And the next slide. And we need to be reminded as the committee that as NPA, we still continue to work towards our 3 high-level outcomes, which are increased feelings of safety and security for all South Africans, improved investor confidence in South Africa through high-impact prosecutions, and improved access to NPA services. And these committee members, in terms of our 3 high-level outcomes, we are just showing how is it that we have contributed in making sure that we are achieving these high 3-level outcomes. In respect of the first one is that we have been attaining high conviction rates in terms of your murder, sexual offenses, and trio crimes. And we have been good in successfully prosecuting these cases, which have got lengthy sentences. And in relation to the second one, we have been capacitating our complex commercial crime component, and obviously also there's a progress in relation to the permanency of the ID. And in relation to improve access to the NPA services, the NDPP also spoke about us having to increase the footprint of the TCCs, and we, on the maintenance services, court preparation officers, and DNA results coordination with the regional nodal points. And we have also enhanced our community prosecution initiatives. The next slide really, in terms of our performance, I would believe that there are infographics that are related to each and every sub-unit in the NPA, and I believe that these are a self-explanatory achievement in those infographics, and we could most probably, depending on the questions that would be raised by the committee, that we can also look into those infographics, but they are as detailed as it can be in relation to the overall performance of the NPA. And thank you all, and I can also hand over to Advocate de Kock, who can also at a high level speak to these infographics in relation to MPS.
Sorry, Honorable Chair, Advocate de Kock, I'm not sure if he is muted. He's not in the room where I am. Apologies for this, Honorable Chair, honorable members. Honorable Chair, honorable members, I think what we will do is, if we can move on the presentation to the AFU part, if we can move the slideshow up to AFU, and then we'll come back to the NPS part of it. Okay. Let's move on to the AFU. There you go. Advocate Rabaji Rasataba will deal with this. You got us. You'll tell us when she looks. Yeah.
Thank you very much, Chairperson and honorable members. Thank you for this opportunity. If we could go to slide 23, which shows the infographics of what the AFU has achieved. The point I want to make is that the 10 billion for the MTF cycle that we have achieved thus far, it's made up of the 7.1 billion from ID matters, investigative directorate matters on slide 13, and 320 million from specialized commercial crime cases. It was said earlier that the 14 billion freezing orders is from NPA and other partners. So it's from AFU and other partners. So the partners are NPA partners. So that's the only point I want to make on that slide. If we move on to the next slide, so this slide speaks to the work that's being done on corruption cases, particularly the ones that were ventilated at the Zondo Commission of Inquiry. So the slide shows the breakdown, and it shows the breakdown of the total amount of 72 billion and what the big chunks of those investigations are. I've explained what the breakdown is, and on slide 26, and I'll deal with it later, we then break that down in terms of the other state institutions that are dealing with these cases. So the point is, we know our landscape as it recovers, and we know what we have to look into as far as that is concerned. The case of Regiment's Capital, the 2.4 billion, you'll recall that we've got a restraint order as NPA, and is one of the cases that's highlighted in the annual report. The biggest amount, which is the locomotives, the 48 billion, it's the one that SIU and SARS have been dealing with. And there's been also some settlement discussions between Transnet as well as China South Rail and North Rail. So if we move to the next slide, we want to demonstrate that as NPA, we started with the recoveries even before the Zondo Commission was established. We did two big cases, which was the 1 billion that was paid back to ESCOM. And in that case, I just want to highlight that we first did a preservation order, and then we did a recovery, which was paid to the victim, which is what my colleague Salome Baloyi was explaining when she said that because of the ABB settlement, we couldn't make the recovery amount because we didn't have a preservation order before. And it took 2 years to finalize and settle that matter. Then the second amount of also over 1 billion, which was for mine rehabilitation funds, we did a preservation, we did a forfeiture, and then the money was paid back to the Department of Minerals and Energy. Now, post and during the Zondo Commission, we have recovered SNPA 14 billion, not recovered, frozen 14 billion, and then recovered 5.4 billion. What are the interventions? I've highlighted the interventions on the bottom of the slide in terms of AFU having a new recovery strategy, showing a couple of interventions. We focusing on chapter 6, which takes less time because it's not dependent on prosecution and conviction of the people who have benefited from crime. And then, of course, again, after 18 months, we now have got 2 companies that we've appointed overseas to help us with funds that have left the country. We also then have started doing the corporate alternative dispute resolution mechanisms, ABB, having been the first case in NPA, and we are in the process of dealing with other matters. Then we've got a multidisciplinary project called Professional Enablers Project, where we seek to recover funds from money launderers. And we've stated the name of all the law enforcement agencies that we're working with, and hopefully we can make it into the DOJ program on legislative amendments to enhance the work we are doing. The next slide, which is slide 26, I think it shows that over and above the 27 recommendations that were made on asset recovery, yes, by Zondo Commission, we're dealing with these cases with our partners, SARS and SIU, and we will continue, therefore, to do beyond this 27 recommendations as this chart indicates. I just want to thank you for the opportunity.
Honorable Chair, we're now handing over to Advocate de Kock, head of NPS, who will do the NPS performance overview. I think we need to speed up our presentation.
Good afternoon, Chairperson and honorable members of the committee. Thank you very much for the opportunity to address the committee regarding the performance of the prosecution services. Just to indicate that the prosecution services have achieved 80% of its indicators. So it actually reflects 8 out of 10 indicators, and the slides that have been presented to the committee captures the work of the prosecutors in our respective divisions. The work that's reflected in the information contained in the presentation is largely done by the directors of public prosecutions in the 10 divisions of the prosecuting authority in the country. Just to acknowledge the work of the prosecutors at the coalface of our courts in terms of what they've achieved. The first slide regarding the trends that have been set out is an indication of the impact of COVID and how the prosecution has improved since COVID, and the upward trajectory in terms of the finalization of cases. What is important to note about the slide is a correlation between the finalized cases as well as the new cases, and you can see that the finalized cases tracks the new cases that are referred from the police. You will note in the slide, in the year 2018-2019, there seems to be a decrease in the number of cases referred to the courts. And on our analysis of that information, it was largely as a result of the Constitutional Court judgment in relation to the possession of cannabis for private use. So since then, the COVID impacted on us during the year 2020, and the members will recall, as at March 2020, we went into a lockdown, and now we can see the impact of that lockdown up until the end of 21, and then a beginning of a performance, a turnaround in terms of the performance of the courts. Can we move to the slide dealing with specialized commercial crimes? I think that this has been covered, but just to note in terms of the priority crimes, largely in terms of corruption, those cases referred to on the ACTT list, we note that there are 363 accused persons currently before the courts, involving 79 cases. And 21 of these cases are enrolled in the high courts. I think this demonstrates the commitment. It's also an indication of the way in which the prosecution has collaborated with the DPCI as well as the SAPs generally, and then, of course, the ID. So this work and this slide must be read in conjunction with the slide of the ID, or the slides of the ID, to indicate the manner in which progress is being made by law enforcement generally in terms of dealing with priority corruption cases on our court rolls. The second part of the slide deals with the Fusion Center, which was also an initiative of the law enforcement agencies to address corruption during the COVID period, and the PPEs in particular. And the committee will recognize that the information provided in terms of cases in court, convictions 45, accused persons 186, and accused sentence 58. So that's a demonstration of the commitment of all law enforcement agencies and the prosecution to address corruption in the country. If we can move to the next slide, please. As far as murder and trio crimes, serious violent crime in that category, we highlight the question of the conviction rate of 80% that is being achieved. This is an increase of 2.4% on the previous year's performance, and a total of 3,738 cases was finalized with the verdict. We also note an upward trend in terms of the trio crime conviction rates that speaks to serious violent robberies of 82.7%. If we can move to the next slide. As far as gender-based violence and femicide is concerned, this remains a serious priority for the country as a whole, and the part of law enforcement and the prosecution in addressing crimes committed in this space. The response of the MPA was to increase the Tutuzela centers. We now have 62 Tutuzela centers as at the end of the financial year. We have accused sentenced for sexual offences during the period of 1,195. Life imprisonment, which is very significant, 257. And yesterday the committee did receive information regarding the situation of the prisons. But of course, the MPA focuses on the serious cases, and we also focus on obtaining life imprisonment. So that's a significant amount of persons that's been sentenced to life. And then, of course, we indicate the number of years in the different categories as well. And as you can see, long terms of imprisonment is being granted by the courts. As far as organized crime is concerned, we're also maintaining a high conviction rate. It is one of the areas in terms of our FATF obligations that we are focusing on very strongly to ensure that we address some of the questions around how we deal with money laundering in the country. And organized crime is an important area that will make a contribution. We are just coming out of a strategic planning session with the police and the DPCI to strengthen our collaboration in terms of addressing organized crime in the country. And we are also putting strategies in place to deal with the question of money laundering and dealing with syndicates, dealing with networks, dealing with third-party enablers in terms of addressing money laundering. Some of the strategies that my colleague, Advocate Rabaji, referenced earlier in terms of the Enablers Project also speaks to addressing this question of the illicit flow of funds, particularly out of the country. And this work, the synergy of this work is being collaborated through all law enforcement agencies. So this is the response in terms of how we need to address the FATF obligations and the grey listing questions that have been raised earlier. As far as the TRC is concerned, We again thank the DPPs and the colleagues at our national office for the hard work that has been done over the last year to improve our performance in TRC matters. I think that we are now seeing cases being brought to court, inquests being heard, evidence being led under very difficult circumstances in terms of finalizing the investigation. But the models that we have put in place in terms of coordination, collaboration, accountability to the victims and to the families, and sharing of information is starting to bear fruit. And so we are proud of the progress that we are making in addressing the outstanding TRC cases, and we provide a commitment from the prosecution that we will continue to do this work until all of the cases have been finalized by the prosecution. The slide just gives a summary of the matters and the progress. So some of the other areas in terms of our tax component, there's an indication of the number of tax cases finalized. The conviction rate remains very high, and we work closely with the South African Revenue Services and the Commissioner of SARS. Just as we speak, the colleagues are in a 3-day working session with the SARS to improve the manner in which we investigate and prioritize the SARS cases so that more money can be recovered for the fiscus. The Priority Crimes Litigation Unit continues its work. We are looking at strengthening the work of the PCLU by appointing dedicated prosecutors in our regions, particularly also to address some of the outstanding issues flowing from the FATF grey listing to deal with terror financing. So that work is in progress, and some good progress is being made there. And then as far as the MLAs are concerned, which our colleague Advocate Pillay of the Department of Justice referenced earlier, there's an indication of the number of new extradition requests that have been dealt with, and the total number of incoming formal requests received from foreign states was 61. So in the area of MLA extradition, a lot of good work is also being done in collaboration with the central authority. So that brings me to the conclusion of my brief report on the work of the prosecution. But just to say, Chairperson, that we continue to ensure that the prosecutors are well led. We've got a number of directors of public prosecutions, prosecutors who have been appointed over the last 2 years. And we are satisfied as the head office of the NPA that our divisions are well led and that the strategies of the organization are being implemented. So thank you for that opportunity, NDPP. Thank you.
Thank you, Advocate de Kock. Honorable Chair, honorable members, Advocate Johnson, I apologize, but she was here from very early this morning, but she had to leave because of a private medical emergency. So I'm going to ask Advocate du Plessis to do the ID performance overview, and then he will go straight into the strategy, operations, and compliance performance overview as well.
We wish her a speedy recovery. Please.
Thank you, Honorable Chair, honorable members. It's actually a family member and she had to rush off, but I will certainly convey your sentiments. Thank you.
You are left with 20 minutes.
Thank you very much, Lydia. Thank you very much, Chairperson. We will be less than 20 minutes because we only have the this and then a concluding section. I think the NDPP has already touched on some of these figures, so I won't go through them in detail. But I do think this speaks to a crucial point that was made at the beginning of the presentation, and that's that this narrative that's somehow become a self-fulfilling and in our view, quite a disingenuous one. That narrative being that the NPA hasn't moved on state capture. I think these figures show that is not correct. As Advocate de Kock said, even in the context of the 370 odd matters that have been brought by the SCCU, if you look at these figures, and we're speaking here about 34 very high profile matters that have been enrolled by the ID. We're looking at over 200 accused, I think 206 accused now. We're looking at restraining orders over the last 2 years of 7.1, almost 7.2 billion rand. Of that, about 3.2 has been paid back into CARA. And if you look at the actual recommendations that come from the Zonda report, the next slide, Marty, you'll see that many of these recommendations actually have been taken on by the ID. So I won't go into all the details, but I think you can see them there. What is very important in the context of the ID, and obviously I speak on behalf of Advocate Johnson in this regard, is that the ID theoretically has been working on these matters since it was proclaimed. But of course, the Zonda Commission recommendations or final reports were only released in June last year. And by global standards, what we're seeing is that these kinds of cases take between 6 to 8 years to be finalized. So I think for us to be in a situation where essentially a year and a bit after the Zonda recommendations came out, for us to have had these numbers, I'm sorry, the slides are not now coinciding with this, but to have these numbers already being produced by the ID is hugely significant. And I think both for the committee, but also for the public, it's to recognize this progress in an incredibly complex and challenging environment. And of course, we recognize as much as everyone else does that this isn't sufficient progress. More progress has to be made. But I think it is very important for the NPA, just to reiterate the point, that although Zonda provided an in-depth analysis of what happened, it didn't provide a blueprint for prosecution, as some have mentioned. So I think those statistics speak for themselves. Perhaps at a higher, more strategic level, of course, the NDPP's touched on this. The question of the new ID bill becomes fundamentally important, because we do know that one of the challenges in dealing with these levels of complex corruption matters is the question of the prosecution-led investigation model, which we know has worked in South Africa before, which is the fundamental premise on which the new ID bill or the NPA Amendment Act is based. And we do believe that that is going to be, if you like, the game changer that's required, not for all corruption cases, but certainly for the ones that fall within the ID's mandate, which, as you know, is not just about Zonda, but also about 2 other commissions of inquiry. But they do relate to the most complex, most sophisticated forms of corruption. And that model becomes absolutely essential to succeed. The other issue is the question of permanence. We know that the ID has struggled to recruit and retain the level of staff that it needs. That's obvious, I think, in an environment where there's an uncertainty about the future. We're hoping that the new bill will deal with those issues, and that we'll have an entity within the NPA that really will be up to the task. And of course, we know there's a broader architecture that's unfolding as we speak. We know that NACAC will be making recommendations around this, but we're very confident that as the only constitutionally mandated organization in the country to be able to prosecute criminal matters, that the NPA will fit into that new architecture in a highly effective way. And I think the IDAC, as it's now will be called, is a really important step towards achieving that broader objective. So we can have a discussion on that, but I think I'll leave it at that and then move to the what is then the final section before we conclude. And I'm just making sure the slides keep up because there's a bit of a lag. And that's enhancing NPA strategy and operations. And that's my role as a deputy, as head of strategy and operations and compliance for the organization. I think, yeah, Chair, just to make a couple of points, and I think it's a segue from the ID, but while the spotlight for the NPA has certainly been on how we've responded to state capture corruption matters, and I think in local parlance, it's whether or not how many people are in orange overalls. I think it's important, as the NDPP pointed out, that the NPA is an organization that deals with over 650,000 matters a year in one of the most violent countries in the world. And it was also an organization that, as we know, was ravaged by state capture. So one of the things we've had to do is systematically rebuild the organization from the inside out to make sure that after years of neglect, and it wasn't only neglect, it was also in some cases malicious destruction to the organization, that the NPA has a solid platform underneath it. So you see all the statistics of the prosecutions and what we do in terms of our core mandate. But we need a solid platform underneath that to be able to ensure sustainability and professionalism of the organization. And we're very proud, although these things don't get into the media, they're not often discussed, but we've had to rebuild an organization, and I have many colleagues sitting around this table that are part of that, that is a professional, well-run organization with effective operations, effective policies, procedures, and of course, administration. And we can say, I think, with some level of certainty that we are very much at the forefront of innovation when it comes to a number of, if you like, operational and strategic components. And I'll just mention some of them. They are listed on the screen there, but what this has led to over the last few years is firstly a very important reversal in the qualified audit that we had for multiple years on contingent liabilities. Last year, we saw the first unqualified audit on this hugely complicated but very important aspect of the NPA's work. We're also very pleased, as the DOJ presented earlier, to have an unqualified audit on finance. We recognize that there are some issues that have been raised around our performance information, but we've put in place a dedicated team to make sure that we address those issues moving forward and that we engage with the Auditor General to make sure that those performance findings, particularly on information verification, is not repeated. The other thing we've done is reviewed all the policies within the organization. Now, for an organization that's 25 years old, that was no mean feat. We've simplified them, we've clarified them, and we've made them more user-friendly. So anyone who comes into the organization moving forward comes in with policy certainty and clarity, which I think is hugely significant in an organization our size. We've obviously worked with all the all the different units on the development of their strategies and the alignment of those strategies to the organizational strategy, which we're now going into the final year of implementation. Of course, as we move into the next MTSF period, having strategically aligned business units and core business components of the NPA allow for an organization that is strategically coherent and allows us to deliver on those high-level outcomes that Ms. Baloy spoke about earlier. And then the last thing that this committee's heard a lot about is we spearheaded the development, sorry, the slides there's a bit of a delay. We spearheaded the development of the Office of Ethics and Accountability, which has been signed and will be gazetted soon. And this is really a leading innovation in terms of organizational focus on ethics and accountability from the lowest levels all the way through to the top leadership of the organization, which I think is important. Next slide. The NDPP spoke about communication. As an organization, we communicate a lot more than many other prosecution authorities in the world. We know it's important. We know how important the rule of law is to our country, and we know how important the NPA's role is. But we feel like communication is starting to shift the narrative. And internally, we focus on significant staff wellness and capacity building initiatives. And I've already mentioned to this committee, the Capacity Review Committee initiative that is really going to help us get a fit-for-purpose organization. You'll see from the annual report that our EE profile has significantly improved over the last few years, with 54.5% of all staff being female. And very importantly for us, 65% of these women are in key senior management positions, which particularly in a profession which I think was traditionally quite male-dominated is quite an achievement, and we're very proud of that in 2023. I think on recruitment, there are issues, of course, moving forward with the budget cuts and the fiscal environment, but we have recruited a number of new employees. You've seen there the number of 657, and 52% of these are prosecutors. So you've seen now, and you'll see it in the annual report, our establishment has grown quite significantly since our budget was increased a few years ago. We've dealt with a number of misconduct and disciplinary hearings quite effectively, and of course there are a number of well-publicized ones that are still continuing and unfolding as we speak. And then very importantly, something that's not very well known about the NPA is that we also manage the witness protection program, and you've seen our performance there is 100% with no witnesses being harmed or killed on our program. And of course, it's not just our witnesses that need to be protected, it's also our prosecutors. And you'll be amazed at the level of threats and the number of threats against prosecutors, which we see ramping up in the coming years as the nature of the cases we take on become more serious, and particularly in the context of organized crime. Perhaps I'll conclude this and then hand over to the NDPP by saying that despite all these efforts that we've made in the context of our operational effectiveness, I hope that this committee remains committed, if you like, to its stated legacy aim of ensuring the enhanced NPA operational independence, which remains constrained, I think, by the historical structural issues being with us being administered within the Department of Justice. So this is a discussion that needs to happen. Just the last slide, sorry, on the budget, which I just need to go through. It will be very, very brief. I think the numbers speak for themselves. We're again appreciative of the budget increase we got in last year. In the last year, we're of course concerned about any cuts. You'll see that the NPA does not underspend. We in fact spent 101% of our budget and had to environment a small percentage over from the Department of Justice, which is why you see that 101%. But we are very strategic and very clear on our planning around our budgeting, which also doesn't allow for us actually to absorb budget cuts, because there's no fat built into our budgets, as you can see, particularly when it comes to the compensation of employees. And the DG referred earlier to the question of having to absorb those cost of living increases. So we are sitting at the moment with an under budgeting on compensation of employees, which has huge implications, but we're engaging with the DG and the CFO of Justice to be able to deal with that issue. But I think I'll leave it at that, and then I'll hand over to the NDPP to give the final wrap up. Thank you.
Thank you to colleagues that have done the presentations. Honorable Chair, honorable members, in conclusion, let me say, as you've noted from the presentation, that the NPA has indeed made significant progress in stabilizing the organization and laying a solid foundation for the prosecution of very complex cases, including state capture, money laundering, gender-based violence, etc. We are in the final stages of developing, as you heard from Advocate Kok, an organized crime strategy, also strategies to deal with FATF. These are hugely important for the country. You would have noted, Honorable Chair, honorable members, we are tackling high-level corruption matters, but as Advocate Kok said, Advocate du Plessis, there's certainly a lot more that needs to be done, and we are hoping that with the IDAC, which is hugely important, that we will be able to really ramp up the work of the NPA insofar as the issue of dealing with very, very serious and high-profile corruption is concerned. It is indeed the most important next step towards dealing with corruption in South Africa. In line with Section 179 of the Constitution, it will be a key prosecutorial element. And we certainly hope that the bill will go through Parliament swiftly, so that ID investigators could have the powers that they require. But whilst this is happening, we also require that ID investigators be declared as peace officers. The minister has signed the government notice, which enables them to, in fact, be declared as peace officers. This was done in December 2022, but for various reasons, not a single ID investigator yet has these powers. But there has been an amendment that's been made recently, and we hope that this will be gazetted very quickly, so that whilst the bill is going through Parliament, these peace officer powers certainly will be conferred on ID investigators. I want to say, Honorable Chair, honorable members, is that it's really important that that this bill, we hope, will be, as I said, a swift process, and that all will be acting in the best interests of what South Africa needs right now. Whilst the NACAC does its work and we can decide on what the final architecture will look like, it is critical that the ID is empowered to be able to have the powers and also be able to recruit the skills that it needs. You would have heard about the new asset forfeiture strategy, so I'm not going to say anything more about that. The last slide, if you can move on to that. Honorable Chair, honorable members, for the NPA to succeed, it needs to be able to keep the momentum going, to strengthen and consolidate the achievements that we have made thus far. It's really important, therefore, that the NPA is not subjected to any budget cuts, which will seriously undermine the gains that we have made thus far. During the current financial year, we are prioritizing the following. One is a prosecution prioritization policy and practice for obvious reasons. The Community Prosecutions Initiative, we're looking at service delivery improvement initiatives, and we're also prioritizing amplifying the NPA's voice and strategic influence on the broader JCPS, focusing, of course, on priority matters and focusing on building towards a future that addresses new crime threats and organized crime. In preparation to deliver the expected impact required of the NPA, we are thinking more carefully about the high-level outcomes for the next medium-term strategic framework period to ensure that these outcomes are more closely linked to the work of the NPA. We've already started internal discussions, and we will soon be engaging with our partners in the criminal justice family to ensure that we are able to deliver for greater impact. Finally, Honorable Chair, Honorable Members, while the NPA has an important role to play, we cannot prosecute our way out of the crime crisis in this country. We cannot win the fight against crime and corruption in particular on its own. We need a societal response and a strong collaboration with our law enforcement agencies, which we are certainly prioritizing for greater impact. But the people of South Africa may rest assured that the NPA is doing everything that it can to, in fact, make an impact. I thank you, Honorable Chair, Honorable Members, and we stand ready to take any questions. Thank you.
Thank you very much, NDPP. Right on time. In fact, you have saved a few seconds. Thank you very much for that. Members, any questions or comments? I have Honorable Horn. Honorable Horn, proceed.
Yeah, thank you, Chair. Good afternoon again, and good afternoon to the NDPP and the team. And thank you for the presentation. Chair, and maybe at the outset, one must say that also in response to, I want to say, the plea from those who presented that, this committee must be believers as far as it goes to the NPA, and secondly, this committee must, in the past, as far as it's within our ability, assist regarding the fight for a sufficient budgetary provision and to be more precise, for the NPA not to be subjected to budget cuts. And in both cases, of course, I would think all of us as members would want to stand with the NPA in this regard. Maybe just before I go on to specific issues, also to say that from our side, we must say to the NPA that, of course, the perception out there amongst the public, to which the NPA is very sensitive, that not much progress has been made with high-level prosecutions of corruption and state capture-related matters, is, of course, primarily informed by the issues around the Guptas and of late the Nolani matter, to which the NDPP has referred as temporary setbacks. So maybe as a first question, we must ask why, in respect of the Nolani matter, the NDPP is of the view that an appeal is still possible, or it's, I think, now a petition to the SCA, and what will be different in the SCA than when the High Court dealt with the matter. And maybe in addition to that, and at the risk of sounding negative, to what extent consequence management will be implemented in the case that ultimately all doors are closed on the Nolani matter, given the fact that, as we understand it, this matter ultimately was decided basically on due to a lack of proper forensic investigation and evidence being in place. So then, Chair, while I am on the the forensic matters, digital data forensic services, forensic auditors, and DNA matters. All of those were issues which, in terms of the plan of the NPA, would have been dealt with through the additional budgetary allocation that was afforded to the NPA. So it would be good to hear what specific achievements have been put in place or what specific achievements was put in place on the back of that additional budgetary allowance. Linked to that, it was planned that at the end of June this year, 50 external counsel was to be contracted to assist with state capture and corruption-related cases. So is that in place? And have that been achieved? In respect of both firstly, the Gupta matter, I don't know whether there is updated information around any positive movement on the extradition case. And then similarly, we've noted that the minister has recently indicated that the Malawian authorities, with much more our friends, if not at least partners, in respect of the extradition matter of Shepherd Bushiri, but yet also despite the fact that a long time has now passed, there seems to be no news forthcoming in that regard. On DNA related matters, Chair, we have a question about the backlog cases firstly, and then there was a report that they've been fast-tracked to the forensic laboratory. But it remains a bit of a concern that when the minister was asked, and obviously the NPA would be the ones to answer on his behalf, how many of those cases ultimately were resolved through a verdict, that answer remains outstanding. And the use specifically of the word resolved in respect of these matters creates a perception that quite possibly a large number of these cases ultimately were withdrawn. So I don't know whether the NPA is in a position to give us that specific information. If not today, then please as soon as possible. If I move on to donor funding, a lot was done, and also I think through the majority of this committee at least, to put some pressure on to ensure that the framework to deal with donor funding for the NPA would be put in place, and we were informed that it was ultimately put in place. So it would be good to hear what is the types of donor funding that has been secured and how that has been spent, and closely linked to that, Chair, whether it was not possible to look to donor funding to prevent the shutdown of the aspirant prosecutors program, which is I would believe a big worry to the whole of this of the committee. Then, Chair, in respect of conviction rates, as in the past, we must repeat our point of view that conviction rates, and specifically the information supplied around conviction rates in the annual report, is as good as quickly opening up a curtain before drawing it as close as possible again. We have in the past requested, and there was an undertaking that in addition to conviction rates, the real numbers of cases would be supplied. I've noted today in the presentation that, for example, around murder, there was real figures, but ultimately, unfortunately, nothing yet in terms of to enable us to look at a trend in respect of the number of cases to be enrolled. We saw that specific graph supplied by Advocate de Kock, but yet we as a committee, and I don't know whether the NPA at the time followed those proceedings or were able to follow it, must also view that along with the submissions of Professor Munting of the Dullah Omar Institute, which says that if one drills down into figures, then ultimately it might talk to a prosecutorial policy, if not officially so, looking into enrolling the easier cases, and it doesn't give a complete picture as to what numbers and what percentage of the more complex cases are ultimately enrolled. So unfortunately, those, Chair, still leaves more questions than answers. And then the last question, Chair, at this specific point in the calendar last year, we were informed that on the issue of the 10 years plus dispute about occupation-specific dispensation, there was a directive given by the NDPP that this matter be resolved and settled more or less within the immediate future or the immediate period after the engagement with the committee. Can it be confirmed that this was in fact concluded? Thank you.
Honorable Swart.
Thank you, Chair, and thank you to the NDPP and your colleagues for the input and the presentation. And I do appreciate from our side that there has been progress made with state capture cases. Obviously, as conceded, far more can be done, but I think it's important to say there is progress, and if one looks at the figures, I think the dilemma that we as public representatives face is the perception amongst the public that crime is out of hand. And I think I've raised this before. If you look at the construction mafia, if you look at illegal mining, if you look at various other issues, and that must be overwhelming for the NPA. And I think we need to appreciate the work that is being done, but at the same time, for you to understand the pressure that we are under as public representatives, where there is a perception, maybe it's more perceived than real, but there is a real crime out there that needs to be addressed. It's not only at your door, obviously, it's also at the door of the police to relieve that issue. Chair, I had to leave the meeting earlier, so I didn't get the response on the issue by the DG relating to cost containment measures. But I would like to ask the NPA whether they are aware or have been involved in any discussions around cost containment measures that will impact upon them. And clearly, I hear very specifically that it is unaffordable, and we as a committee have in the past not supported any budget cuts, given the fact that it is bodies that the NPA needs to prosecute, people to prosecute all the matters. So I also then want to add to this the issue which I raised earlier about the CARA account. And we know that the NPA successfully recovered the 2.5 billion from ABB in that settlement, although there's still criminal prosecution continuing. And whether the NPA, given the fact that even if there are no budget cuts, there's still budget pressure, would the NPA be making a presentation to the minister to then make a presentation to CARA for additional funding to go to the Department of Justice and then to the NPA from the CARA account, given that it sits at 3.38 billion rand compared to 738 million last year, and that is attributable to the work done by the NPA. I also just wanted the NDPP to comment briefly on, I didn't quite follow that issue relating to the peace officer powers. And I understand fully the need for the investigators in the ID to have the specific powers, but I got the impression there was a gazette issued in December, but there have been delays. What is the issue there? Why are there still these delays pending the processing of the ID bill, which, as the NDPP indicated, is critical, that the ID is empowered. And I think that is a very important point for us to take note of. But I'd just like some clarity on that issue. I also appreciate the briefing on the SARS NPA cooperation. I think that is very, very important. SARS has a lot of powers internationally, that they can use powers internationally. And of course, they can also levy penalties when it comes not only to criminal prosecutions, but in recovery of funds. And we know that they can be very efficient, and maybe that is also a way of where it could be very difficult and complex to prosecute people, to rather rely on SARS to recover funds for the fiscus, because at the end of the day, the funds, that there's a challenge with finances. Chair, those are briefly some of the issues from my side, and I just want to emphasize again the issue of budget. I think it is important for us to understand that we appropriate the budget. It's Parliament. And it's a challenge for me because we always say, oh, well, National Treasury doesn't want to give funds, but at the end of the day, it's Parliament. And so I struggle often to understand why they must be so pleased. And when we as a portfolio committee say we don't support budget cuts, why it's still done when we are the ones that pass the budget. And we need to look into this, possibly as part of the legacy report, that should our pleas on the budgets not be heard, that we need to then follow the measures in terms of the legislation and appear before the Appropriations Committee, where we can argue on behalf of the entities that need additional funding. There is provision for that, and I think that is something we need to look at. Thank you, Chair, just from my side.
Thank you, Honorable Nivo Truchan.
Thank you, Chairperson. Greetings to everyone, and thank you to the NPA for their presentation. Just two small issues. Anyway, yeah, the good work from the NPA, as the slides showed today. I still have just two issues. The one is with regard to the grey listing, and the second one is the trafficking. In South Africa, it's becoming quite bad, and I think now we're the 7th highest country out of 193 countries, if I'm correct. We're 7th. So I just wanted to know from the NPA what work must still be done to get us off the grey list or the grey listing. And then with regards to trafficking, is there something that we can, in the security sector, in the security clusters, there's something that we're not understanding with regard to trafficking? Does the NPA have anything to say about that? And then there wasn't really a lot of information in the presentation about the TCC. I just got information about 3 deaf counsellors who received certificates from Lifeline, which was an intensive training on how to counsel with regards to GBV issues. So I'm hoping that the NPA, through the TTC centres, can also use them to assist people who are deaf facing GBV issues. So, for example, I was a little bit concerned about the Western Cape, where a woman was raped, and her case was almost thrown out of court because there was no sign language interpreter there. But I do believe that if she went through the assistance from the TTC, from the start, that the case would have been, continuing. But many deaf people don't go to TTC centers because there's no access, and they prefer to go to deaf organizations who don't necessarily have that intensive counseling training, which I believe the TCC does offer. So I'm hoping the TCC or the NPA can use them. They are from Gauteng, but in future we'll have others in the other provinces, deaf people with that kind of training to provide counseling to deaf people who come forward. So just two things that I wanted to say. Thank you, Chair.
Thank you, Honorable Masako Chale.
Thank you very much, Chairperson. And also, let me thank the NDPP and the team for the presentation, and also share the progress made and the work that has been done in relation to fighting crime. Chair, let me add my voice on the issue of budget cut. I would also request that they should not have be subjected to budget cut because of the work that they are doing and also supposed to make more progress when it comes to fighting crime, Chair. That takes me, Chairperson, to the perceptions that my colleagues have alluded to earlier. I also have some of the perceptions from the community or the citizens in relation to the Zondo Commission chair, where the citizens have a view that NPA is biased when it comes to who they should prosecute. Particularly, Chair, on the matters of the big businesses, which takes me to what they are saying about the big businesses. They're saying these big businesses, in fact, from the report, I could see that something is happening myself, but I can't not ask this question, Chair, on behalf of those who are having this perception that those companies, big companies that have stolen or were involved in the Zondo commissions, it seems as if some of them are still working with government, Chairperson. And also, Chair, the allegations that these businesses, Chair, some of them they paid fines. I'm not sure they will assist me on that one. They pay fines, and those fine, the fine that they, or the money that they recoup from them, it is not sufficient. It's not equal to what they have stolen, Chair. It's a little bit. It's a small amount when these businesses have a lot of money on their side. Lastly, Chair, because I don't want to get into more of those details, it is the issue of the Kara fund, the funds, Chair. Okay, because it's another issue of these amounts that we recoup, because I can see that the one that are being frozen, the percentage is higher vis-a-vis the money that has been recouped. There's a question here, Chair, that these monies, after we have received them or we've got them back, they are used, yes, in fighting crime, but now these funds have been stolen from the community projects, and those projects, some of them are not finished, and the community are subjected in those unfinished projects, and the problems, lots of problems in the communities when the money that it was duly supposed to have worked for them is now being used for other things. It is another comment that I would like maybe the NPA to assist on that one. I know that it is not for their decision, I know, Chairperson, but what is their view on that one? Thank you very much. I'll stop there, Chair.
Honorable Janji.
Thank you, Chair. I'm largely covered extensively by all the colleagues who have spoken. I just have a few very brief and specific or pointed issues, and maybe make some suggestions or requests in some of them. I think the first one, Chair, accepting the performance of the NPA for the period under review. It's a mixed bag in that we appreciate the progress made. At the same time, there's a wish that things can be done much better, faster, with more kind of assurity, kind of. For example, the first matter I want to raise is the TRC issues. Out of 135 cases, you have 10 being attended to, 10 outstanding. One is really not satisfied with the pace and the progress on the TRC matters. It would be good that perhaps, Chair, we find a space, because I wouldn't want to get a perhaps detailed response for that now. We find a space where we have an audience with the NPA specifically on that matter, so that there's proper breakdown of these issues. I'm interested in, I like the map they produce there in each region. One would want to follow that. And so if you talk about this 10, where in this region have you affected some of these and so on? And I'm sure they can also improve that map of theirs, because it has Eastern Cape as 13 cases, and then at the same time has Mthatha as 10. It's like the old demarcation of the Republic and Transkei. So I don't know whether they still work according to that, because Mthatha is in the Eastern Cape. But the issue really here is that the pace and the progress there, and it's a complex matter, one understand, but if today we're still dealing with issues of inquest, as the court would have pronounced yesterday, we would want in our time to attend to these matters and not have them being rolled over for another 10 years and so on. So I'm really not happy with the progress on the TRC. And I'm trying to suggest that we're going to need a much closer look and conversation so that we ourselves understand better where your difficulties are, why this snail's pace on this matter. You're able to share that with us, what are the blockages? Are these issues that are beyond your control and the control of everybody else? Or are there some factory faults that we can deal and really confront? So the presentation doesn't give that for now. And I think it can only do that when we zoom into it. So that's really my first point, Chair, that one wants to make. I think colleagues have spoken about the state capture progress. I share what the Advocate Batoy says in terms of the work that you have done. There's significant progress. I agree with you as well that if people were arguing for small fishes, then the matters that we have seen are not small fishes. There might be fewer than the progress, but maybe one of the things that you need to consider doing, because and I say this after listening to Advocate du Plessis, that maybe the society is not, it's deprived of the kind of level of communication about your progress. You might need to think very differently as to how on an ongoing basis. So you don't wait for an annual report or when the committee calls you, how we keep the country abreast and informed and traveling with you on these matters. You might have to think about that. And I know it's not in the terrain of prosecutors or yourselves, but you do have communication specialists that can assist in that regard. And the third point I want to raise, Chair, is which speaks to a certain extent to the Nolani matter, but because for NPA to re-earn the confidence and the trust of this country, it means that when you take a matter to the court, we must trust, we must have this confidence that yes, it's not 100% in your hand, but we must have the confidence and the trust that you are bringing there a very tight case that it must be 95% in favor of conviction. What we need to avoid is what I call lotto prosecutions, taking something to court with the hope of the toys of a corn. And I'm not saying that's what you do, but when you see the Nulani matter and then you read about the slowness of the Matsela Koko matter and so on, it can create an impression that the NPA doesn't seem to really know or show off what it is doing. So I think we must focus on that. And one welcomes this ethics and accountability set up that you did. I think it will go a long way, so that you're able to have that kind of complete protection and trust in terms of the work that you do, and that will also float to us as a society around that. The independence of the NPA as a project is supported, whether now or when there's a new on the 7th term. I'm interested that perhaps we need to have the timelines shared with us, maybe not in this meeting, from the ministry, so that as part of the legacy report, if we're not able to conclude that, we're able to say this is where this matter is. It's crucial that we deal with that. Issue of budget cuts, I think the chair has always been strong on that issue. Yes, I understand that you had an underperformance of 14 million. So in the environment of budget cuts, 14 million becomes a lot. And so as we speak with budget cuts, we must therefore motivate that with our own kind of performance. But I think you will find an ally in the committee from all of us around that. I completely agree, perhaps as a last point, with Advocate Batoyi, that the NPA must not be seen as a sole savior of the high crime rate in the country. That issue then speaks to the coordination of these institutions, as well as bringing society on board to really smash the culture and the narrative that crime pays. I think that will take us a long way. But the day we will rely on the NPA to deal with the crime rate, it would be a sad day. So there can't be any reliance on that one institution. It's a multiplicity of convergence of role players that must ensure that it doesn't happen, including the NPA for that matter. So thank you, Chair. Those are my few points I wanted to make.
Thank you very much. NDPP.
Thank you, Honorable Chair, honorable members. We will start off with Advocate de Kock, who will deal with some of the questions. Thank you. Advocate de Kock.
Thank you very much, NDPP and Chairperson. I wish to start just with the response to the question around the grey listing. I think in the presentation of the Department of Justice, Advocate Pillay did give some brief input. But on overall progress to address the deficiencies identified by the FATF, the country is making significant progress in terms of how we are doing that. So firstly, we are convened by the National Treasury as the key department responsible for dealing with the question of the grey listing. And there are regular engagements with all of the agencies across the board, both in the financial sector and in law enforcement, coordinated by National Treasury. To remind the committee that we, at the time of the mutual evaluation report of the FATF, they identified 67 action items in relation to South Africa's effectiveness in our anti-money laundering system that needed to be addressed. When we went to the plenary of the FATF in February of this year, flowing from the engagements with the plenary, South Africa had a remaining 22 action items to address. And these are not the same action items. It was after evaluation and analysis of the progress that we had made during that year post the evaluation. So currently, we have 22 action items across 11 effectiveness areas. And from our assessment with the FATF group, in the first phase, the first quarter, we are making good progress. We are satisfied we're making, although we still have a way to go in terms of addressing all the deficiencies. As far as the one raised in relation to investigation and prosecutions, there's a number of areas. It speaks to mutual legal assistance, applications that we've dealt with earlier. It also speaks to investigations and prosecutions of serious, complex money laundering cases. This is an area that we're working on very closely with other...
Sorry, Advocate Kok. I mean, you start by being very specific with regard to grey listing. 67 issues, 22 issues, but I think your last statement is very broad. What do you mean when you say good progress has been made? Because I think from the last time you would be able to say 22 issues outstanding. How far are we with those 22 issues?
So on the other 22 issues, 17 of those issues, we are showing good progress. This is still work in progress, and the FATF plenary is in October. The challenge we have with presenting too much detail under the guidance of the National Treasury, we cannot speak too much about that progress until we have engaged with the FATF plenary at the end of this month. So after the end of this month, we will get an outcome from the FATF. The FATF will then publish its progress report, and only after they published its progress report can we then speak to the specific detail of that progress. So that is the limitation, Chairperson. But as I indicate, out of those 22, we are satisfied that in relation to 17, we're making good progress. Not to say that that will be the end of the journey. And then on the others, we are also working quite hard on the remaining ones to ensure that there is progress. And that speaks largely to our investigations, prosecutions, and what we need to then do in relation to those. So we will be able to provide a Chairperson on receipt of the FATF outcomes. I think that we will then be able to provide a more detailed report on the actual progress, if that will be okay with the committee, and that will be at the end of October. In relation to the TRC, the issues raised regarding the TRC, just to indicate that a lot of work is being done in relation to the TRC matters. We currently have 38% of our cases, about a quarter of our cases, in the phase where decisions are going to be made in relation to those. So those decisions will relate to either a prosecution to institute or decline a prosecution, or to refer a matter for inquest, or to make a final decision that there isn't sufficient evidence to proceed with the matter. The collaboration that we have with the DPCI and the dedicated component within the MPA, we are doing good work in relation to those as well. Again, if the committee requires an update in relation to the individual matters, we'll be happy to provide a written response to the committee. But just to again indicate that this work is very challenging work. Many of these matters are very old, and the collation of the evidence is quite different to a case that we of a recent nature or of a recent incident. The colleagues are working very hard to ensure that there's progress. What is significant is that since the last report to this committee, and after direction of the NDPP, the MPA went to great lengths to engage with the families, as indicated also by the committee. And we have set up structured interventions with the family groups, and the prosecutors on individual matters are also keeping families up to date in terms of their respective matters. I think those are the two areas. NDPP, was there another? On the Bashiri matter, the Bashiri matter was on the court roll yesterday. We delegated the Director of Public Prosecutions of the Gauteng DPP office to attend that hearing. The matter has been postponed until the 11th of December of this year for the hearing of the application for extradition. Just to remind the committee that many of the previous postponements in the matter was as a result of various points taken by the defense. The case has also gone on appeal to the High Court of Malawi on a number of occasions, and the Malawi High Court has given directions in the matter. So we are working very closely with the Director of Public Prosecutions of Malawi, and as I've indicated, it's receiving the attention of the most senior law enforcement official in Pretoria, and that is the Director of Public Prosecutions. He's still in Malawi. I think he's only returning this evening. So on the DNA and on the question of the Tutuzela centers and on the question of the human trafficking, with your permission, I'm going to ask Advocate Bonikari Gamwell, the Special Director of the Soccer Unit, to please just answer those questions. Thank you.
Good afternoon, Chair, the members and the colleagues. I will start with the question that was raised around the TCCs by the Honourable Member Nivo Drigen around particularly the TCCs and Lifeline, the counsellors that have been trained on sign language. Just to first of all say that one of our key activities in respect of the TCCs is indeed to increase the accessibility to our services. And in doing so, one of our key areas has been ensuring that victims that are deaf are able to access the services at our TCCs. First steps have already been taken with our work with the Centre for Deaf Studies at WITS, where in collaboration with them, we've been able to develop a little short video which is played to a deaf victim at a TCC, which in sign language will explain the services, the entire process, as we wait for a sign language interpreter from DOJ to arrive. Next steps, we are in the process of developing a database of sign language interpreters with the Department of Justice to ensure that we have access to sign language interpreters across the country. In addition, long term, we intend doing some basic training in collaboration with the Centre at WITS to allow our staff to be upskilled in terms of sign language so that the basics can be at least the greeting and very, very basic sign language, just to make the victim comfortable as they enter the TCC. So we welcome any assistance from Lifeline. Lifeline is one of our stakeholders that operates at some of our TCCs. So we welcome that engagement with them to make sure that we are able to provide services to all victims. In respect of the trafficking, just to say that yes, we are currently a tier 2 country in terms of the country report, which is drafted every year. Much has been done to address the shortcomings that have been identified by the country report. That includes training. Currently, our prosecutors are very well trained across the country in terms of the prosecution of TIP. We will now continue with combined training with our SAPS colleagues. Already we've engaged with DPCI, who holds the mandate for the investigation of TIP, as well as with organized crime, because often they are the ones that are on the scene first. So in collaboration with both units within SAPS, we are hoping to address trafficking in persons as a collective. In fact, we will be holding a workshop in the next month with DPCI, with organized crime, and bringing together the Department of Justice and everybody that is involved in TIP management in this country, and really develop a collective strategy which will assist us going forward to improve our tier status. In respect of the DNA project, which commenced with the police late 2020, which to date has brought us close to 40 reports, is still in operation. From the NPA perspective, we can report that we are receiving fewer requests from our prosecutors for prioritization. We are also receiving very recent reports, 2023 analysis reports, which for us indicates that much has been done by SAPS to address the backlog of DNA. Thank you very much. I think I've dealt with all 3 aspects of the questions.
Bonnie, before you go, you said 40 reports. Did you mean 40,000 reports?
Sorry, my apologies, NDPP, 40,000.
Thank you. Honorable Chair, honorable members, I'm now going to hand over to Advocate Rabaji Rastaba.
Sorry, NDPP, before you proceed, there is this issue of sign language interpreters. I think the DG is here. How far is the department with that? DG Justice?
Yeah, he's online, but he's gone. He's not at his desk.
Mr. Sahela, can you alert the DG that we would like to get a written response on that? Let's proceed.
Thank you, Chair. Advocate Rabaji Rastaba.
Thank you, Chairperson and honorable members. I've broken the questions that were asked by Honorable Maseko Jelo into 4 parts. The first part was that these companies that we settle with in terms of alternative dispute resolution mechanisms don't pay the fine that is equal to what they have stolen. So the response to that question is that there are 2 parts to paying back the money. The first part is the restitution, disgorgement of forfeiture, which is the actual amount stolen. Then the second part of the amount is the penalty. So they do pay more than what they have stolen, as well as the penalty. Then there was a question around the freezing orders are higher than the recoveries. Indeed so, honorable member, in that during the period when the freezing order is in place, parties can apply for exclusion of interest. There are some innocent owner defenses. In Chapter 5 matters, there's living and legal expenses that we pay to the family of the accused person, and all this is ventilated in court. We don't make a decision that we pay back some money. So indeed, the money, when it finally goes into Kara, will be less than what was initially frozen, because the court will make certain interlocutory applications. Then there was an issue around the money is paid into CARA and of course paid back to law enforcement agencies when it was intended for the community or for government department. I did make an example of the two big matters that we seized and recovered pre-Zondo Commission, which was the 1 billion that we paid back to ESCOM, as well as a further billion that we paid back to the Department of Minerals and Energy. So we pay more to victims actually. So looking at our records, we've paid more than 6.3 billion back to victims. And then I think I've covered all the 4 questions in DPP, if I'm not mistaken. Thank you for the opportunity.
Hang on.
I think Honorable Jelle also made a comment, in fact, was requesting your comment on the perception that you favor big companies.
In terms of prosecution.
Yes, in terms of prosecution. Am I correct, Honorable Jelle?
Honorable Chair, we'll deal with that in a moment.
Okay.
And Advocate.
Yes,
Du
Chair,
Plessis,
you are
take a few.
correct.
Thank you very much, Chairperson and honourable members. I'm going to deal with some of the questions that came up, particularly around the budget. I think the first question was in relation to the Zondo lab and the forensic services in particular. Well, the budget that was allocated to the ID was used not only for hardware, but also used to hire capacity into the entity, which was done. There were specific colleagues that were brought in that are focusing on the digital and financial forensic aspects. Of course, we need to do more, but we are waiting for the bill to go through, so that money has been allocated there. We are still in discussions with the Department of Justice with regards to the final transition of the Zondo lab. There's been a residual mechanism that's been set up, as you know, within the department. So we'll be accessing that lab as well with the resources that we have brought. And so I think the DG's hands is up. He can also come in on this. In the question on Section 38 appointments, I asked if we'd appointed those. Yes, we've actually appointed 67 external counsel to help us with our most important cases. These are some of the leading counsel in the country, and we have also focused on representation, both in terms of getting from previously disadvantaged groups, but also making sure that we have briefed, or that a number of female counsel have been briefed in our matters. So that's 67 in total over the last 2 years. The question was raised on the donor funding framework, and yes, the NPA does have its own donor funding and in-kind funding framework in place. Again, very important to note that we don't ever receive cash funding from anyone other than the Treasury. So any support we get is in-kind support, and we have our own internal policy on that and our own internal guidelines. We are working with the CFO of Department of Justice, who are also putting together broader guidelines for the Department of Justice on in-kind contributions. So our policy framework speaks to that. And we're very aware of the perception issue around that, which is why all our engagement with external in-kind support happens through Business Against Crime, which has been a process we've used for many, many years, and is well established within government. And of course, you would have seen the recent developments through the presidential initiatives, where a third priority stream has been established called the Joint, I think it's the working title is the Joint Initiative to Combat on Crime and Corruption. And we're part of that process, although the initiative, as I understand it, is being at this point led by the SAPS and in coordination with the DG in the presidency. So that's where our work on this takes place. The question around the aspirant prosecutors, yes, that was indeed very unfortunate. It's not something which we would be engaging with donors on. Again, we do not accept any cash support from donors, or so to get any external partner to fund something like that would be extremely difficult in my view. But we are engaging with our colleagues in justice to see how quickly we can reinstate that aspirant prosecutors program, because as Honourable Member pointed out, this is a hugely significant part of the NPA's capacity and future-proofing of the organisation. The question I want to deal with, the one on OSD and the DDPP salary. That issue, as you'll recall, I think from our last briefing, has been resolved. There are one or two individual instances where colleagues are questioning the final amounts and back pay periods, but that process was finalized through a task team that we set up. Just to remind colleagues, it wasn't OSD in particular, it was a specific salary dispensation under provision of the NPA Act, because OSD is not something which is being considered at the moment within government. So we resolved it through the NPA Act, through a specific salary dispensation that the minister was engaged on. I want to come very briefly to the question of communications, Honourable Gianti. Thank you for raising that issue with us. Yes, we do need to communicate a lot. We need to take the public with us on this journey, but it's also a fine balance. And obviously, we can't be trying any cases in the media. We can't be creating unrealistic expectations about cases. So we do need to be we need to strike a fine balance between how much we communicate, what cases we communicate on, because we do not want to create the perception that we are either going after particular cases because of pressure or because we're wanting to get media profiles. So it is a fine balance, but I hear what you say, Honourable Member, and I think we will continue honing our communication strategy, not just at the high level, but also in terms of how we engage with community radio stations, communities themselves. And of course, linked to that is our community prosecution initiative, which we've spoken to this committee about before, where those community prosecutors are out there communicating constantly with the communities we serve. So it's not just about formal communication in the media and through our briefings to Parliament, but also our engagement with community prosecutions. I just want to also deal with the question from Honourable Gianti about the underspend. There wasn't an underperformance on our budget. It's a technical issue. It was basically had to do with capital expenditure, which was reclassified. I think the key point to make is we're actually overspending on our budget, not underspending. So that's, you'll see at the 101% of our budget expenditure. So that amount that's referred to in the slide had to do with basically a recategorization of a particular line item. But no, we certainly are not underspending, and we'll be taking any additional funding that we can from the fiscus. I'm just trying to see if there were any remaining issues that I've dealt with the OSD. And the last question that was raised, I think it was in terms of Professor Munting's presentation to the committee, and the question around our conviction rates. And I think also when we presented on our APP earlier this year, we said that we are thoroughly interrogating our performance indicators, not only in the context of the current reporting, but certainly in the context of our next MTSF period, because we agree conviction rates on their own are not necessarily a particularly good indicator of our impact or our success, but they're also not something we have complete control over, and in fact might create perverse incentives for prosecutors if that's the only thing driving our performance. So we are looking at a broader metrics of data, and certainly enrollment rate is a key one. But just an interesting fact or statistic, what we've seen recently, that the NPA's actual conviction rate in relation to enrolled matters might seem low if you look at the percentage rates, but compared, for example, to the United Kingdom, where their enrollment or their finalization rate of all matters enrolled by the police is actually around about 2%. We're actually pretty much on line with international standards in that regard. But certainly we need to be looking at the data we produce, and we are going to be doing that not only in terms of conviction rates versus enrollments, but also disaggregating our data to provincial and more local levels, because that's ultimately where communities need to have a better sense of our performance and how it's impacting on them. So I think I've dealt with all the issues. Thank you. And hand over to the NDP.
Thank you very much, Advocate du Plessis. Honourable Chair.
So I think before you conclude, let's allow the DJ. He raised his hand.
Sure.
Thanks, Chair. Thanks, Chair. When you looked for us on the sign language, I was just off the screen. I wanted to ask Mr. Isaacs to quickly just answer that question on the sign language. With your permission, Chair, Mr. Isaacs can proceed.
Thank you, DG. Thank you, Honorable Chairperson and honorable members. Yes, the sign language is now an official language in our country, and the courts are required to make provision. Currently, at the moment, we have included the sign language interpreters per province in our critical posts, keeping in mind cost containment, but obviously it is right at the top of the of our priority list in order to now start procuring or recruiting sign language interpreters per province. But in the meantime, we are using the private sector companies in per province. I know there are permanent sign languages on contract or permanent in Gauteng, and in most provinces, sign language interpreters are available for services in the courts. Many times the people in court, more especially the victims, if I may be allowed to say so, require the services of the sign language interpreters, and we experience the possibility of cases being withdrawn if we do not have such sign language, which was indicated by the Honourable that it should not happen. So that is top of our priority, and we would necessarily need to supply DG with a list of the database of sign language interpreters in the country, which I then hopefully expect from a memorandum point of view that DG then forwards the statistics per province to the chairperson of the committee. Thank you, Chairperson.
DG, Mr. Isaacs, how long will that process be?
What specific process, Chairperson? The supply of information or the recruitment process?
The recruitment process.
Chairperson, I think the recruitment process is the normal process. So that would be an advert, 30 days, or minimum 15 days, shortlisting, interview, payment. I mean, not payment, appointment. So minimum 3 months, maximum 4 months. That's the normal recruitment process. Otherwise, it would then necessarily be that we put our national committee together for these purposes, so that it's not done at the pace per province, but that it is done from a national priority point of view, and it can then be done within a period of 3 months, Chairperson.
Sorry, Mr. You are giving me the general broad answer for how the process is. And you have said it's a priority, and we agree that it is a priority. And if it's a priority, you should have by now be knowing, you should have had a project plan as to when are you going to advertise, and possibly by when this thing will be done. Not to explain to us how the process normally works, because we would not know even if you have already started recruiting. When did you start recruiting? When are you going to finish interviews? We want that kind of a detail, because the NPA would not have raised that thing if it was not a serious issue.
Thank you, Chairperson. Yes, Chairperson, I agree. Chair, in the meantime, as I indicated, we are using the services of casual interpreters countrywide. First of all, we are using companies that supply that service. But to answer you, Chairperson, I am sure that by no later than the 15th of January, we would have our casual interpreters appointed and operating in each province.
I put my head on the block, Chairperson. So that gives me then October, November, December, and the few days in January, if not sooner, Chairperson. But that would be the latest date, Chairperson. Thank you.
Thank you very much. No, thank you very much, DJ. NDPP.
Thank you, Honourable Chair, Honourable Members. I'll deal with the other questions that haven't been addressed. Firstly, the one relating to companies and the perception of bias. And I'm pleased that the word perception is used, because that is very, very far from the reality. In the ID itself, to give you some ideas of examples of some of the companies that have been charged and are already accused in matters: Albertine Pty Limited, Regiments Capital, McKinsey, Trillion Asset Management, Estina Pty Limited, Sahara Computers, Oak Bay Investments, Linkway Trading, Westdown Investments, and of course the Tonga Tulit as well in KZN. These are just some of the companies that have been charged, and to really assure this committee and the public that it is critical for us that companies be held to account for the damage that has been done to this country. And we are, in that context, I want to say that we are engaging, because of course, like you have the ABB settlement. So we're striking a balance between holding companies or individual directors responsible and also bringing back the money that this country desperately needs. And so in striking that balance, we're very careful, because we certainly don't want to create a perception that if you are a company, you are able to avoid accountability. But what we are doing is in fact, in the context of our alternate dispute resolution mechanism practice or guidelines, we are engaging with certain companies, and we will continue to do that, where we find that they're able to pay back the money that they've stolen from this country. Now, I know it was Honorable Jele who said that the impression is created that the amounts that they pay back is not equal to what they've actually stolen. We are actually engaging in various initiatives, including potentially with the NGOs, to actually get to a point where we're able to more accurately calculate the actual benefit that these companies have received, so that indeed, when there are any corporate alternate dispute resolution mechanisms, that agreements that we enter into, that the amounts are more in line with the actual profits or the actual amounts that may have been stolen. So this is an important balance to be struck, but to also say that in instances even where this is done, the issue of directors, the individual directors, this does not mean that we do not pursue the individual directors. And for example, in the ABB settlement issue, ABB then cooperated fully with the prosecuting authorities, or is cooperating to make sure that certain directors are held to account. So this is a complex environment, but we are certainly trying to manage it carefully so that we do hold companies to account. And our country needs the money. But as you say, Honorable Jele, we should try to make sure that they do pay what they should be. With regard to the New Lane and Gupta matters, it is indeed sad that the success or the work of the NPA is still being calibrated through the lenses of just two matters. I agree these were important and we do not dismiss them, and we are certainly, as the NPA, we take it very seriously. We are looking into what could have been done better, but that said, this matter, the New Lane matter, you're right, it is on petition to the Supreme Court of Appeal, but those papers would be public. So if details are wanted about what the NPA's position is, it can very easily be obtained from the court, from the Supreme Court of Appeal, and that will give all the details about what the NPA's position is regarding the New Lane matter. With regard to the Gupta extradition matter, this is something that, again, the South African authorities, that is the central authority in the being the Department of Justice as well as the NPA, have done, in our view, everything possible to be done. We earlier this year sent a note verbal to the UAE asking very, very specific questions, in particular about the reasons for the failure of the extradition process in the UAE courts. We have not yet received a response to those very specific questions. That said, publicly, there is a perception that the NPA or the Department, the South African authorities, have not done what they should be doing, they should have done. And so at the recent International Association of Prosecutors meeting, Advocate du Plessis, Deputy National Director, met with the Prosecutor General of Dubai, and they had engagements about how we can take this forward. The difficulty that we find ourselves in is to submit a new extradition request. We need to fully and properly understand what were the weaknesses in the original request. And in our view, we went there, we sat with the prosecutors, we were given the green light that we had done what we needed to do. And then we were surprised by the outcome. So unless we get that detail, it's very difficult for us to submit a new application because we want to address those gaps. So we are looking at still engaging with the General Prosecutor of the UAE, with the NPA on a prosecutor-to-prosecutor basis to properly understand this and get the answers that we need. And then we will be able to decide what the next steps will be. But this is by no means a closed chapter. We're still looking at what we can do in this regard. With regard to the TRC matters, certainly, Honorable Janchi, we would really, really appreciate it if the committee gives us sufficient time to address the committee on all the, I'd like to say, incredible work that's happening. If one still, thinks about the fact that nothing much was done in these cases for years, and it was wrong. And various law enforcement entities, whether it was the prosecuting authority and even politicians, must take some responsibility for what happened in the past and why these cases were not brought to court. We are under incredible pressure at the worst of times, frankly, when resources are the lowest, there's low budgets. There were times 10, 20 years ago when it was not the case. And when in fact things could have been done and families would have received justice and would not be complaining that people are dying, witnesses are dying, suspects are dying. And now we are 20, 30, 40 years later, trying to reconstruct evidence under very difficult circumstances. So, but that said, I would the work that has been done is quite remarkable in this. And we still have a long way to go. Inquests are being opened, but we're really trying to do the best we can under incredibly difficult circumstances. But as Advocate de Kock said, one of the really important issues is, and even after the last session, one of the sessions, which we were already doing, but we have heightened, is really engaging with the families and making sure that they are kept abreast of all of the developments. But there's still a lot of work to be done here, and with very, very scarce resources. But we are really trying to do our best together with the DPCI, who are the ones that investigate these matters. So we would really welcome a more detailed session in this regard. With regard to the issue of extradition, AFU, I think the CARA funding has come up, and I think, I'm not sure, one of the honorable members, I think, mentioned the fact that, trying to get some of these funding to go out more to the victims and to victims and complainants. To say that, just to add to what Advocate Rabaji has mentioned, that we ourselves understand the frustration of certain communities because money was stolen, money that was destined to improve the lives of communities. And so when asset recovery, we are able to recover funds, we are looking at how we can, in addition to the various complainants that Advocate Rabaji Rasataba mentioned, we could really try to support community level projects. So that's something we're looking at, and hopefully we will be able to make some progress in that regard. With regard to CARA funding, yes, the community has indicated, this committee has indicated that, and I think many members, that, the NPA should be looking at CARA funding to supplement its budget. You heard from the DG earlier on that the priority is with regard to illegal mining, I think the DG said. I stand to be corrected, but that was the indication. And certainly, we are certainly fighting as the NPA to get a larger slice of the CARA pie. So once the committee sits, and it's the DG makes recommendations, of course, it's a committee of the Ministers of Finance, Police, Justice, as well as the National Director that's on the committee itself. But the committee will ultimately decide on the allocations. But from the NPA side, we certainly hope that we will be able to get a bigger slice of the pie. And then, if I may, on the peace officer powers, to explain that a little bit more, I think it was Honorable Horn. Yes, so pending the, in view of the fact that ID investigations did not have basic peace officer powers, there is the provision in the Criminal Procedure Act that allows the minister to, in fact, confer the Minister of Justice powers on certain categories of persons after consultation with the Minister of Police. So because these powers are so important for the ID, we pursued this with the Minister of Justice. And as I indicated, in December last year, regulations were promulgated that would have allowed this process to move forward. But regrettably, after we sent, the process then means that the ID has to compile quite a detailed compendium, should I say, of all of the documents that's required for each individual investigator, so that the Minister of Police, not Minister of Police, the National Commissioner of Police then provides the certification for each individual investigator. And it was during this process that it was discovered that the regulations included a requirement of firearm competency certification for these ID investigations, which was not a requirement for our investigators, because they're not running after accused persons or suspects trying to arrest them. We're dealing more with commercial and corruption matters. So it was not a requirement, but somehow it got into the regulations. And so we've had engagements with the SAPs. The minister has agreed. Then the regulations were changed. There then had to be further consultations with the Minister of Police. So it was really a long, drawn-out process. Finally, now we have the regulations, and we're just waiting for them to be gazetted, and then hopefully they will be able to. But still, the process is we will need to submit these applications to the National Commissioner of Police to apply his mind and then to certify. So it's still a bit of work to be done. So hopefully we'll be able to get that done whilst we are awaiting the ID bill to move swiftly through Parliament. And then with regard to there was a comment about the fact that I think it was Honorable Horn as well, that wanting real numbers in terms of numbers of cases, to look at trends, etc. I'm given to understand that these figures are given in our annual report. And I think it's from page 31. But if there's any further questions, they can certainly be submitted to us, and we are happy to give further information in this regard. And then with regard to, I think it was also about easier cases being enrolled. Let me be quite candid. This was one of the issues that when I was appointed National Director that we had, was that the Specialized Commercial Crime Unit was indeed ticking numbers, and the complex cases were not being enrolled. We took a conscious decision that that was not going to be the case, and that all of these, in inverted commas, easier cases from the specialized unit must be migrated back to the regional courts, the ordinary regional courts, so that the specialized unit deals with the highly specialized and complex commercial crime and corruption matters. So that is a very decision that we took. And in fact, one of the consequences of that is that you'll find that numbers could actually drop in terms of numbers we finalize, because we are taking the more complex cases to court. So that's certainly not what we are doing. And we are consciously trying to change that in the SCCU. There was a comment about the perception that crime is out of control, and it was Honorable Swart, I think, and thank you for appreciating that it's not entirely in the hands of the NPA to deal with these issues. And I think it's really important. I accept this is the Justice Portfolio Committee and the NPA has to account to you, but we really want to make the point very clearly that apart from ID cases, the NPA does not investigate. And I want to make this clear to the media, to the public at large. The NPA does not investigate outside of the ID, which has a very specific mandate. That said, we work very closely with our partners in the DPCI to try to assist and support and work with them on prioritized matters. And there's a lot of really good working in terms with regard to collaboration. And the one thing I can say is that we are really proud of how far we've come with various stakeholders, the DPCI, the SIU, SARS, the Financial Intelligence Center, and as necessary with other partners that are required to really enhance collaboration. You would have heard from Advocate Rabaji Rasataba as well about the Enablers Project. And this also talks to private companies that we are really trying to hold accountable in this process, not just looking at your professional money launderers. And this talks to our FATF obligations as well, looking at your accountants, looking at your car dealerships, looking at lawyers, looking at banks, looking at all of these professional money launderers that we really need to hold to account. So there's a lot of work that's going into the Enablers Project, and that will feed into FATF, and hopefully we will be able to give some good news about progress that's made in that regard as well. And I think I've covered all the questions. I just want to wrap up by saying that, we should really not forget that in 2019, the national director was appointed. It was only 18 months later that the full leadership of the deputy national came into the NPA. So pretty much nothing changed for about 18 months, except a new national director trying to understand, visiting the various regions and just getting a sense of what was going on without the leadership at the top levels being in place. In fact, we still had old deputies in the office at the time. And this took us into 2020 when COVID hit us. And so it's really the beginning of 2021 that the NPA has really started its massive rebuilding efforts. And now we are in 2023. So say 2.5 years of intense work. So in as much as I agree that we are not where we want to be, I just want to repeat what I said at the beginning and what Advocate du Plessis also said. The narrative that the NPA is doing nothing is factually wrong and is in fact dangerous. I'm really proud of the work that the teams are doing, but putting a lot of pressure on them to do even better. So I hope that in the next year, we will be able to show that a lot more progress. And the ID bill is critical to this as well. So Honorable Chair, Honorable Members, I think we've covered all the questions. I thank you.
Thank you, Honorable Masego Jali. Is that a follow-up question?
Yes, Chair. I think she still has to answer one question. The NDPP just read the list of those companies, and then she said those are some of the companies that are involved in the Zondo Commission. But she did not also, in fact, I wanted to find out if there are, because she says are some. Can we get the list of all those companies, even if it's not today? They can finish us later. But the question that I think they did not answer, Chair. Is that one of how many of those companies that are still doing business with government? Chair, can I also take an opportunity also to make a follow-up on this issue of the TRC cases? We agreed at some point, Chair, that the NPA must come and give us a progress report. I don't remember if it was quarterly or what, but I remember it was like quarterly. I just wanted to find out, Chair, if ever maybe have we missed something, but it has been some time now not getting that progress report. Thank you, Chair.
Yes, but that cannot be directed to them. It's us. We will deal with that. I don't think they can answer that. It's something that we have to do. Honorable NTPP?
Chair, on the blacklisting issue, that's a matter for Treasury that has a list of the companies that they blacklist. So we will not be able to answer that question. On the TRC, we are in your hands, Chair, but we certainly would, if the committee would like a written report, we're happy to submit a written report, but also to do an oral presentation. Thank you, Chair.
Well, thank you very much. I think let me take this opportunity on behalf of the committee to thank the NDPP and the team for the work done. I think from the presentation, you can see that there is a lot of progress. Certainly, you are not where you are. And I think even to your own admission, you are not where you are supposed to be in terms of in terms of delivery. We think that a lot of progress has been made, but still there's a long way to go. And we would encourage you to do more as a crime-fighting institution. But taking from what you said and Honorable Janji said, it needs a whole of society's approach to fight this issue. It's not an issue that is just a police matter or a prosecutor matter or a judge's matter. We need a whole of society approach to deal with this particular issue. But certainly we are very pleased with the progress that we see. Hopefully the next committee would work with you to where you need to be in terms of the vision that we have set out, the aspirations of our people. It should be a collaborative effort. This committee has tried to work with you, but we think that the next committee should work with you to higher levels. There is an issue that Honorable Swart raised, and he has been raising it. It should really form part of our legacy report to say what really is Parliament's view to crippling budget cuts for the security cluster. Because certainly if we move from a premise that it is just NPA justice, we will miss the point. If you can fund NPA properly and not fund the police properly or the intelligence properly, NPA will not be able to achieve its objectives. So it's an issue that we really need a collaborative approach as all the portfolio committees. But I think we need really more than that. I think this should be our recommendation for the 7th Parliament. We really need more than that. We generally can't expect that when there is high levels of crime and underfunding, that miraculously you are going to have higher levels of investments or a growing economy? Where will you get that? Because the issue of high levels of crime, we are not only talking about contact crimes, we are also talking about commercial crimes. We are talking about illicit financial outflows. So I do think that the accounting or an accountant approach by National Treasury to say we are just going to cut everybody's head by 2%, it's unscientific. It's grossly unscientific. We should be leading a more entrepreneurial state. We should be saying, if our crime-fighting institutions, we give them 5 billion, especially your asset forfeiture, your SIU, we can be able to bring back to the state 40, 50 billion. Now, the whole approach of thinking that you are cutting budget, it's a more strategic thing. I think it just falls flat. It's really unstrategic. It's lazy thinking, in fact. The second one, Honorable Janji and Honorable Jele have correctly raised the issue that we need to have a last meeting with yourselves. It will cover the meeting that, on the state capture issues where you could not present. And then it will also cover the TRC issue. So it will be that meeting that will cover all those, in fact, the two issues, so that we can close the chapter for the 6th at Parliament with yourselves, and issues that would not have been completed would be part of the legacy report to the 7th Parliament. Even issues relating to your independence. It's one of the issues that should be part of the legacy report to 7th Parliament for it to be prioritized. Because what we have been saying as the committee is that we have done a lot of legislation, but we think that the 7th Parliament must start by focusing on legislation that deals with the architecture of our institutions. For instance, if you look at the Public Protector Act, which predates the 1996 Constitution, is generally out of sync with current realities. So we have to go back to that act, overhaul the act to take into consideration issues arising out of Section 194 committee, issues about the appointment, then the issue relating to the Nkandla judgment. So we must do with all of these institutions, what are the structural or architectural issues that we need to do with respect to the NPA, with respect to the SIU, all of those issues. Those issues should be part of what would need to be prioritized by the 7th Parliament. But we are really pleased with the report we have received. It shows that a lot of good work has happened. And I think you must really take it to heart. We do understand the balance that Mr. Du Plessis was talking about, and I think it's important. But it would be important that you speak much more about your work, especially focusing on civil forfeiture. I think it's very important that some of these monies that you get back, a lot of noise would be said about them, because for South Africans, especially facing high levels of poverty and unemployment, to know that there are people who stole billions and that has got a direct effect on how they are feeling or going about their everyday life. So if the state is able to achieve something in terms of bringing money back to state fiscals, which will help with creation of jobs and social security issues, that should be prioritized in terms of communications. We are not saying that you should be people who are looking after headlines. But at the same time, you should have a duty to communicate a good work because you are people's lawyers. So the people must know what you do and what you have achieved and not achieved on their behalf. Thank you very much, NDPP, and to your team and to members and everybody on the virtual platform and at home. The meeting is adjourned.
Thank you very much, Honorable Chair.
Thank you, Chair.
Thank you, Chair.
Recording stopped.